ಮೇಡಮ್ CRP ಇಲ್ಲ ಅಲ್ಲ ಮೇಡಮ್ ಎರಡನೇ ಮೂವ್ ಮಾಡ್ತಾ ಇರೋದು
ಪ್ರಿಲಿಮಿನರಿ ಹೆರಿಗೆ
ನಾವು ಫ್ರೆಶ್ ಅಲ್ಲ ಮೇಡಮ್
ಅವ್ರು ಬೈ ಮಿಸ್ಟೇಕ್ ತೋರಿಸಿದಾರೆ ಮತ್ತೆ ಹಂಗೆ ಸರ್ ಯಾವ ಇಯರ್ ಸರ್ 22 ಮೇಡಮ್
ಸರ್ ನಂದು CRP ಸರ್
ಸರ್ ಬಿ ಗ್ರೂಪ್ ಆದ್ರೆ ಪೋಸ್ಟಿಂಗ್ ಕಷ್ಟ ಅವಾರ್ಡ್ ಇದ್ರೆ ಅಷ್ಟೇ ಬಂದಿದ್ಯಾ ಮೆನ್ಷನ್ ಮಾಡಿ ಹೇಳಿ ನೋಡಿ ಅವ್ರ ಅದರ್ ಸೈಡ್ ಇದ್ರೆ
ಸರ್ CRP ಪೆಂಡಿಂಗ್ ಮಾಡ್ರು ಎರಡನೇ ಸತಿ ಮೂವ್ ಮಾಡ್ತಾರೆ
ಎಲ್ಲ ಕಳ್ಸಿರ್ತೀವಿ 50 ಮ್ಯಾಟರ್ ಅಷ್ಟೇ ಪೋಸ್ಟ್ ಆಗೋದು ಬಿ ಗ್ರೂಪಾ
ನೋಟಿಸ್ ಹಾಕಿದ್ದಾರೆ
ಬಿ ಗ್ರೂಪ್ ಕಷ್ಟ 23 ಇದಲ್ವಾ ಡೇಟೇ ಒಂದು 20 ಇರ್ತದೆ ಬಿ ಗ್ರೂಪ್ ಅದಕ್ಕೆ ಪೋಸ್ಟ್ ಆಗಲ್ಲ ಪೆಂಡಿಂಗ್ ಸ್ಕ್ರೂಟಿನಿ ಬಂದ್ಬಿಡಿ ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚಸ್ ಸ್ಕ್ರೂಟಿನಿ ಸರ್ ಆ ಕಡೆಯಿಂದ ಬಂದ್ಬಿಡಿ ಎಲ್ಲ ಕೇಬಲ್ ಇರುತ್ತಾ ಅಂದ್ರೆ 59 ಇತ್ತು ಸೊ ಆಗಿದೆ ಅದಕ್ಕೆ ಆಯ್ತು ಮೋಸ್ಟ್ಲಿ 50 ಇದ್ರೆ ಆಗಲ್ಲ ಅನ್ಸುತ್ತೆ ಅವ್ರಿಗೆ ಹೋದ್ರೆ ಅದ ಆಗುತ್ತೆ 7 ದಿನದಲ್ಲಿ ಆಗತ್ತೆ
Here is a submission, my lord, regarding being spoken to. With respect of the order passed by the sample court, while at the time of remanding, by setting aside the order passed by the deputy commissioner, in the order, instead of deputy commissioner, it has been stated that it is special deputy commissioner. After taking the matter on the file of the deputy commissioner, while at the fag end, they have raised some objections. The direction is issued to special deputy commissioner, not deputy.
Correct in chamber.
Much obliged.
ನಿಮ್ಮ opposite ಯಾರು?
ಇದು ಗಂಗಾಧರಪ್ಪ ಅವರು. I served copy on the marks.
My lord, in this case, respondent has seized petitioner property without giving any endorsement. I am moving memos.
ಯಾವತ್ತಿಗೆ?
Serial number 42, my lords.
Yes.
Sir, kindly adjourn the matter for
ಇದು ಯಾರಿಗೆ?
petitioner, my lords.
ಅವ್ರು ತಿಳಿಸ್ಬಿಡಿ ಬಸವರಾಜ್ ಅವ್ರು.
Yes.
For the petitioner, for Mandamus, is requesting to execute a sale deed because allotment was made in the year 1996, my lord.
Shri M. Ajay Kumar to take notice for respondents. Released on.
Hearing on of the petition, my lord. There are certain office objections that have been raised.
Court fee is not paid.
I have paid the court fee subsequently, my lord. My lord, there have been a few office objections which have been raised, which I will clear by tomorrow, my lord. In the meantime, notice may kindly be ordered, my lord.
What is the matter about?
My lord, there was an e-auction process, my lord, that was conducted by BDA, and I was a successful bidder in the fourth e-auction process, my lord.
Take notice. Respondents. All BD alva?
Yes, my lord. 1 to 3 is BDA, 4th is private respondent. I request for emergent notice with respect to private respondent, my lord.
R4 to R4. Office objection be complied with and maintain.
Grateful, my lord.
Division. B. S. Session to take notice for respondents. Released on. Office objection complied with and maintain.
The case of land is acquired for formation of a road. And thereafter I submitted a representation for a disbursement of compensation. The Tahsildar made communication to the horticulture officer for with respect to coconut trees which are axed in the said land.
A. To take notice for
Lord.
respondents.
In this effect, my lord, already an endorsement kept to be issued, informing that no land has been acquired for the purpose of farming.
ಇವರೇನೋ ಬೇರೆ ಕೇಳ್ತಿದ್ದಾರೆ ನೋಡಿ, prayer ನೋಡಿ.
My lord, page number 54, my lord. As per my representation communicated to the horticulture officer,
Compensation ಅಂತ. Where is for disbursement of compensation?
I will furnish the endorsements in the next date of it.
J. To take notice for respondents 1 to 8. Released on. Jilla Panchayat.
Jilla Panchayat now will list.
Why have you made 8 respondent a party?
my lord, acquired the land for public welfare department. I made a communication public welfare department, but they're saying that National Highway Authorities acquired the land.
The 8th respondent is a senior assistant horticulture director.
But the Tahsildar communicated to the my communication to the horticulture officer. But page number 55, my lord.
Notice ತಗೊಳ್ತೀರಾ?
I'll take notice, my lord. Anyhow, you have issued long back during the year, December.
Page 55, my lord. You given a communication that 42 coconut trees are axed.
All right, let it take notice.
Yes, ma'am.
Petitioner, my lord. The writ of Mandamus, my lord, for consideration of my representation for
The people
allotment
party
of
to take
alternate
notice
site.
For respondents. Released on.
please. The request for date.
If the petitioner, my lord, petitioner's lands are acquired by the Karnataka Industrial Areas Development Board and the compensation yet to be given to the petitioner herein. But in acquiring the lands in question, the provisions of the right to fair compensation and transparency.
Seeking time
No.
for filing the statement and private respondents are there, my lord. They have made a part.
Yes,
are
their lands
liable,
were
they are
also part of the preliminary notification. Subsequently, they have dropped their lands, though they are similarly placed to that of the petitioner. Petition,
Our notice under late agate. You want notice to go to them?
oh, Swami, because,
Are you seeking any prayer against them?
no, but my prayer is limited to quashing of the final notification.
Notice to R7 is deferred. Objections, if any, in 2 weeks' time, relist on. AJ to take notice for respond number 1. 1 and 5.
Sought for stay of the final.
Our should.
2023.
ಏನು ಮಾಡಿಲ್ಲ
13/3/2023.
we have issued a notification notice under section 28(6).
ಏನಕ್ಕೆ ಅಕ್ವೈರ್ ಮಾಡ್ತಿರೋದು?
ಅಲ್ಲ KDB ಇಂಡಸ್ಟ್ರಿಯಲ್ ಪರ್ಪಸ್ ಮೇಲೆ
ಅಲ್ಲ, ಏನ್ ಪರ್ಪಸ್?
ಇಂಡಸ್ಟ್ರಿ ಫಾರ್ಮೇಶನ್ ಆಫ್ ಇಂಡಸ್ಟ್ರೀಸ್.
Formation of industrial area, because
It's almost 1 year now.
ಹೌದು ಸ್ವಾಮಿ, because ಅವು ಏನು compensation so far ಏನು ಕೊಟ್ಟಿಲ್ಲ, but
We are ready to pay the
Compensation ಬೇಕಾ
If
ಇಲ್ಲ?
petitioner has claiming compensation, we are ready to
because
pay.
Want compensation?
Bound to
no
pay
step.
also. my lord.
also ಅವ್ರಿಗೆ ಇರೋದು ಒಂದೇ ಎಕರ್ ಲ್ಯಾಂಡ್. If it is dropped from acquisition, it is very
You
good.
have to make a choice. If you want compensation, then you can't ask for a stay. If you don't want acquisition, then I'll consider.
Also, my main prayer is quashing of the final notification itself.
For objection not clear.
That's
Relist.
Date, the date. Yeah, it may be have done 16th or 17th, my lord. 15th I am not in station. Please.
My lords, I appear for the petition in this matter. My lords, in this matter, my lords, was sought for e-notifying of the land with respect to 20 guntas of land, wherein the petitioner has entered into an agreement for
Will be
putting.
direction to denotify.
Yes,
They challenge the preliminary notification.
preliminary notification was there. My lords, we had entered into an agreement as in 2014 with regarding to putting up of a petrol bunk. All the permissions, everyone, all the sanctions have been done. Only with respect to entire extent is 4 acres, 22 guntas.
But how can you, they may draw, accept your objections. How can you challenge preliminary notification?
My lords, since my lords, 2014 itself, my lords, the agreement was entered into, and even the National Highways Authority has also considered that this thing with regarding to the petrol bunk. Sanctions have been done, and all the permissions have been granted.
Now, file objections, let them consider it. How can I entertain a petition against preliminary notification?
My lords, with respect to 20 gundas, we have sought. Even the one,
Or 20 acres, the principle remains the same, isn't it?
yes, my lords, we had requested only for 20 guntas because by the time they have taken the permissions only, it was almost 6-7 years. All the panchayats, HPCL, everything, all the permissions have been granted. A notice be issued, my lords, if it's possible, let it be considered. Let a notice be issued if we can.
To take notice for respondents. First respondent. Who is the third respondent?
My lords, third respondent is the owner.
Is he?
Owner.
There you are?
He's the owner of the entire extent of the property.
You're claiming as a lessee.
Yes, ma'am, as an agreement holder.
How can a lessee challenge the acquisition?
My lords, since it is prior, after notification, my
But
lords,
still,
I don't have
understand
any.
both of you being petitioners. How can you as a lessee?
Because my only contention was that since the agreement has been held prior
I
to
understand,
almost
but-
6 years.
If the owner does not challenge it, how can you come and challenge it?
He has filed an objections and he has given a
I'll make him a petitioner, withdraw this petition, both of you file it together. Suppose he wants acquisition. How can you say don't acquire?
Yes, my lords, I may be permitted to do so.
And consider the petitioner seeks permission to withdraw the recognition and seeks to file a fresh petition if the need so arises. Permission sought for is granted, petition is dismissed as withdrawn.
With the liberty to file a fresh petition.
Lordship, last Monday, there were two other matters that were listed. This had to be connected with those two matters, but however, they've been listed today. The date is. ಈಗ ಲಿಸ್ಟ್ ಆಗಿದೆ ಬಟ್ ಲಾಸ್ಟ್ ವೀಕ್ ಲಿಸ್ಟ್ ಆಗಿದ್ರ ಜೊತೆ ಕನೆಕ್ಟ್ ಆಗ್ಬೇಕಿತ್ತು. It's been wrongly listed today. I've given a list of the 4 petitions that had to be connected together.
Post along with.
Vinayak S. Pandit has been asked to take notice for BDA and government advocate was asked to take
notice
for
for
respondent number 2. The next date is given as 15th for the other 2 writ petitions.
For the first respondent, AG to take notice for the second respondent. We list along with.
For the petition matters.
Yeah, sought for a direction to allot alternate land. Last 2 occasions, they are sought for some time.
Information, we need to get information.
Yes, sir.
We'll seek information from the board, my lord, to which time may be granted.
It taken time because there is a circular for allotment of alternate land. I am seeking only for allotment of alternate land as per the circular minutes.
We'll seek information and we'll file.
ಎಷ್ಟು ದಿನ ಬೇಕು ಹೇಳಿ?
1 week, 1 week.
Relist on.
Lordship may have this matter on 15th month. Much of it.
Respondent in this matter, my lords. Lords,
The last second is lordship.
interpreting instructions, my lords, a week's accommodation.
My lord, the interim orders after granted the interim order, though they are digging the sites, my lord.
ಏನೇ ಮಾಡ್ತೀರಾ ಏನಾರು?
My lord, as per his instructions, my lords, because I'm unable to reach any officer, my lords, because of the election duties. Sorry, my lords.
She wants you to take notice for respondents till the next date of hearing, status quo as it. Last time I ಕೊಟ್ಟಿದ್ದಾನ.
ಕೊಟ್ಟಿದ್ದೀವಿ, ಅದು ಅಪ್ಲೋಡ್ ಆಗಿಲ್ಲ ಇದರಲ್ಲಿ, ಬಟ್ we cannot communicate to the department also, which is not the upload in the website notes. That is the reason we could not intimate to the BD also.
I have granted an interim order. What more?
Yes, madam, the lordship is granted, but which is not in the uploaded in the website. I could not get the interim order also.
Interim order granted earlier.
Kindly issue by hand, my lord.
ಇದೆ, it's already signed last week itself. In upload ಆಗಿದೆ.
That's okay.
Who's R19?
My lords, R19 is R1's brother, my lords. He has not been given notices, my lords. Now I am appearing for R1, my lords. I seek to vacate the interim order dated 5/2/2021 because I was not made a party in the OS nor the FDP nor the RSA, my lords. I was not made a party in either of the suits.
What is this order revision against?
My lords, the revision is against the order of the court stating that rejection of plaint, my lords. They had sought for rejection of plaint stating a sale
Who's
of-
R3, R4 and R13?
Well, it's
My lord,
R3, R4 and R13 are not my family members, my lords. My lords, with the vacating, in the statement of objections, my lords, I have filed a family tree of mine, my lords.
You appear for the petitioner?
I am appearing for petitioner, my lord.
Yes, you sought for vacating the interim order.
My lord, here, the respondent number 3, 4 and 17 are died during the, respondent number 3 died before filing the suit, my lord. But they have made the party in the suit. And 4 and 13 already died during the pendency of the suit. Now, regarding 13, legal heirs of 13 are already on record, 14 to 17. But in the last occasion, the respondent number 17 also died.
Now,
So
for
I
the
have to
purpose
take
of,
step.
for the purpose of this revision, only the first respondent is contesting part, isn't it?
Yes, my lords.
Yes, my lord.
Why do you want the plaint to be rejected?
That is earlier OS 169 of 1997 has filed by the respondents and the same has been decreed. And moreover, the FDP also completed.
What
And
is the
thereafter
suit
they
for?
suit for
The suit-
partition.
He is seeking for cancellation of judgment and decree in OS 169/97.
97.
Because we were not made a party in the OS. Also in the earlier OS, my lords, in the OS 169 of 1997, in the FDP that preceded the OS, and also in the RSA that one of my brothers came before the court, I was not made a party, my lords. Because in these matters, my lords, the ladies of the family were not made a party. Now, as per Vinita Sharma and Rakesh Sharma case, I have co-personary right over the property, my lords, and hence I am seeking for a Namana party ne madila. In his cross-examination, my lords, he agrees that he has not made us a party, which is filed with the objections of mine, my lords, on 25th March 2024.
My lord, one submission, my lord. Even if the partition is decreed, they have a right to seek a partition in respect of their share in their co-personary.
We contend that we are the co-personers, we are the real co-personers of the property, my lords, as per the.
Now, what is the
Family-
ground to reject the plaint?
There is no ground.
There are earlier two suits are pending in respect
Were
of
they
the
parties
partition.
were they parties in the earlier two suits?
Yes, they are all parties except these respondent number one, my lord.
Respond number one ತಾನೆ court ಬಂದಿರೋದು.
ಹೌದು.
If they are not parties, how can you bind them to that decree?
No, the partition is affected among the all co-personers except
That was
these.
a matter for trial. How can you reject the plaint?
No, my lord. Already FDP is completed. In the FDP, the share of the
No, that is
this
your
co-personer.
that is your defense.
Your family ಏನ್ ಅಲಾಟ್ ಆಗ್ಬೇಕಂತ ಆಲ್ರೆಡಿ ಅಲಾಟೆಡ್. ಆ ಅಲಾಟೆಡ್ ಪ್ರಾಪರ್ಟಿಲಿ ಇವ್ರಿಗೆ ಏನ್ ಬೇಕೋ ಆ ಶೇರ್ ತಗೋಬಹುದು.
ಅಲ್ಲ ನೀವು ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿರೋ ಡಿಗ್ರಿ ತಗೊಂಡ್ರೆ how can they be bound by the decree? Suppose
No,
they're
my lord.
entitled for a larger share.
No, my lord, I will produce one document in respect of the partition in.
Show me from the plaint as to why the plaint should be rejected, not from your defense.
So 2 days time may be granted. I will be appearing physically due to my shoulder pain. I am not unable to appear before physically. Only 2 days required, ma'am.
Obliged.
Third,
Yes, sir.
Kindly pass over, my lord. Senior, I
For the
engage in
case
senior.
number one, press time to file objection, they filed application for stay the proceedings of.
My lord, RA is every day is I'm seeking a stay of the RA, my lord. The RA is posted today. So matter has referred to mediation center. Mediation center is not settled out of.
what is the matter about?
So my lord, suit matter of order 41 rule 21 restore the RA, my lord. After nearly 808 days, the judgment has been decreed the RA. Against the judgment and decree, they filed a miscellaneous petition to restore the RA. The same came to be allowed.
This is allowed.
Miscellaneous is allowed after 808 days
On
delays.
what ground?
My lord, the service has not been, notice has been not served.
Then
No, my lord, the real, that contesting respondent has not appeared. Because only PA holder.
ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿದ್ರೆ ತಾನೇ ನೀವು.
ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿದ್ವಿ, ಅವ್ರ ಪಾರ್ಟಿ ಅಪಿಯರ್ ಆಗಿಲ್ಲ, PA holder ಅಪಿಯರ್ ಆಗಿದೆ, ಜನರಲ್ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ.
You are which defendant?
There's a
Minutes before I would be appearing for the respondent number 4 and 5 here, minutes, and my friend is appearing for.
So respondent 4 and 5, they're supporting
He was the
P,
contesting respondent,
contesting respondent.
lower court.
RA judgment is page 53 na? Page 53?
Yes, minutes. The initial judgment.
Yes, my lord.
Yes. Initial judgment is at 53. Then, my lord,
You are which respondent in that?
Respond number 1 or 2 in this map.
Respondent 2, my lord, in the RA.
Ashok Nair.
Ashok Naik.
You are placed expert.
Yes, ma'am.
In
No
the
notice
OS,
has been-
in OS also, they placed the expert.
No
In
notice. issued
original
by the-
suit also, he was placed the expert.
They filed miscellaneous to set aside the expert order, is it?
The expert order.
Where is it served in the RA?
Yes, my lord.
No,
Where is,
no.
where is the finding?
Let's
they were
running
served.
page 32 for a moment.
That order sheet is, order sheet I produced, my lord.
Let's,
Additional documents.
ಇಲ್ಲ ಈ ಮಿಸ್ಲೆನಿಯಸ್ ಪಿಟಿಷನ್ ಅಲೋ ಮಾಡೋದಕ್ಕೆ
Yes, my
ವಾಟ್ ಇಸ್ ದ ಫೈಂಡಿಂಗ್ ಅವ್ರು ಸರ್ವ್ ಆಗಿದ್ರೆ ಇಲ್ವೋ
32 minutes.
The
Service
service
ಆಗಿಲ್ಲ.
service
It
agreement.
was transmitted from.
The service held sufficient to respondent 1 to 5. It is in the order
ವಾಟ್
sheet.
ಇಸ್ ದಿ ವಾಟ್ ಇಸ್ ದ ಕೋರ್ಟ್ಸ್ ಇನ್ ದ ಮಿಸ್ಲೆನಿಯಸ್ ಪಿಟಿಷನ್
Miscellaneous petition,
ಅಲ್ಲಿ ಏನಂತ ಹೇಳ್ತಾರೆ
kindly pass for my
No
law. I
notice,
engage
sir.
senior lawyer.
No
senior
notice
counsel.
issued by
Can
the
I-
court.
Can I assist minutes running page
No, no,
32 the
senior.
finding?
you want the senior to come pass out.
My lord, I am for the item number 13.
I think for a short adjournment.
I'm appearing for the petitioner, my lord,
received the-
counsel appearing on VC, my lord.
Yeah, my lord, I am for item number 13.
I have just received the copy of the CRP only in the morning today.
This is that specified value, isn't it?
Yes,
Yes, your lordship. Yes, lordship.
What is the specified value that you have mentioned?
No, we have said that this is, our contention is it is maintainable before the civil court. On the ground, because we'll argue the matter next week sometime, actually, give me a short date. I'll just go through the petition.
List.
My lord, I have a small submission on 8th of April. The trial court is about to hear the petition. So if a interim order of stay, maybe for the next date only, will help, my lord.
No, your lordship will kindly see the quota number 10, it means the matter is pending, is vacant as of today. So there's nothing that is going to happen in that matter. So,
Relist.
For the petitioner, Lord, I am file a application under order 3 rule 2 before the land trial court for changing of authorized person for leading of evidence, but the land trial court is rejected our application. ನಮ್ಮ authorized person change ಆಗಿದ್ದಾರೆ some company ಇದು. ಅದಕ್ಕೆ ಬೇರೆಯವ್ರನ್ನ ನಾವು authorized person ಅಂತ application ಹಾಕಿದ್ರೆ rejected.
ಕಂಪ್ಲೀಟ್ ಇದೆಯಾ ಪೇಜ್ ನಂಬರ್ ತಪ್ಪಿದ್ದಂಗಿದೆ
ಇಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆ.
ಪೇಜ್ ನಂಬರ್ 10 ಆದ್ಮೇಲೆ ಪೇಜ್ ನಂಬರ್ 11 ಅಲ್ಲಿ comply with the opposite objections that order copy is not produced in full.
ಆಮೇಲೆ page number 10.
10 the last line with all contentions.
Next coming to the page number 14. 14 is continued.
Next page ಅನ್ನ ಬೇರೆ ಇದೆ.
ಇಲ್ಲ ಅದು ಆರ್ಡರ್ ಕಾಪಿ ಹಿಂದ್ಗಡೆ ಆಗಿರ್ತಕ್ಕಂಥದ್ದನ್ನ ಅದನ್ನ ಟೈಪ್ಡ್ ಕಾಪಿ ಹಾಕಿದೀವಿ ಅದಕ್ಕೆ ಮೇಲೆ. Page number 14 is continuation. Page number 10 continues to page number 14.
Who appears for the respondent? Who appears for the respondents in the trial court?
Milord,
Who appears for the respondent in the trial court?
trial court is one.
Counsel to take out notice on the counsel to represent the respondent in the trial court. Relist on, you are the land. Please intimate the lawyer that
Yes,
taken
I'll
up this week.
But in between, today is the case is posted for
Or tell them notice is ordered and take time.
much of it. Much of it. Fifth ಬೇಡ ಸುಮ್ಮನೆ 7th, 5th ಬೇಡ. 5th date ಕೊಟ್ಟಿದ್ರೆ 5th ಬೇಡ. Much of it.
That's for the petitioner in this matter.
What happened?
That's I went through this judgment. That's it's not applicable to the facts of the case which is here, my lords, or the position of law which I'm contesting. And I say that for two reasons, my lords. Number one, what was questioned here was that, my lords, that whether it was an interim order at the outset. Second, whether the court in Ballari district could have revived the suit at all. Now, my lords, that would fall squarely within the scope of the jurisdiction qua the court. Now, my lords, to answer that, my lords, I may take my lords to that paragraph. If the judgment is with my lords. But I can pass the judgment. It has my marking. That's the point which I'm trying to convince my court, this court is that, Millets, is that all the orders, Millets, admittedly, Millets, would fall under interlocutory order, except this order, which would call for deciding the rights of the parties. Now, Millets, I ask myself a second question. Can the court under 226 dismiss or quash the suit which has been pending before the court? The answer to it, Millets, to that, my lords, respectfully is no. Supervisory jurisdiction, my lords, in fact, 1986 judgment, which has been referred in this judgment also, would deal with the issue whether the courts before the, that's the court below the high court, my lords, the trial courts, can the high courts control and the conduct of the trial courts if they're going in the right manner in the pending suit? That is, my lords, to put it otherwise, can the would the High Court would be in a position to monitor if the suit would continue in the right manner? Now, my lords, that is not the scope of 115. Now, my lords, on that very principle, in fact, my lords, the judgment, paragraph 19, my lords, which I have pointed out to my lords. It starts from page 24. The issue of commercial court was alone discussed, my lords. It is the law, my lords. What was discussed was the nothing but a copy paste of the act, saying that, my lords, under section 10(3), certain things can be done. That is, CPC prevails over this particular enactment, number one. Under section 8, you cannot entertain an appeal or a revision against an interlocutory order, number 2. Number 3, would an appeal come under section 13? These are the only 3 things which is being discussed. That's my difficulty, my lords, which I'm expressing before this court, is that until and unless, my lords, this court holds that an application rejecting Order 7, Rule 11 is an interlocutory order, my lords, section 8 is not a bar for me, especially in the view of section 10 subclause 3. In this particular case, my lords, number 1, given the checkered, in fact, the word used is also checkered facts. An arbitration was concluded before the Bangalore Arbitration Center. As against that, an AS was filed, that is arbitration suit under section 34 was filed at Ballari, my lords. Execution was filed before Anantpur. Now, my lords, after that, an application with regard to can a court, that is the district court in Ballari, entertain a arbitration which has been concluded here in Bangalore. My lords, that again was returned to Bangalore. Now, my lords, at that point of time, they went to Supreme Court. They said, no, Ballari court can entertain this particular suit. Again, from Bangalore, it went back to that district. There, what happened is that, my lords, instead of filing a new suit, because here it was a return of plaint under Order 7, Rule 10, they filed an application to revive the entire suit there. That was called in question, saying that can a trial court look into that? This, my lords, I can equate it to any leave which is being granted to the defendant or respondent, my lords, depending on which jurisdiction of state they're contesting, in a summary suit under Order 37. That would alone would not decide the rights of the parties. Order 37, my lords, when a leave is granted to contest the suit by reading evidence and so on and so forth, that alone would not decide the right of the parties because it's still open. But here, my lords, if my lords hold that the CRP is maintainable, number one, number two, CRP should be allowed, the suit would go for its entirety. That, my lords,
Because
respectfully.
the Commercial Courts Act does not permit such a dismissal or rejection of a plaint, then what is your argument? By virtue of section 8, if you file a suit
Yes, my
which
lords.
goes to the Commercial Courts Act,
Yes, my lords.
the concept of rejecting the plaint would never be there.
My lords, that is not even.
Law does not expect the Commercial Court to reject the plaint.
My lords, that is not what, my lords, even the act when you read it, my lords.
Even if it's accepted that the Commercial Court rejects the plaint, you have no remedy under 115.
No, I don't have the remedy under 115 because that would culminate into a decree. No, my lords, that is exactly.
Remedy under 115 by virtue of section 8. Then where do you stand?
That's by virtue of section 8, my lords, I'm convinced, I'm trying to convince this court to say that only if it's an interlocutory order, dehaus the allowing or not allowing of the order. For example, my lords, an application
You're
say.
also, you're not concentrating other two words, or that's other challenge.
But my lords, that's section 8, my lords. The first word is interlocutory. And then, my lords, all other words, even if the words have to be read by grouping, my lords, all those words have to be read with interlocutory application or interlocutory order itself.
No word is superfluous there. Every word has a meaning. The second portion of section 8 is again an independent provision. The third is another is an independent situation.
Let's make
How
this
can
clear.
you read?
No civil revision application or petition shall be entertained against any interlocutory order of the commercial court, including an order of issue of jurisdiction and any such challenge. My lords, that again would go back to the question, my lords, which I ask myself, can a order passed rejecting order 7 rule 11 can be treated as an interlocutory order? Or my lords, even if it's an
Suppose it
order,
is treated as an order.
it's an order.
Relating to a challenge to the jurisdiction.
Then, my lords, then the next question which I ask myself is that, my lords, under 226, can the court excise the jurisdiction to allow an application under 711, thereby the consequence of it? That, my lords, what I would say, depending on the judgments I have quoted, my lords, and what my lords would hold.
Sir,
Yes, my lords.
reserved.
That's in the event, my lords, in the event this order is negative, my lords,
I'll say liberty for you to approach the appropriate forum.
please,
You
my lords.
decide.
Grateful.
Petitioner. Let respondent 5 has entered appearance for the first time.
Waiting for the respondent number.
But page 27 may kindly be seen, but your lordship heard this matter extensively. There is also a subsequent development. But your lordship's order starts at page number 23.
Yes.
But your lordship's order is at page 23, my lord. But this writ petition was filed to enforce the order. Your lordships get at page number 105.
Lords, one submission, my lords. Before my senior counsel continues with the merits. Your lordship on 23/11/23 had passed an interim order of status quo as on today with respect to revenue entries. Based on that order, my lords, the present petitioner, review petitioner, he got changed the kata in his name itself. This
The
is the
appeal
actual
filed,
instruction of the
the
maintained.
appeal filed
And
before the deputy commissioner is allowed. And on that,
It is allowed, my lords. My humble submission
Not-
is that as on this honorable court of order of status quo regarding the revenue entry, irrespective of the deputy commissioner allowance, allowing of the appeal.
not changed.
But revenue entries with respect to the property in question, it got changed. That is what my instructions are by my party.
They're not,
File a contempt then.
no, it's not changed.
Maybe I filed the memo along with those records before this
No,
honorable
if
court.
there is a violation of this interim order, you know what to do.
No,
Yes,
it's
my
not
lord.
changed. It is not changed. But what happened?
My instructions are
Simultaneously, I have filed an appeal.
with that, my lords, and further submissions, my senior needs to attend the proceedings as he is on abroad.
It is not changed.
I am having difficulty to proceed with the matters. May I request your lordship to take after vacation if possible, my lords, because
Lord, may one submission.
as on your lordship, already your lordship direction of interim order or status quo, it is there. If it is the revenue, it is also not changed as per my senior counsel's instruction. They will not be harmed with respect
But
to
it
the
is
interim
not-
order of this honorable.
But he is only compounding the, my lord,
What's your rank in the writ petition?
I am the
Fine,
petitioner
fine.
in the writ petition.
petitioner. Remember, respondent one, my lord, the entire, my lord, gamut is against respondent five. Respondent one is the mastermind behind this. That's why, my lord, I draw your lordship's attention to page number 105, my lord.
You are not a party there, no, in the writ petition?
He was a party.
You are not a party.
What happened, my lord? They made me a party. They gave a wrong address even before the notice could come back.
The third respondent.
Yes, no, third and fourth respondent, even before the notice could come back, saying that no such person exists in the address, Mr. Mahesh, my lord, was misled to file wakalat on behalf of the respondent 3 and 4, and he was misled to make a submission that he has no objection for change of kata. That is the entire responsibility falls on Mr. Nataraj Ballal's client, Mr. Respondent number 5. He is the
I have
person
been
who approached
implemented.
Mr. Mahesh.
The RP I have been impleted, I have filed wakalat, my lord, I will file my objections. Because now if that is the allegation against me directly, because in the RP originally I was not a party. After the allegation of fraud, my name is inserted as I pleaded. I'll file my objections, my lord, sometime maybe.
But in the-
This matter,
in
I
the
want
mean-
to submit one thing. As a general power of attorney, I filed wakalat this case. Now the present petitioner filed a complaint before the bar council
But that we will withdraw because
against me.
we'll withdraw that because we were under the impression, no, he made it clear that it was,
Record your statement, you'll withdraw.
yes, certainly. Will certainly.
Senior counsel, Shreyas Basaraj submits that the complaint that has been lodged against Sri A.S. Mahesh before the bar council shall be withdrawn. The statement is taken on record. Not counsel for the fifth respondent seeks for time to file his objections.
But there is one development in the meanwhile. Simultaneously, I had preferred an appeal before the deputy commissioner. Deputy commissioner allowed my appeal and there is a direction to change the kata and restore my, therefore my rights are safeguarded. Now, therefore, I am not pressing for continuation of the status quo order.
Let the status quo. Status quo order granted earlier shall continue for the next date of hearing.
Because of this, what's your power of attorney?
It's okay, it's okay.
Yeah, for AD. Who's R3?
Number 1 and 2, my lord, to consider my representation, my lord, for releasing of compensation, my lord.
Is he a rival claimant?
My lord, he was a purchaser, my lord. What has happened? The land was granted to me, my lord, in the year 19. ಇಲ್ಲ I saw, my prayer is only to consider my representation as per annexure.
In his absence, how can you, if he's got a claim?
My lord, in fact, my lord, the amount has been already released in his favor, my lord. Now, my lord.
What is the point in
My
considering?
lord, what has happened, my lord? I have filed an appeal before the assistant commissioner. Assistant, kindly see, my lord, page number, annexure T, page number 89, my
If the
lord.
compensation amount is already released,
Yes, my lord.
then your prayer for considering the prayer would not survive.
My lord, they have to pay me and later on they have to recover. Kindly see, my lord, the order, my lord, page 89, only one submission, my lord, page 89. Page 89, last portion of the order, my lord.
89.
Yes, my lord.
Annexure?
Annexure, my lord, annexure T.
Annexure?
Annexure T, my lord, page 80, 80. Operative portion is annexure T, my lord, page 80. Before my representation.
136 side.
No, my lord, it is an appeal under protection of prohibition of transfer of certain lands, SC Act, my lord. The last portion of the order, my lord, there is an order for me to take action, my lord, for payment of compensation, my lord. Now, my lord, I have submitted the representation. Let them consider and, my lord, let them pass an order, my lord, based on this representation in the light of this order.
ಅವ್ರನ್ನ party ಮಾಡಾದ್ಮೇಲೆ then you have to take the consequences.
My lord, I'll,
ಬೇಡ ಬಿಡಿ ಅದು. Post after service of notice.
next week it may be.
R3 serve ಮಾಡಿ.
Please, man.
Post
Date
after
may be
service of
given.
notice to R3.
My lord, short date may be given, my lord.
If you furnish process fee, then it will be sent.
Yes, my lord, we'll do it today itself.
A week's time is granted to the needful. Post after service of notice to R3.
Office kindly directed to furnish. I'll give the copy.
ಯಾರು R3 ಯಾರು?
Lady.
Who's R3?
R3 is the
Rival claims ಇದೆಯಾ? Rival claim?
Private claimant.
Untalama ಅಂತ.
Compensation release. It's already released to someone, my lords. It is that person who has already claimed compensation and received it. Now there is a contesting claim as against him by the present petition.
Post after service of notice to. A week's time is granted. Post after service.
ಯಾವಾಗ ಫೈಲ್
My lord, on the last date of hearing, specific instructions were given to the KADB advocate that land bearing survey number 16/P48. File an affidavit that it has not been acquired with a sketch. That was a specific direction given to the KADB.
My lords, may please have my statement of objection. There we have filed a sketch already. My lords
Section
will
was
find.
given to file an affidavit and also the sketch that was annexed to the notifications 28(1) and 4. Not the sketch that you have produced. Whatever was the sketch that was a part of the notifications under 28(1) and 4 was to be produced along with an affidavit.
A short accommodation may kindly be given. My lords, I was under no impression with the deepest of the respect, my lord, the deepest of the apologies, I would state, my lords, that the sketch is already there. There is a dispute as regards the identification of the
I want
property.
the notification, the sketch annexed to the 28(1), 28(4) notification, not the subsequent sketch.
My lords, there is no sketch attached with 28(1) and 28(4).
Kindly see the
However, a JMC is drawn at
see the notification. It does say a sketch is available for inspection, doesn't it say that? How can you say that there are no sketch?
ಈ ಅಧಿಸೂಚನೆ
(28) notification page,
my statement of objection, page number 7.
Where's the 28(1) notification?
Page number 7 of my statement of objection. ಈ ಕೆಳಗಂತೆ ಅನುಸೂಚಿಯಲ್ಲಿ ನಮೂದಿಸಿರುವ ಜಮೀನುಗಳು ಕರ್ನಾಟಕ ಕೈಗಾರಿಕಾ ಪ್ರದೇಶ.
Come to page number 8. Second paragraph. ಈ ಜಮೀನುಗಳ ಒಂದು ನಕ್ಷೆಯನ್ನು ಬೆಂಗಳೂರು ವಿಭಾಗದ ಕರ್ನಾಟಕ ಕೈಗಾರಿಕಾ ಸೋನ್ಸೋ ಕಚೇರಿಯಲ್ಲಿ ಪರಿಶೀಲನೆಗಾಗಿ ಇಡಲಾಗಿದೆ. This is similar paragraph in the 28(4) notification.
I will secure it.
And counsel for the KDB 6 for 1 more week's time to comply with the order dated 5/3/2024. Relist on.
Deeply obliged. Obliged.
Petition the matter.
Petition is filed, my lords, for seeking quashing of the general award, my lords, passing of a consent award.
RSA ಏನಿದೆ?
Well, it's the contention taken by the KIDB is that there was some suit filed against me with regard to this property. Because the suit is dismissed. RA was filed, RA is also dismissed. Now RSA was filed. On that ground, they are refusing to take up my plea for passing of the consent.
What is the RSA about?
It's that RSA which is filed by the other party members. There's a private person who is involved. He had filed a suit against me for specific performance. Suit was dismissed. Before this honorable court.
Copies for the appellant here.
Sidwala Parapera.
Let him come.
Aye.
We'll list next week.
Please.
Not served a copy of the object.
I have furnished it.
I shall go through and make some appropriate submissions.
Copies of the SO filed by advocate for R3.
Served it on the PDA also.
It's I appeal for respondent number 2 BDA. The matters allotted copy is not yet served. Let petition.
I shall serve the same minutes. I shall.
Are 2 minutes.
Council is also directed to furnish
Request for a
petition
short date
papers to the council for the second respondent.
Short date.
That's grateful. Once I appear for the respondent number 4, may I kindly request for a passover, my lords. I filed I8. May I kindly request for a passover. I'm for the respondent number 4.
Until they are served, what is the point?
My lords, I have sought to vacate the interim order, my lords. I filed an IA to vacate the interim order, my lords. May I kindly request for a passover? Grateful.
Was told that they will conduct a survey with the proper instrumentation. So which instrument they want to use it and they will take it. And the
survey.
We will do it, but the permission is required to do it using the ETS system.
will
electronic
get the
total
permission,
survey.
letters, whatever the instrument they want to use. If they give it, I will get the permission from the headquarters. It's a strategic location. Officially, we have to get the permission from the New Delhi headquarters. We will get it. That's not a problem.
You are the one who's coming in the way of this survey.
We will get it, Manoj. We will get it. That is no problem. We will get the permission. We will permit them and get it completely survey that village. Identify the entire land which has been acquired and whose name this was notified also. The problem here is there are 14, 15 people are there from whom we have acquired, we have given the payment. Within that, they are trying to say that this land is there. Whether 180 acres only is there or excess land is there in that. If they identify it, then everything can be resolved. Only that's the issue, Manoj.
When will you get permission?
Manoj, if they give it today itself and we'll get to put it
We are
to.
ready to do it using the modern technology, madam. Because they won't allow even chain and all, they won't allow defense area.
No, that's what I'm requesting is, well, we will allow.
ನೀವೇ equipment ತಂದ್ಕೊಟ್ಬಿಡಿ ನಿಮ್ದೇ.
No,
ಅದ್ರಲ್ಲಿ
ಇಲ್ಲ.
ಮಾಡ್ತಾರೆ ಅವ್ರು.
ಅವ್ರದ್ದು ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ಇದೆ ಅದು ETS ಅಂತ ETS ಅಂತ ಇದೆ
Let
ಅಂತೆ
them take permission.
ಅದನ್ನ will get the permission if they give what instrument they use only will say put it immediately and get it.
ಕೇಳ್ಬಿಡಿ ನಾನು ಇಲ್ಲೇ ರೆಕಾರ್ಡ್ ಮಾಡ್ತೀನಿ ತಿರ್ಗಿ ನೀವು ಒಂದು letter ಬರೆದು. What is the equipment that you want to use?
Electronic total survey system. ETS system.
Total survey.
That they can write one letter, I will get it. ಅದು ಏನ್
Survey done, you get.
I will get it. Only one issue, is not like it's a strategic location where some information cannot be scanned or something like that. That will put it to their this thing and that's all.
You don't trust the state government also.
No, we are not doing so. Instrument, what they use, no, we will intimate them in advance and get that. That's all. There is
PGA submits that
nothing else, man.
the government is prepared to conduct a survey using
Electronic
ETS.
total survey station.
council for
Electronic
the
total station
petitioner
survey.
is directed to secure permission for the conduct of such a survey and inform the same to the DDLR.
Yes.
Once
Some
such
time frame
permission-
is fixed, man.
Such permission being granted to the DDLR, a survey shall be conducted. ಯಾವಾಗ?
ಅವರು ಯಾವತ್ತ ಹೇಳ್ತಾರೋ ಪರ್ಮಿಷನ್ ತಗೊಂಡು ಯಾವತ್ತು ಹೇಳ್ತಾರೋ ಅವತ್ತು ಮಾಡ್ತೀವಿ.
We will try to get it within next 4 weeks.
After election.
You are the one who's pulling, dragging your feet.
ಇಲ್ಲ ಮಾಡೋದು 4 weeks ಮಾಡ್ತೀವಿ ಅಷ್ಟೊಳಗೆ ಮಾಡ್ಕೊಡ್ತೀವಿ. ಯಾಕಂದ್ರೆ ಚೂರು ಅಲ್ಲೊಂದು ಸಣ್ಣ ಇಶ್ಯೂಸ್ ಇದೆ ಅದ.
Again, you will come back with one more affidavit saying notice was not served.
No.
So I'll fix a date now.
No. Date may fix.
Fix a date for the survey. What is your date? Tell me.
After election, was officials will not be available. After election. MP election.
May ಅಲ್ಲ?
May.
Third week.
May some date may fix.
Survey shall be conducted on May 15th.
May 15th.
May 15th. It is made clear that the petitioner shall not be do not expect a separate notice, and the passing of this order shall be considered as a notice
Notices.
for the survey department on the 15th of May. ಇನ್ಯಾರು ಇರ್ಬೇಕಾ ಅಲ್ಲಿ ಸರ್ವೆ ಮಾಡಕ್ಕೆ?
The respondent 5 must be present. Respondent number 5.
The DDLR to inform the 5th respondent that a survey will be conducted
By
on
11.
the 15th of May.
We will commence by 11 AM.
That's
11 AM. 11 AM, May 15th, 11 AM.
DDLR along with ADLR as well as Tahsildar. Last time that was the direction issue, Minister.
ಬೇಕಾದ್ರೆ ಕರ್ಕೊಂಡು ಹೋಗ್ತಾರೆ ಬಿಡಿ, ಅವ್ರಿಗೆ ಬಿಟ್ಟಿದ್ದಲ್ಲ.
Because
ಅದಕ್ಕೆ ಪರ್ಮಿಷನ್ ಕೊಡಲ್ವಾ?
ಇಲ್ಲ, that whoever comes, we will get the permission. They will intimate who are the persons who are coming, we will give the
We will
information.
Inform
intimate
them
them
in
at-
advance.
Advance.
Yes. ma'am. We will
Persons who are
intimate.
coming. Until such time, it's just that operation of the
The list on June 5th.
till such time, the sketches may be stayed, Maharaj, because the contempt is there. That's what they are pressing for that time.
Contempt act.
Yes, yes. Contempt is there.
Contempt ಇದೆ, but
ಯಾರು ಹಾಕಿರೋದು?
The respondent 5 has filed.
ನಮ್ಗೆ
Then he is not here.
It's not here. It's a
Not appeared.
notice yet to be ordered for. Till such time, because once it is clear, there will be, everything will be resolved.
Contempt is against which order?
Only DDLR and state government officer, not against the central government.
Lord, along with affidavit, I have mentioned this red petition number, which is 52713 of 2017. Para 4, my lord, affidavit as well.
ಎಲ್ಲಿದೆ ಮೇಡಮ್ ಕಂಟೆಂಪ್ಟ್?
ಕಂಟೆಂಪ್ಟ್ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ. ರೆಡ್ ಪೆಟಿಷನ್ ಆರ್ಡರ್ ನ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದ್ರು ಅವರು.
Contempt 9.
916 of 22, my lord. CCC 916 of 22.
No, what is the purpose in survey sketch and granting ST of the survey sketch?
But it's based on that only they were supposed to act because
No,
they
the
were.
contempt was filed for non-implementation of which order?
There's a 2021 order passed by the
No,
justice.
that is already complied with.
Not yet complaint, man. That's what the exact thing, because they have
Where is
produced
the
this
2021 order?
page number 109. 09.
Is there grievances, my lord? During the contempt proceedings, we have conducted this survey.
ಅದನ್ನೇ ಹೇಳ್ತಿರೋದು.
No,
But
that's-
their grievances is that they have not been served with notice.
So then contempt as, the order still stands compliant.
Hurriedly,
No, not further, they have to proceed for acquisition. That is another first next step. So that's where the issue is coming upon.
ಅವ್ರಿಗೇನಾರ ಟೈಮ್ ಕೇಳಿ ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಿ.
Till such time,
List, June 5th.
update,
5, 6. June
5th June.
oblige.
ಮಾಡ್ತೀರಾ ಇವತ್ತು?
I am ready.
I'll pass it over, I'll take it up afterwards.
Very
Pass over.
24 copy.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಗೌರ್ಮೆಂಟ್.
Password.
ಕೊಟ್ಟಿದ್ದಾರೆ, ಹೊರಗಡೆ. 24 ಅಲ್ಲಿ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ.
Appear for the petitioner in this case, minute. So far as IA is concerned, minute, through a memo, it has already been filed. This may be taken up along with this only for formality, minute, that IA has been filed. They should not have filed a memo, minute, but instead they filed an IA now. So therefore it may be posted along with the main minute.
But we have not been served with any of the.
A1 for production of documents should be considered along with the main red petition.
Please, Your Honor.
The copy of the IA is not served.
Copy
Well, I-
ಕೊಟ್ಟಿಲ್ವಂತೆ ರಮೇಶ್.
I'll instruct the instituting council, minute, to ensure that.
Copies be furnished to the council for the BDA.
Please, Your Honor.
For the petition. I have filed an application seeking for amendment of the writ petition.
What is the amendment sought for?
My lord, to one amendment is paragraph number 8, my lord. That I have sought for production of the final notification that is issued by the KIDB, as well as two other notifications, my lord, and as well as the prayer and the interim prayer. The prayer I have sought for quashing of the final notification. The amendment sought for is at page number 3 and 4.
Who's opposing you?
My lord, on the Mr. Pradeep Kumar appears for KIDB, my lord. On the last date of hearing, I had sought for replacement of the paragraph numbers, my lord. So he had no objection, just that due to the technicality, I was asked to make the
Amendment is allowed since no prejudice caused to the respondents. Amended petition to be filed within a week. Additional objections, if any, in 2 weeks.
interim order earlier granted.
Interim order grant earlier shall continue.
Much.
This is an advance early hearing application, my lords. The early hearing application once all filed and already been allowed, the matter is in hearing only.
In matter, no?
My lords. During COVID, my lords, the petitioner had laborers on the site. There were orders issued to the petitioner not to allow the laborers to leave. In those circumstances, my lords, the petitioners undertook certain construction. Thereafter, as soon as COVID eased, we made an application to the BDA saying, please issue commencement certificate, because in emergent circumstances, this construction was undertaken. BDA has refused to consider my application on the premise that you already construct marta ideri, therefore I cannot consider your application. This, my lords, is the
What is annexure L?
my lords, that is a letter, my lords, of rejection. Each one of those letters, my lords, are page number 110, my lords, is annexure L.
Which any annexure L, P and
Lords, L, P and S, my lords, each one of them, they say, sorry, we cannot consider your application because you have already undertaken construction. That is their principal ground. P is at 125.
you had sought for change of land use.
My lords, I sought for change of land use. Then your lords
Refused.
Please, my lords. Then I made an application under annexure P. It was once again rejected at 125.
It is reserved for an industrial purpose.
Please, my lords.
And you
From
want it to be used for,
educational purposes.
is that permissible?
My lords, it is not impermissible so long as, my lord, section 14 and 14A requirements under KTCP Act are met. That is, my lords, it is for public interest.
Objection accurate.
Okay.
In what is your ground?
It's in violation. Construction is in violation, my lord. There is no provision.
Change of land use gain, annexure L again, answer.
Annexure L, my lords, they filed two applications, once for development, issuance of development plan, and another for issuance, change of land use.
First is change of land use alva.
ಇಲ್ಲ ಅವರು ಎರಡಕ್ಕೂ ಹಾಕಿದ್ದಾರೆ. We have annexure L, we have rejected saying that the 10% ಗೆ ಮಾತ್ರ confine ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ. Because once they make an application for issuance of a development plan, then we look into the master plan, zonal regulations. As per the zonal regulations, the permissible limit is only up to 10%.
Permissible special circumstance ಕೊಡಕ್ಕಾಗಲ್ವಾ?
L provision ಇಲ್ಲ. See, they violated and they constructed a building. Now they say it's because of COVID situation. ಅಲ್ಲಿದೆ. 76F regularization ಗೆ ಬೇರೆ provision ಯಾವುದೂ ಇಲ್ಲ. 76FF ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ. 76FF ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಅವ್ರಿಗೆ ಅಪ್ಲೈ ಆಗೋದು ಇಲ್ಲ.
What is your answer, Kulkarni, on that?
Lords, my respectful submission, my lords.
Change of land use if the zone regulations don't permit more than 10% of.
Please, Lord, my respectful submission is twofold. One, my lords, under section 14 and 14A, that power is there with them to be able to make it, provided, my lords, the criteria mentioned in section 14 and 14A is met. In this case, my lords, they had to apply their mind and reject it. The criteria mentioned in section 14, my lords, for instance, they have to issue a public notice, they have to invite comments, they have to check whether it is in public interest. That exercise has not been done. That, my lord, is my first answer. Lords, my second answer is the circumstances at that time were such that I had no option but to undertake construction, because I was ordered
to keep those laborers on my premises, to house them, clothe them, feed them. Because there were orders, my lords, my respectful submission is at that point in time when I undertook construction, the operation of the statute was suspended. Therefore, for that period, this act does not apply at all. Only the DMA will apply.
Where's your application seeking for change of land use?
Please. Lords, my earliest application. Lords, my first application is at page 103. At annexure G. 18/7/2009.
Next year G.
Please.
This
Type copy
this
of
is for a
lordship.
building plan.
Please.
Where is your application for change of land use? Without there being an application for change of land use, you ask them to approve your building plan directly?
Your lordship, my lords, may please come to page 107, my lords. Lords, then your lordship may please see, my lords, 105 also. ಕೈಗಾರಿಕಾ ಉಪಯೋಗದಿಂದ ಶೈಕ್ಷಣಿಕ ಶಾಲಾ ಉಪಯೋಗ, page 105. In the subject matter itself, my lords.
This is only a communication asking you to produce certain documents.
Lords, at
Page 107.
please, my lords, that's the response. At 105 is my request. 105, your lordship may. please see.
105 is for building structure.
Not subject line, your lordship may see, my lords, please. Vishaya, Bengaluru Dakshina Taluku, type copy at 105. Hobli, Jalaghatta ಮತ್ತು ಗುಂಬಿಪುರ ಬಡಾವಣೆ ಗ್ರಾಮದ ನಿವೇಶನ so and so.
ಇದು ಖಾತೆ ಸಂಖ್ಯೆಯಲ್ಲಿ ನಿವೇಶನದಲ್ಲಿ ಕಟ್ಟಡ ಕಟ್ಟಲು ಪ್ರಾರಂಭಿಕ ಪ್ರಮಾಣ ಪತ್ರ ನೀಡುವ ಕುರಿತು.
Please, my lords.
Where is your application for change of land use? This was annexure page 107.
Please,
This was your, I think, first application.
105. Lords,
ಎರಡು ಒಂದೇ application ಹಾಕಿದ್ದಾರೆ, composite
ಬೇರೆ
application.
ಬೇರೆ ಹಾಕಿದ್ದಾರೆ. 2-3 ಸಲ ಎಟ್ ಇರ್ರೆಗ್ಯುಲರ್ ಇಂಟರ್ವಲ್ಸ್ ದೇ ಫೈಲ್ಡ್ ಅಪ್ಲಿಕೇಶನ್ಸ್. ಒಂದ್ಸಲ ಡೆವಲಪ್ಮೆಂಟ್ ಪ್ಲಾನ್ ಕೇಳ್ತಾರೆ, ಇನ್ನೊಂದ್ಸಲ ಕೈಗಾರಿಕಾ ಉದ್ದೇಶದಿಂದ ಶೈಕ್ಷಣಿಕ ಉದ್ದೇಶಕ್ಕೆ ಅಂತ ಕೇಳ್ತಾರೆ.
ಅಲ್ಲ ಇದ್ರ annexure J.
103 ಅನೆಕ್ಷರ್ ಜಿ ಅಲ್ಲಿ ಸಬ್ಜೆಕ್ಟ್ ಕ್ಯಾಪ್ಷನ್ ಅಲ್ಲಿ ಇದೆ. ಪೂರ್ತಿ ಕಾಪಿ ನಮಗೂ ಕೊಟ್ಟಿಲ್ಲ ಅವರು, ಟೈಪ್ಡ್ ಕಾಪಿ ಮಾತ್ರ ಇದೆ. ಅದರಲ್ಲಿ ವಿಷಯ ಲಾರ್ಡ್ಶಿಪ್ ಗೆಟ್ಸ್ ಇಟ್ ಮೈ ಲಾರ್ಡ್.
Yes.
ಆ ವಿಷಯದ ಲಾಸ್ಟ್ 1 ಚದರ ಮೀಟರ್ ವಿಸ್ತೀರ್ಣದ ಪ್ರದೇಶವನ್ನು ಕೈಗಾರಿಕಾ ಉಪಯೋಗದಿಂದ ಶೈಕ್ಷಣಿಕ ಉಪಯೋಗಕ್ಕೆ.
ನಂದ್ರಲ್ಲಿ ಇಲ್ಲ, ನಂದ್ರಲ್ಲಿ ಹೇಳೋದು ನಮ್ದ್ರಲ್ಲಿ ಕಟ್ಟಡ ಕಟ್ಟಲು ಪ್ರಾರಂಭಿಕ ಪ್ರಮಾಣ ಪತ್ರ ನೀಡುವ ಕುರಿತು ಅಂತ. Page 103. I think you put typed copy different from that of the.
Yes, my lords. I will correct it. I'll correct this. First, the type copy, my lords, contains that, but 103 does not say so.
ಪೂರ್ತಿ ಇದೆಯಾ ಅಪ್ಲಿಕೇಶನ್ ಅದು? ಬರೀ ಒನ್ ಶೀಟ್ ಇದ್ದಂಗೆ ಇದೆ.
Yes, my lords. It is typed copy of annexure.
Page 105, just 2 columns. There's a sketch annexed to it. I don't think the application is complete.
Please.
ನನ್ನ ಹತ್ರ 105 ಇಲ್ಲ, 105, 106 ಎರಡೂ ಇಲ್ಲ.
I'll give him copies, my lords. I'll produce the full copy of the.
In 107, they've given some reply. What did you respond to page 107?
Yes, my lords.
What was your response?
My lords. At 109, my lords, is my response. What I do, my lords, is I submit all the documents they have asked me. I also drop, my lords, one survey number 49/2. ಅದಾಗಿ ಈ ಮೂಲಕ ತಮಗೆ ತಿಳಿಸುವುದು ಏನೆಂದರೆ, ಬೆಂಗಳೂರು ಜಿಲ್ಲೆ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಕೆಂಗೇರಿ ಹೋಬಳಿ ಚಲಘಟ್ಟ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ so and so 7 ಎಕರೆ 33 ಎಕರೆ ಗುಂಟೆ ಹಾಗೂ ಕಂಬಿಪುರ ಗ್ರಾಮದ so and so ದಿನಾಂಕ 18/7/2019 ಅರ್ಜಿ ಸಲ್ಲಿಸುವುದು ಸರಿ ಅಷ್ಟೇ.
ತಿರ್ಗಾ ನಕ್ಷೆ ಮಂಜೂರಾತಿಗೆ ಅಂತ ಕೇಳ್ತೀರಾ?
ಸ್ಯಾಂಕ್ಷನ್ ಪ್ಲಾನ್.
My lords.
Think there's some confusion.
Yes.
There's no chronology, it's not coming across correctly.
Please. Your lordship may, one last letter, my lords. I will make a list of dates and I'll submit, my lords. Page 111, annexure L. This is their response, where, my lords, they say, they respond. And they also respond, my lords, that there is only a minimum area, only 10% one will be able to use. But, my lords, I will put together, my lords, a list of dates together with these documents. The list.
15.
Great.
One, 2 to 5. Paper 2 weeks.
We want to implement.
The land acquisition officer who was in office of the respondent number 5 has been implemented personally.
Okay.
The respondent number being the proposed respondent has intentionally had paid the compensation amount for land belongs to the petitioner's. When she had mutated, passed an order when she was Tahsildar in the office of the Downtown Tahsildar, my lord, she had passed an order for mutation.
Notice ಹೋಗಿದ್ಯಾ ಅದ್ರ ಮೇಲೆ?
But I have filed Wakalat Malad on behalf of proposed respondent number 8. But I would like to file my objections to the application because Malad in her official capacity, she is arrived as respondent number 5. Now, whatever she has done, it is in her official capacity.
I'll allow the application because they are making alleging malafides. File what objections that you want to file.
But I don't think Malad, the presence of the respondent number 8 in her individual capacity may not arise. For this is only 2 dates Malad submit. Malad, the compensation,
49
compensation has been disbursed on 8/6/2023. The objection was filed by the petitioner for payment of compensation after 1 month from the date of dispersal. Therefore, I have no idea, Malad, whether there was another claim in respect of the very same land. Therefore,
Commissioner has clearly passed an order. The previous predecessor in the office of the respondent number proposed respondent number 5 had sought clarification from the assistant commissioner. And assistant commissioner had clearly stated that the land belongs to some other person. That is petitioners. In spite of that, the proposed respondent.
What is annexure S?
Annexure S is the endorsement given by the proposed respondent number 8. The land acquisition officer has usurped the powers of the reference court or civil court bailiff. Though there was a title dispute, the compensation has been paid. Page number 49, my lord.
Iದೇನು page 49, read page 49
Please, please.
Page 49, last 2 paragraphs.
from the first paragraph.
First, ಈ ಕಚೇರಿಯ ಉಲ್ಲೇಖ 5ರ ಪತ್ರದಲ್ಲಿ ತಹಶೀಲ್ದಾರ್ ಹರಿಹರ ಇವರ ನ್ಯಾಯಾಲಯದ ನಂಬರ್ RRT ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಆದೇಶವನ್ನು ಮರುಪರಿಶೀಲಿಸಿ ಸೂಕ್ತ ಆದೇಶ ನೀಡಲು ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ದಾವಣಗೆರೆ ಇವರನ್ನು ಕೋರಲಾಗಿದ್ದು,
ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 6ರ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ದಾವಣಗೆರೆ ಉಪವಿಭಾಗ ದಾವಣಗೆರೆ ಇವರ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಲ್ಲಿ ತಹಶೀಲ್ದಾರರು ಹರಿಹರ ತಾಲೂಕು ಇವರ ಆದೇಶ ದಿನಾಂಕ ಸೋನ್ಸೋ ಆದೇಶದ ಹುಚ್ಚಪ್ಪ ಬಿನ್ ಹನುಮಂತಪ್ಪ ಬೆಳ್ಳುಳ್ಳಿ ಇವರ ಹೆಸರಿಗೆ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಲು ವಿರುದ್ಧ ಮೇಲ್ಮನವಿ ಪ್ರಾಧಿಕಾರವಾದ ಈ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಯಾರೂ ಈವರೆಗೂ ಸಹ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲವಾದ್ದರಿಂದ ಹಾಗೂ ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿಯೂ ಸಹ ಯಾವುದೇ ಹಿತಾಸಕ್ತಿದಾರರಿಂದ ಈ ಪ್ರಕರಣದ ಪಕ್ಷಗಾರರಾಗಿ ತಮ್ಮ ಅಹವಾಲನ್ನು ಹೇಳಿಕೊಳ್ಳಲು ಯಾವುದೇ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲವೆಂತಲೂ ಮತ್ತು ಹಾಲಿ ಸದರಿ ಜಮೀನು ಕರ್ನಾಟಕ ರಾಜ್ಯಪತ್ರದಲ್ಲಿ ಪ್ರಕಟಿಸಿರುವ ಸೋನ್ಸೋ ರಂತೆ ಕೆಎಡಿಬಿಗೆ ಭೂಸ್ವಾಧೀನವಾಗಿದ್ದು ಸದರಿ ಪ್ರಕರಣ ವಿಚಾರಣಾ ಹಂತದಲ್ಲಿರುವಾಗಲೇ ಕೈಗಾರಿಕಾಭಿವೃದ್ಧಿ ಮಂಡಳಿ ಎಂದು ನಮೂದಿಸುವ ಬಗ್ಗೆ ಎಂಆರ್ ನಂಬರ್ ಸೋನ್ಸೋ ದಿನಾಂಕ 22/2/2022ರಂತೆ ಮ್ಯುಟೇಷನ್ ಆಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಸದರಿ ಜಮೀನಿನ ಖಾತೆ ಮತ್ತು ಪಹಣಿಗಳಲ್ಲಿ ಯಾವುದೇ ಬದಲಾವಣೆ ಬಗ್ಗೆ ಆದೇಶ ಹೊರಡಿಸಲು ಇರುವುದಿಲ್ಲ ಎಂದು ತಿಳಿಸಿ ಪ್ರಕರಣ ಮುಕ್ತಾಯಗೊಳಿಸಿ ಆದೇಶ ಮಾಡಿರುತ್ತಾರೆ.
No, the earlier paragraph indicates that they did receive a legal notice by which a rival claim was stayed. How can you correspond
No,
with
the legal notice was issued on 22/8/2023. The compensation was disbursed on 8/6/2023 itself, 2 months prior to the issuance of legal notice.
Then where is the concept of you corresponding with them?
But earlier in 2021, there was a communication to the assistant commissioner.
No, that means you were aware there was a rival claim.
But the assistant commissioner has said, now since there is no.
Can you act upon the assistant commissioner's order?
The assistant commissioner has reported to KIDB saying that since there are no.
That the procedure to be followed.
But the compensation is now paid in favor of the notified khatedar only. The RTCs were standing in their name.
The moment you were aware there was a dispute, what was your duty?
As on the date when the.
You go on exploratory avenue where you decide whether.
They have produced the documents of title based on which the compensation is disbursed.
Why did you have to write to the assistant commissioner? Because you were aware there was a dispute.
At that point of time, there was no dispute.
ಅದಕ್ಕೆ ಈ ಕಚೇರಿಯ ಉಲ್ಲೇಖ 5ರ ಪತ್ರದಲ್ಲಿ ತಹಸೀಲ್ದಾರ್ ಹರಿಹರ ಇವರ ನ್ಯಾಯಾಲಯದ MR ನಂಬರ್ ಸೋನ್ಸೋ
In that proceedings, KDB was not a party. It is inter.
Why did you write to them?
This is written pursuant to the document produced by the petitioner. This endorsement is subsequent endorsement in which earlier proceedings have been indicated. As on that date, it was the Tahsildar and the assistant commissioner. They were corresponding. We were not party.
Was the award passed? To whom was the award notice issued?
The KDB.
63/2020.
This is the second or third case I am coming across KDB where the land acquisition officer becomes a district judge.
In this case, there is no such thing. As per the records produced by the petitioner themselves, on the date of dispersal, there was no objection by anybody for payment of compensation. And the RTC were standing in the name of the person to whom the compensation is disbursed.
When did you raise your first objections?
First of 26/7/2020.
Award notice banta?
Illa namagen.
26.
Because Khata was changed in the name of the father-in-law of this seventh respondent.
The first time objection was raised as per Annexure N, page 37. That is on 26.
What is the date of 28/1?
The 28/1 minutes.
Dates idea?
I don't have the records. It is carried.
File your objections.
Please.
The list on. Make sure that whether objections are filed before or after the disbursal.
Please, minutes. It is after the disbursal. I'll file the counter indicating the dates. Minutes. 2 weeks. 15th, 17th, 18th. Please, minutes.
That's on the last date. They have given me one document to show that one site is vacant. I went to that site and it is, let alone 40/60, it is less than 30/40 also, and it is in a triangle shape, which is not fit for construction. I have taken the photo.
What was the site allotted to you measurement?
40/60. 60/40 mandates, yes.
We had identified a vacant site. We shared it with her.
Yes.
She says it is not even 30/40.
As per our report, it is vacant site.
And to get these reports, we are, the officers were not available. That is why we are to the election.
I think you're just making a run around. When he made the submission that the site was available, you should have known the dimensions of that site.
60-40, my lord, as per our reports, my lord, it is 60-40. I shared it with the.
I'll appoint somebody here. Suppose it comes out, it's not 40/60. I'll impose severe costs on it.
My lord,
When he makes a statement, there's some responsible statement.
my lord, will verify again.
You identify a site, then you say, no, the earlier site is available. That site is not available now. Ask him to be serious, or else
Only because the engineers, my lord, they are.
he is before the court, he is personally present, he knows what is happening. Released on Wednesday. Let him come until this is solved.
Represent the
This
state in the matter.
matter, my lord,
This is the matter which had come.
Penganalli, my lord, the metro matter,
Huh.
they are required to deposit, my lord, 5 crores and that towards the interest. Some my share, my lord, they
Let me have my
deposited.
say at least. Lords, on the last occasion, my lords had found that the SLO would not get powers insofar as adjudicating facts to my lord's notice subsequent to the representation which was given by the petitioner, my lords, which my lords would find, which was dated 10th of February 2013. Since
What is the date of the 28-1 notification? 28-1, ಏನಿದು?
Under Land Acquisition Act, my lord, 17 invoked, 4-1 as well as, my lord, 17 also invoked and possession was taken.
Lords, 4/10/2008 was the preliminary notification. 4/11/2008 was the final notification. 4/10/2008 preliminary notification. 4/11/2008 final notification. Award passed on 11th of July 2010.
What is the date of the declaration? Same day,
Same day, lords.
4/10.
Lords, everything is at rest, my lords, till the representation dated 10th of February is given by the petitioners.
What is the name of the, what is the survey number in what?
Sorry, my lords?
Survey number.
Survey number is, my lords, 15/2, Benniganalli village,
15
1
bar,
acre 38 guntas,
15 bar,
15/2, my lords.
Page 28, please, my lord. Notification. Bayamma, A. Chinnappa, Bayanna Sarkara.
1 acre 38 guntas.
Please. 22 acres, 22 guntas was
Bayamma,
to NGF.
A. Chinnappa, Bayanna, my lord, my brothers. Bayamma, my mother.
May I just give the chronology of the,
1 minute.
please.
There were 4 names, Bayamma.
ಇಲ್ಲ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಅಪ್ಪಾಲಪ್ಪ is the original propositor.
No, the notified khatedar.
Notified khatedars are only 3. That's the reason I wanted to.
Bayamma,
Bayamma, Bayanna and Chinnappa.
Bayamma, Chinnappa and Bayanna.
Yes, my lords. The Appalappa has 2 wives. The first wife's son is Chinnappa.
Declaration is also in the name of these 3 people.
Please, my lords. Now what would happen is, till this date of 10th of February, which is at Annexure A, page number 14,
What is Annexure H?
Annexure H, my lords.
My lord, the award.
Annexure H is the award.
Award.
Page starts at 32 minutes.
Date of the award?
My lord, the
11/7
page number 41, 11/7/2010.
11th, it's his case. Really, sir.
11?
2010.
11/7, huh?
Please. My lords would find all the 3 names in the award. I just pass the original records already. One desert ಕಾಣಿಸ್ತಿಲ್ಲ. I just pass this for my lord's consideration.
Photos.
My survey number covers from page number 35, my lord, from bottom.
ಎರಡನೇ ಲೈನ್ ಹಾಕಿದ್ದೀನಿ.
ಇಬ್ರೇ ಇದ್ರೆ ಖಾತೆದಾರ ಬೈಯಮ್ಮ ಎ ಚಿನ್ನಪ್ಪ.
ಇಲ್ಲ, ಇದು ಅದು ಕಾಣಿಸ್ತಿಲ್ಲ. I'm producing the original minutes, which my lords may kindly peruse. ಅದು ಈ ಲೈನ್, ಎರಡನೇ ಲೈನ್, ಮತ್ತಿದ್ದು ಇದು, ಅದು. In between the tabular column, my lords would find in the second line. ಖಾತೆದಾರರಾದ ಬೈಯಮ್ಮ ಎ ಚಿನ್ನಪ್ಪ ಬೈಯಣ್ಣ.
The first objection, what is the objection? 12 notice ಯಾವಾಗ ಆಯ್ತು?
ಯಾವತ್ತು ಮೇಡಮ್ 12 notice?
12 notice.
No 12 notice, please.
ಇವರು till
let
from
this
the
say-
award, they keep quiet till the annexure A.
No,
Where is
they
the
may
12
keep-
notice? To whom was it issued?
Not very sure, minutes. But they 12 notice ಕೊಟ್ಟಿದ್ದೀರಾ?
Page 36 earlier was says, please deposit in the civil court.
ಅದ್ರಲ್ಲೇ ಇದೆ.
ಕೊಡಿ. notice ಕೊಡಿ. 12 notice ಕೊಡಿ.
ನೋಡಿ.
90 days, please.
You invoke the urgency clause.
Yes, my lords. What would happen is,
Where was the 80% compensation deposited when?
it was it was got disbursed to these three children of Bayana.
4/10/2008 is the date of the declaration.
Yes, my lords.
According to 17(3), you're supposed to deposit 80% on the date you took possession. So when did you take possession and when was the 80% deposit?
Deposit was done much subsequently, my lords. The date, I produced the copy of the
Then the once you invoke,
23 ಅಲ್ಲೇ ಮಾಡಿದ್ದು, ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಮಾಡಿಲ್ಲ. I should be quite.
then what?
What would happen? That's the reason I wanted to only make this submission. Till annexure A is issued on 10th of February 2023, this officer would assume post as an SLO in 2019. I produced the CTC also. 23 vargu everything was kept quiet. 23 early after this notice was given.
No, 4/10/2000 is declaration.
Please.
When do you take possession?
We have taken possession then only, my lords. I've taken possession on 18th of October 2008.
18th of?
October 2008.
Then when was it 80% deposited?
23 minutes. That's the reason I wanted to bring it to my lord's notice. Land acquisition proceedings were going on quite some time, my lords. This officer would come to the post of SLO only in 2019. 2023 February vargu, there was no issue which was opened at all. 2023 February, when this notice was given, what this officer would do is, may I just pass this.
The award, let me go one by one. 18/10/2008 possession was taken.
Please.
80% is not deposited.
No, it's not deposited.
Then you proceed to pass an award on 11/7/2010.
Please.
When was the 12/2 notice issued? In whose name was it issued?
12 to 40 ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು.
Then what kind of an acquisition is this?
Only under the emergency clause, because they said some medical emergency was there, he would issue it only in 2023 minutes by virtue of an order.
2010 to 2023. There's no notice of the award.
But I'm not sure whether any, because I'm told that certain litigations were going on with regarding to.
You need to-
ಕೊಟ್ಟಿಲ್ಲ. I have to concede before my lords, 12 to 70, 12 to ಕೆಳಗಡೆ, they had to, the collector had to give a notice to say that we were taking over the property and. They have not, my lords. That's the difficulty. Because he says 2019, we have, whatever has happened, my predecessors have done. 2019 in the 23 February or till this notice was given, nothing happened. What he would do is a little important, my lords. After February 2023, when he receives the notice, he would ask the petitioners to give documents to indicate who are they and how are they eligible. Or yav document kodalla. Per se, the other impleading respondents who are now before this honorable court would give documents to show that how they have, are the legatees or successors in charge.
Then he judged the whole issue.
No, minutes, he could not have. What he would do is, he passes an,
The moment a claim was made.
he should have sent it to the civil court to get it adjudicated.
Then
But he
that's good
only-
enough for me. As it is, 80% is not deposited.
Please.
What notice is not issued?
But what he would do is, insofar as the petitioner's claim of 1 crore and odd is concerned, that he has deposited it before the civil court, that amount is not touched. My only submission is this, my lords, if at all, if that could be taken into consideration to say that the award money which the petitioners are entitled to is kept before the honorable civil court. That is intact. There is no question of the SLO
He has
retail.
basically judged that will be entitled only to 1/3.
Our 1/3, that is their claim also to say that 1/3.
Where is their claim?
In the annexure A, which is page number 14, minutes.
Before that, my lord, may I request, my lord, BMRCL file a counter. My lord, when was passed the award, when was deposited
Page
the
number
amount?
16 ಅಲ್ಲಿ last unnumbered paragraph, notes. It's 16, further ಅಂತ start ಆಗುತ್ತೆ. Further, you may please take note that the Honorable High Court in petition number so and so has ordered withdrawal of the amount by establishing that they are the legal representatives of the owner, original owner. Now, I being one of the legal heads of the original owner, late so and so, has got 1/3 equal share in the compensation amount awarded. Hence, I earnestly request your good sir, disburse this share.
If not record, my objection and refer the matter to the city civil court under section.
But you are claiming only 1/3 share.
My lord, 3 children, my lord, Appalappa.
You are claiming only 1/3 share.
1/3 share, 1/3 share only. I am seeking, my lord, please deposit the entire amount. My share I'll take. My brother, they'll come and check their share. Instead of that, they divided into 3 shares. 2 shares, my lord, he has dispersed, and my share, my lord, now dispersed before the civil court without, my lord, interest.
You are Bayamma.
Bayamma.
What is the relationship of the family?
My lord, I am a daughter of my lord Appalappa. 2 others are, my lord, the first wife's son and the second wife's son. Bachana is my brother.
ನಿಮ್ಮ ತಂದೆ ಹೆಸರೇನು?
Appalappa. Appalappa.
ಇವ್ರು ಇಬ್ರು ಹೆಂಡ್ತೀರಾ?
ಇವ್ರು ಇಬ್ರು ಹೆಂಡ್ತೀರು. ಅದರಲ್ಲಿ ಬಯ್ಯಣ್ಣ ಮೊದಲನೇ ಹೆಂಡತಿ ಮಗ.
ಹೆಂಡತಿ ಹೆಸರೇನು?
No, my lord, ಎ ಚಿನ್ನಪ್ಪ ಮೊದಲನೇ ಹೆಂಡತಿ ಮಗ. Then ಬಯ್ಯಣ್ಣ.
ಹೆಂಡತಿರ್ ಬದುಕಿದಾರ ಇಲ್ವೋ?
ಇಲ್ಲ ಇಲ್ಲ
ಇಲ್ಲ.
ಇಲ್ಲ, ಇಬ್ರು ತೀರೋಗಿದ್ದಾರೆ. ಇಬ್ರು ತೀರೋಗಿದ್ದಾರೆ.
ಮೊದಲನೇ ಹೆಂಡತಿ ಮಗನ ಹೆಸರೇನು?
ಮೊದಲನೇ ಹೆಂಡತಿಯ ಮಗನ ಹೆಸರು ಚಿನ್ನಪ್ಪ, ತಾಯಿ ತೀರೋಗಿದ್ದಾರೆ. ಎರಡನೇ ಹೆಂಡತಿ ಅಗೇನ್ ಬಯ್ಯಮ್ಮ.
ಸೆಕೆಂಡ್
For convenience sake, we'll just say ದೊಡ್ಡ ಬಯ್ಯಮ್ಮ. ದೊಡ್ಡ ಬಯ್ಯಮ್ಮನಿಗೆ ಇಬ್ಬರು ಮಕ್ಕಳು, ಬಯ್ಯಣ್ಣ ಅಂಡ್ ಬಯ್ಯಮ್ಮ ಅಗೇನ್, ಚಿಕ್ಕ ಬಯ್ಯಮ್ಮ. Now after her death,
ಬಯ್ಯಮ್ಮನಿಗೆ ಎಷ್ಟು ಜನ ಮಕ್ಕಳು?
ಇಬ್ರೆ, ಬಯ್ಯಣ್ಣ ಅಂಡ್ ಬಯ್ಯಮ್ಮ.
ಬಯ್ಯಣ್ಣ and
ಬಯ್ಯಮ್ಮ. That's the reason in the award my lord should
3
find.
children.
Sorry, my lord?
3 children.
3 children. ಇಬ್ರೆ.
ಅದೇ
ಅಪ್ಪಲಪ್ಪನ 3 ಜನ, ಇಬ್ರು ಹೆಂಡತಿದ್ರಿಂದ ಸೇರಿ ಚಿನ್ನಪ್ಪ, ಬಯ್ಯಣ್ಣ ಅಂಡ್ ಬಯ್ಯಮ್ಮ.
The wife Bayamma is also not the second wife.
ಇಲ್ಲ.
She is also not.
ಇಲ್ಲ, ಬಟ್ ಅವಾರ್ಡ್ ಟೈಮ್ ಅಲ್ಲಿ ಇದ್ರು, ದಟ್ ಇಸ್ ದ ನೇಮ್, ದಟ್ಸ್ ದ ರೀಸನ್ ಹರ್ ನೇಮ್ ಆಲ್ಸೋ ಫೈಂಡ್ಸ್ ಇನ್ ದ ಅವಾರ್ಡ್. ಚಿನ್ನಪ್ಪ, ಬಯ್ಯಮ್ಮ ಅಂಡ್ ಬಯ್ಯಣ್ಣ.
Bayamma's daughter is also called Bayamma.
ಬಯ್ಯಮ್ಮ, ಶಿ ಇಸ್ ದ ಪಿಟಿಷನರ್ ಬಿಫೋರ್ ಮೈ ಲಾರ್ಡ್ಸ್.
ಕರೆಕ್ಟ್ ಅದು?
ಹೌದು.
Now he is dispersed to Chinnappa.
He is dispersed to Chinnappa and the 3 children of Bayana, because Bayana is no more.
Yogesh, Santosh Kumar and Madhu.
And 1/3
dispersed, 1/3 to Chinnappa and 1/3 to Bayana.
Children of Bayana.
To the 3 children.
Please, my lords. The other 1/3 is deposited before the civil court.
But what about this 80%?
80% of what been disbursed to Bayana's 3 children is there. 20% again is before the honorable civil court.
What 20%?
What he would do is, by an order which he passes as on to indicate 25th of October 23, after taking into consideration the representation of the petitioner and the other 3 children of Bayana, you would pass this order. May I just pass this across me? Sir. You have another copy? ಈ ಆರ್ಡರ್ ಮಾಡುವ ಮುನ್ನ ಅವರಿಗೆಲ್ಲ he will issue notices. Copy of the notices also. These are the notices which was issued subsequent to annexure A. Sir. Order ಕೊಡಿ. After annexure A was issued, these are the notices which were issued.
This is not a registered partition.
Minutes, it says unregistered partnership for partition. Minutes, may I just pass this also, minutes.
And suppose all of them are entitled to an equal share, then what will you do?
That is what his interpretation is, to say that since the three children were entitled to, except the petitioner not producing any documents, and since they gave a or last but unnumbered, last but one paragraph before the operative portion, this is what it reads, minutes. ಅದರಂತೆ ಶ್ರೀ ಚಿನ್ನಪ್ಪ ಬಿನ್ ಲೇಟ್ ಆಫ್ ಅಪ್ಪಾಲಪ್ಪ ಅವರು ಹಾಗೂ ಸಂತೋಷ್ ಕುಮಾರ್ ಹಾಗೂ ಸೋನ್ಸೋ ಈ ಕಚೇರಿಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು, ಈಗಾಗಲೇ ತಮ್ಮ ಜೀವನ ಆಧಾರಕ್ಕಿರುವ ಜಮೀನನ್ನು ಕಳೆದುಕೊಂಡು ಸುಮಾರು 15 ವರ್ಷದ ಮೇಲಾಗಿದ್ದು, ಇದುವರೆಗೂ ಯಾವುದೇ ಪರಿಹಾರ ಹಣ ನೀಡದೇ ಇರುವುದು ಹಾಗೂ ಸಂತೋಷ್ ಕುಮಾರ್ ಅವರ ಕಿಡ್ನಿ ವೈಫಲ್ಯವಾಗಿದ್ದು ಚಿಕಿತ್ಸೆ ಹಾಗೂ ಹಣದ ಅವಶ್ಯಕತೆ ಇದ್ದು, ಮಾನ್ಯ ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸೋದಂತೆ 80ರಷ್ಟು ಪರಿಹಾರವನ್ನು ಪಾವತಿಸುವಂತೆ ಸೂಚಿಸಿದ್ದು, ಅದರಂತೆ ತಮ್ಮ
There's a contradiction. In one breath, he accepts a partition deed.
I understand.
And then he says, no documents
Could
are
not have
produced.
done that, minutes, because in the second unnumbered
Whether there is
paragraph,
a partition he accepts or partition does not
he
accept.
accepts. He says ಮೂರು ಜನಕ್ಕಿದೆ, ಚಿನ್ನಪ್ಪನಿಗೂ ಇದೆ, ಬಯ್ಯಣ್ಣನಿಗೂ ಇದೆ, ಬಯ್ಯಮ್ಮನಿಗೂ ಇದೆ. However, Chinnappa produces documents, Bayyanna's children produces
If he is
documents.
accepting the partition, where is the question of producing documents?
Yes, minutes, because the order according to him would say that revenue ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ವ್ಯಾಜ್ಯ ಇದ್ದಲ್ಲಿ ಸಿವಿಲ್ ಕೋರ್ಟ್
He is not dispersed the amount on the basis of the revenue documents.
Please,
He is dispersing the amount on the basis of the partition deed.
please,
Unregistered partition deed.
please.
Not notified the Atadasan. Mother is notified. He's becoming a Supreme Court judge now.
My grandfather is a
Are
owner.
with his
How he is
attitude, not
concerned
how
about
much ever-
this, my lord. There may be any number of children. How he is concerned about? It may be in the name of my grandfather. He died. Subsequently, others also must have been died. What is your role?
Madam, he is dedicated what?
In the award itself, it has been clearly stated that if there is any dispute under section 3031, directed them to deposit the amount. Now BMRCL says, my lord, 116 crores, they have been at one stress, they have deposited with the LAO.
ಅದು
Way back
53
in year
acres.
2008.
That is for the entire 53 acres.
What about the other 20%? He says about 80%.
20% is again deposited before the Honorable Civil Court is my instructions. One-third portion, no? 20% remaining of Bayana's children's portion is deposited before the civil.
Your Bayamma.
Yes.
This was in 2009 was the order to deposit, isn't it?
Yes, ma'am.
So 2080% amount you not deposited.
Illa.
Then interest component?
No, he would come into this post only in 2019. Interest calculate ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೀವಿ. My lords may kindly see the deposit receipt along with the calculation which I produced, my lords, as on 12th of March. ಅದರಲ್ಲಿ ಹೇಳ್ತೀವಿ.
No.
ಒಂದು ಎಕರೆಗೆ
The
ಎಷ್ಟು?
interest component starts from 2009, isn't it?
Yes, my lords, we have explained, but 2008 ಇಂದಾನೆ.
2008.
Yes, my lords, 8.9% interest from 29th of November. ಅಲ್ಲ, ಇವ್ರು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿರೋದು not 12th of March I produced one document, my lords, along with a memo.
ಅಲ್ಲ ಅವಾರ್ಡ್ ನಲ್ಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ 9% plus 12%, 15% ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಲ್ಲಿಂದ ಆಚೆಗೆ page 36 ಮ್ಲಾಟ್ they have given the interest up to 11/7/2010, 222 days.
May I just pass this across the
Page number 36.
the calculation slip, my lords.
From 12/7/2010, they have to not pay 15% interest. Page number 36. Madam.
Interest from which date have you given?
Sorry, my lords.
Interest which date? From which date have you started?
29/11/2008 ಇಂದ start ಮಾಡಿದ್ದೀವಿ. 9%.
You took possession in 18/10/2008.
Yes, my lords.
From from that date, what is the percentage of interest?
9% is what the award would indicate, my lords. In the award at page number 36,
Now, what is this 11/10/2010? But if the award notice is not given to
issued
the,
at all under 12/2,
then what is the interest component?
Because we have only gone by the award, which indicates the date as well as the percentage.
What does the act say for land acquisition? Interest will runs till when? Land acquisition.
From the date of taking possession or to the date of deposit, my lord, interest starts.
Section 34, my lords.
When was the deposit made?
The deposit was made 12/3/2024 itself.
Or notice another, what is the effect?
What he should have done is, at the time of deposit, at least he should have calculated as per 34 and then indicated this is the amount, and if at all any money was yet to be received from the BMRCL, he should have done that. To my knowledge, he has not indicated to the BMRCL also. His liability. ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ? Interest ಇಲ್ಲ ಅಂತ ಹೆಚ್ಚು ಕಡಿಮೆ ಆಗಿದೆ. ಅದು ಹೆಸರು ನಿಮ್ಗೆ ಹೇಳಲಿಕ್ಕಿತ್ತು. That is what 34 says.
Ability to pay interest will continue. You don't even notify them of the.
That is the reason I wanted my lords to have a look at the percentage of interest which we have calculated.
That's only up till 2010.
Yes, my lords. Adu 9% irutte. As per 34, if it is crosses 1 year, then it would attract 15%, and he has given 50, I mean, the 15% is calculated.
Only till
Only
29.
to the 2010, my lord, 29th of June 2010.
Afterwards,
They should have intimated to the BMRCL if at all, if there is any interest component which is not given, and then subsequently taken it forward. my lord. But they would keep quiet from 2010 till 23 months.
you also kept quiet.
Yes, my lord, because my officer says that ಅವ್ರಿಗೆ ಗಮನಕ್ಕೆ ಬಂದೇ ಇಲ್ಲ.
The moment the award was passed,
Please, my lords.
you should have put them on notice.
Yes, my lords.
Then they had a chance to seek for reference or whatever. By
True.
not doing so, if you issue a 12
No,
notice
no.
now,
Only possible reason was till 2014 or 15, the acquisition proceedings litigation was still.
2013 it came to an end.
Please, my lords.
When the Supreme Court, from 2013
13 onwards till 2023, 10 years,
Ten.
they're not. Only to say that 2019 al ನಾನು ಈ post ಗೆ ಬಂದದ್ದು, ಅದಕ್ಕಿಂತ ಹಿಂದದ್ದು I am not aware is what.
when he is passing an order of this nature, he did not do his duty at least then.
He should have bought it.
How do you propose to solve this now?
Lords, my understanding is, my lords, if at all, if he can be, this officer can be held responsible only after the legal notice which was issued on 10th November 2023, till he made the deposit on 6/3/2024, my lords. To that
One
extent.
part.
Yes.
What about the earlier part? How do you solve that?
Lords, insofar as the persons who have already received the apportionment.
But then they'll be entitled to the interest till the
I understand, Lords.
notice of the award.
Not my submission is this for my lord's consideration. Since they've already received the 80%, 20% is already in deposit. If they have any issues with the interest as such, my lords would kindly refer them to the civil court. Anyway, they have to
Why
go
should
there.
I do that?
No,
Isn't
lords,
it-
I'm only trying to see if this could be worked out in a way. my
No,
lords.
make them 15% deposit from BMRCL into the civil court, then. ask
May
civil
just
court.
get some instructions.
BMRCL is going to, you have deposited the amount in 2008 itself.
ನೀವು ಅವ್ರ ಹತ್ರ ಮಾಡಿದಿರ?
ಅಲ್ಲ ಹೌದು acquiring authority, because we cannot be direct pay to the
ನೀವು
landlord.
ಉಂಟು ಅವ್ರು ಉಂಟು ಜಗಳ.
ಅಲ್ಲ ನಾವು only we can deposit the amount with the the acquiring authority. Acquiring
ಯಾವ
authority,
ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ?
my lord, we deposited on 2008, my lord.
That is 80%.
No, entire amount, 29/11/2008, my lord, we have.
The award was passed on 11/7/2010. How
No,
can you
they
deposit?
have the calculated and called the entire 53 acres of land, the cost of the, my lord, the annexure.
Award was passed only on 11/7/2010.
My lord, the
They
annexure.
have paid 80% of the cost as estimated when taking possession.
No, we have, my lord, kindly see the annexure R2 to my statement of objection. They themselves calculated, the acquiring authority calculated the amount. Then they directed, they called upon to deposit the amount. We immediately deposited the entire amount with the acquiring authority.
Then again, it will be on your head.
I understand, lords. My instructions are you would write to the BMRCL indicating this is the anomaly which has occurred. And insofar as the interest is considered, he will get some response. My lord may have it next week or week after next on a Monday or Tuesday. By then, we will at least get some instructions whether who is to be held responsible, whether the BMRCL or my officer.
Now, this Bayana's 3 children have taken the compensation.
They are present before
And
my lords.
Chinappa has also taken the
Yes, my lord.
compensation.
Chinnappa is not before my lords. Only Bayana's children are there who have now.
Chinappa ಅವ್ರದ್ದೇನ್ ತಕರಾರು ಇಲ್ಲನ್ರಿ?
They are entitled for compensation. my lord.
ಅವ್ರದ್ದೇನ್ ತಕರಾರು ಇಲ್ವಾ?
Interest ಇದೆ, ಅವ್ರದ್ದು ಇದೆ.
ಇದೆ ಅಂತ ಕೂಸಿ.
Claim ಇದೆ. They have taken compensation.
not come
but
before this
my lord,
court is-
may I request, my lord, my memo of calculation may be kindly taken into consideration. As per their own memo of calculation, only I calculated the interest. Please see, my lord, my reply statement filed to their memo of calculation. 3,25,35,000, my lord, there is no dispute up to 7, serial number 7. I calculated the
Look
interest.
at the interest component first.
Please, my lords.
Solve that problem, then
Please.
I don't know, looking at Krishna's argument, I don't think they'll agree.
We have, my lord, 1/7 they have received the.
Somebody has to pay them compensation.
They retain the amount, my lord, themselves instead of paying, but we have, whatever they have called upon, we have deposited immediately, my lord, with the check, they have acknowledged also.
It will be a substantial sum.
Well, see, my learned friend as petitioner has filed the compensation, I mean, the interest, which works out to a substantial amount, my lord, 5 crore 67 lakhs would be the thing itself, because he has calculated correctly, because 1/7/2010 in the illi tanka 2024 for 13 years and 18 months, at the rate of 15% would be a huge amount.
And by not issuing a notice of the award,
Yes, my lords.
you're
May-
also giving them a chance to seek for reference.
Please, my lords. My lords may have it on 16th, my lords. By then, I will personally go through the records to indicate, I'm not sure whether he is aware of the fact that 12 to calculate
No,
was mandatory.
he did his judicial duty, so he is happy now.
I'll
He
come
thinks
back
he's
on
done a
16th.
great
my lords.
favor.
Similar facts and circumstances, my lord, the 13 years delay, what the Supreme Court says, they are liable to pay the penalty also. Present case, my lord, 13 years and that Supreme Court judgment also 13 years, 6 months. Because of
16th.
the
16.
16th, my lords, please. Oblige.
Find a solution or else.
Yes, my lords.
ಚಿನ್ನಪ್ಪವ್ರು ಕರ್ಬಂದ್ ಒಂದು ಅಫಿಡೇವಿಟ್ ಹಾಕ್ಸಿ.
ಇಲ್ಲ, they are the
ಚಿನ್ನಪ್ಪನ್ಗೂ ಹಾಕಿದಿರಾ?
My lords may allow those applications, let them come on record at least, my lords.
The applications filed by impleading is allowed since the applicants there
ಚಿನ್ನಪ್ಪನು
also
ಹಾಕಿದ್ದಾರೆ ಸರ್.
held to be entitled to a share in the compensation amount. Cost held to be amended.
Oblige.
No reference has been made
Lords,
of the same notification.
not sure, my lords.
ಇಲ್ಲ, BMRC ಅಲ್ಲಿ ಯಾರು ಹೋಗುದಿಲ್ಲ, ಯಾರು ಹೋಗಿಲ್ಲ, ನಾವು ಹೋಗೋದಿಲ್ಲ. ನಮ್ಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಎಷ್ಟಿದೆ, 5 ಕೋಟಿ ಚಿಲ್ಲರೆ ಕಟ್ಬೇಕು, ಕಟ್ಬಿಡ್ಲಿ.
I'll verify.
We are going to
Get
share
some
my
instructions.
brothers and myself.
ನೀವೇನು ಅಲ್ಟಿಮೇಟ್ಲಿ ಕಾಸು ಕೊಟ್ಟು ನಿಮ್ಗೆ ಗೊತ್ತಾಗಬೇಕು ತಾನೆ.
ನಾವು ಡೆಪಾಸಿಟ್ ಮಾಡಿ ನಮ್ಗೆ ಇನ್ನು ಯಾವ್ದು ನೋಟಿಸ್ ಇಷ್ಟ ನಮ್ಮ ನಾಲೆಜ್ಗೆ ಬಂದಿಲ್ಲ ರೆಫರೆನ್ಸ್.
All that is consent award in the other cases.
ಗೊತ್ತಿಲ್ಲ.
ಇಲ್ಲ ಇಲ್ಲ ಇದು
ಕಮಿಟಿ ಏನೈತಲ್ಲ, ಕಮಿಟಿ ಅವ್ರ ಮೇಲೆ ಕಾಸು ಕೊಟ್ಟಿಲ್ವಾ ನೀವು? ಹೆಂಗೆ? How is the amount paid?
My lord, first-
ಇದು ಕಮಿಟಿ ಅಲ್ಲ, ಇಲ್ಲಿ ದ ಗವರ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಡಿಸೈಡೆಡ್ ದಿ ಕಾಂಪನ್ಸೇಷನ್ ಅಮೌಂಟ್ ಮೈ ಲಾರ್ಡ್. ಇದು ಯಾಕಂದ್ರೆ ದಿಸ್ ಇಸ್ ಓನ್ಲಿ ದಿ acquired through the government land acquisition.
Up
They
to
have
2012, my lord, under land
50 acres of land which were required. That amount calculated and they have called upon to deposit. We immediately deposit that amount with the acquiring authority. That
Verify whether there is any
some of
28
the properties belongs to the NGF, my lord. Therefore, they totally they have.
up to 2012, my lord, by the government acquisition, after 2012 onwards by the KIDB. Now the committee constituted 2012 onwards, my lord. Nobody has, my lord, gone to the reference, everybody has consented for acquisition.
ನೀವು
because
ಕೊಟ್ಟರೆ
good
ಸಮಾಧಾನ ಇದೆಯಾ? There is no dispute about the entitlement.
Our 1/3 ಕೂಡ ನಮ್ದೇ.
Oblige.
My suit mandate injunction came to be decreed. And the respondent was directed to, my lord, regularize the site bearing number, my site under section 38C. My lord, even in spite of my lord, civil code decree, my lord,
Copious for respondents.
representation to consider my,
My lord, I am appearing. My
There
lord,
is-
they are seeking for the Mandamus to consider their representation.
ಮಾಡ್ತೀರಾ?
Like it is not considered of the annexure, my lord, the page 54.
two representations are there. Page number 44, 47, two representations. Well, there is civic code decree in my favor. There is direction, my lord, by way of mandatory injunction, they were my lord, required to consider my representation. Appeal preferred by them also came to be dismissed for non-prosecution. There is a continuous absent on their part.
Then what?
I'm only
Consider their representation, my lord.
ಇಲ್ಲ, there is a decree of the trial court, page 39.
I'm informed, my lord, that the RFA, my lord, it was dismissed for default. Now it was entrusted to the panel advocate to file the necessary application to default.
It came to be dismissed on 10/4/2023, my lord. Thereafter, my lord,
Here, my lord, was not informed the PDA, now they came to know, and now I was informed that they have entrusted the matter to one of the panel advocate to file the
after,
application to.
after dismissal of the RFA, I have submitted two representations.
No, they will give you a reply saying that they made an application for recalling.
No
Therefore,
replies.
ಅಲ್ಲ ಅವ್ರು ಕೊಡ್ತಾರೆ ಇವಾಗ.
But
ಅವಾಗ ಏನ್ ಮಾಡ್ತೀರಾ?
I verified the status also, my lord. Even in spite of filing this writ petition, they have not taken any steps to, my lord, recall the recalling application. No recall application is filed.
PDA came to, they have entrusted to one of the panel advocate.
Till today, no application is
What do you
filed.
want me to do now?
For the consideration, my lord, the, wait for this was.
My lord, petitioner is aged about 82 years, my lord.
I am 100% sure they'll give you an endorsement saying that they're making an application for recalling. Therefore, your application will be considered after the disposal of the IA.
Kindly see.
Your
page
application
13.
ಹಾಕಿದ್ರೆ ಹಾಕಿಲ್ವೋ?
Till today, no application is filed, man. I verified through very website.
No,
Well,
to be
kindly
clear
the-
in this writ petition is to direct the respondent BDA to consider the representations dated 17/5/2023 and 10/8/2023, by which the petitioner is seeking for a direction to the respondent to reconvey site bearing number 19, or in the alternative, grant an alternate site as decreed in his favor in OS number 3694/2002. It is also stated that this suit was challenged by filing an appeal in RFA number 1307/2016, and the same was dismissed for non-prosecution on 10/4/2023. And thereafter, applications have been made asking the BDA to comply with the decree of the trial court. In view of the above, it would be appropriate to direct the respondents to consider the representations made by the petitioners for complying with the judgment and decree passed in OS 3694/2002 and as confirmed in RFA 13707/2016 within a period of 2 months from the date of receipt of a copy of this order.
My lord, even in the DNP order, my lord, there is a clear, my lord, observe, my lord, there is a lot of absence on the.
2 months.
Tomorrow. Kindly pass over. Tomorrow it will be. Tomorrow.
Pass over.
Madhyan, please.
No, I appear for the petition in this case. My lord, food for partition, my lord, the property in question, the house property which could not be divided in FDP, it was put to action. My lord, actioning, my lord, the reserve price has not been prescribed as required in section 6 of the Partition Act.
What are you challenging now?
The confirmation of the sale in favor of the action purchaser.
Order passed, IA number 7.
Yes, ma'am.
Where is that order?
And if page, it starts from page 17.
You are the auction purchaser. Huh?
My lord, earlier, my lord, RFA was filed. There was an interim order. Since the RFA.
You are auction purchaser?
No, my I am the family member, my lord.
Where is the decree? Where is the decree that is passed?
My lord, decree has not been filed, my lord. I have filed an order made an application for confirmation of the sale in favor of the action purchaser. It's at page 17.
Who filed the suit and what was the decree for?
The mother and the sister of the petition filed a suit for partition.
Varadamma and Sundramma.
Yes, my lord.
They had
Against
filed the suit for partition.
partition against the petition hearing.
That
Since
is
this
the
is a house
brothers.
property, my lord.
Both of them are brothers.
No, brother and sister, brother and sisters.
Alla, Ibru sister,
Obru
mother and
sisteru,
sister,
Obru sister, Ibru brothers.
mother and sister filed a suit against 2 brothers.
Yes, ma'am.
The suit was decreed.
Decree.
Appeal.
1/4 share. Appeal in Haklila. Appeal
1/4
Haklila.
share.
Then in FDP was filed. Since the property in question cannot be divided in meets and bounds. A court
What is the
commission,
property?
house property, my lord.
30/17.
Yes, ma'am.
Hmm.
Now mother is no more.
So 1/3.
1/3 ಆಗ್ತದೆ ಇವಾಗ.
Will ಏನಿಲ್ವಾ?
Pardon me?
Will ಏನಿಲ್ಲ.
Will ಏನಿಲ್ಲ.
So each of them at 1/3.
1/3.
FDP was filed by the mother, by the daughter.
Yes, my lord. Vardhamma
Was
and the daughter.
Auction was ordered amongst the 3 children.
ಅಲ್ಲಲ್ಲ ಪಬ್ಲಿಕ್ ಆಕ್ಷನ್ ಮಾಡಿದ್ರು. ಪಬ್ಲಿಕ್ ಆಕ್ಷನ್ ಮಾಡುವಾಗ then reserve price should have been fixed as per section 6 of the Partition Act. Reserve price has not been fixed. And the property in question was sold for a sum of rupees 25 lakhs. So then, my lord, the action purchase made an application for confirmation of the sale. It has been confirmed. That order has been called in question. Since action is in contravention of section 6 of the Partition Act. Reserve fund was not fixed at all. Section 6.
When
my
the,
lord, my
when was the property ordered to be sold in public auction?
On.
We did not
20
raise objections then.
Pardon, my lord?
We did not raise objections when the,
When the sale notification was issued, my lord, there was no objection. But after the sale, my lord, the objection has been filed. Page 19, my lord, Rashma Kendisi,
he
page
has
19.
deposited the entire amount. Who's in possession?
I'm in possession.
You had made an application for purchase.
I made an application.
That
my
was
lord, to
rejected.
purchase, my lord, but it was rejected.
What was your offer?
Whatever the action purchase yesterday, it was taken on an application was filed, it came to be rejected.
And you did not challenge that.
No, it was not challenged.
Offer was not made in the application.
It was not challenged. But still, my lord, section 6, Rashmi Kendisi, section 6, my lord, it is mandatory. There's a judgment of the Honorable Supreme Court. It is mandatory.
So now you want to continue in possession, that's all.
ಅದಕ್ಕೇನೊಂದು after retain the property, my lord.
ಇಲ್ಲ ಬಟ್ ಕಾಸು ಕೊಡ್ಬೇಕಲ್ಲ ರಿಟೈನ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಅಂದ್ರೆ ಅವ್ರಿಗಿಂತ ಜಾಸ್ತಿ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ
ರಿಯಾಕ್ಷನ್ ಆಗ್ಬೇಕಾಗ್ತದೆ ಸಿನ್ಸ್
ನೀವು ಡೆಪಾಸಿಟ್ ಮಾಡ್ರೆ
ಆನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ದಿ
ಡೆಪಾಸಿಟ್ ಮಾಡಿ ನೀವು ನಿಮ್ ಪ್ರಕಾರ ರಿಸರ್ವ್ ಪ್ರೈಸ್ ಎಷ್ಟು?
that the court, my lord, has to fix that.
You tell me, you are the one who's staying there, you should know. It has gone for 25 lakhs now.
It has gone for 25 lakhs.
What according to
Even
you was-
earlier, my lord, an action has taken place, it was 25 lakh, 26 lakhs, it was action, but it was cancelled since the purchaser did not deposit.
So what according to you should have been the reserve price?
Sir, price, my lord, no attempt was such was made.
Then you don't know. You're only unnecessarily protecting the proceedings.
But my lord, section 6 is mandatory, my lord. It should have been, we do not know the public how they would have bid that amount, section 6, my lord. Every sale under section 2 shall be subject to a reserved bidding, and the amount of such bidding shall be fixed by the court in such manner as it may think fit and may be varied from time to time. On such sale, any of the shareholders shall be at liberty to bid at the sale on such terms as to non-payment of deposit or as to setting off or accounting for the purchase money or any part thereof instead of paying the same as the court may seem reasonable. If two or more persons of whom one is shareholder in the property, respectively, they advance the same at any bidding at such sale, such bidding shall be deemed to be the bidding of the shareholders. This one judgment of the Supreme Court, my lord, just to pass on 2010.
No, kindly read section 2. Section 6 comes into operation only in respect of a sale under section 2 amongst the sharers alva.
Power to court to order sale instead of division in partition. Whenever in any suit for partition which, if instituted prior to the commencement of this act, a decree for partition might have been made, it appears to the court that
by reason of the nature of the property to which the suit relates, or of the number of shareholders therein, or of any other special circumstances, a division of the property cannot reasonably or conveniently be made, and that a sale of property and distribution of the proceeds would be more beneficial for all the shareholders. The court may, if it thinks fit, on the request of any of such shareholders, interested individually or collectively, to the extent of one moiety or upwards, direct a sale of the property and a distribution of the proceeds.
Then section
Need
3.
not be from among the shareholders.
Section 3.
3 may not, procedure on shares undertakes to buy. If in case in which the court is requested under the last foregoing section to direct a sale, any other shareholder applies for leave to buy at a valuation the share or shares of the party or parties asking for a sale, the court shall order valuation of the share or shares in such manner as it may think fit, and offer to sell the same to such shareholder at the price so ascertained, and may give all necessary and proper direction in that behalf. If two or more shareholders severally apply for leave to buy as provided in subsection 1, the court shall order a share of the share or shares to the shareholder who offers to pay the highest price above the valuation made by the court. If no such shareholder is willing to buy such share or shares at the price so ascertained, the applicant or applicants shall liable to pay all costs or of incident to the application.
So you made that application, it was rejected.
It was rejected.
Then
No, here, my lord, whatever, once, my lord, the section 6 mandates, my lord, the reserve fund has to be fixed. That is the judgment, my lord, just I have passed on, my lord, what can we say? It is mandatory provision.
which paragraph?
Paragraph. Pay, 87, my lord, paragraph 87. This brings us to the question as to whether the provision section 6(1) of the Partition Act.
Paragraph.
Paragraph 87. Then page 103. Paragraph 103, 87 and paragraph 103.
Why do you say that there was no valuation fixed?
It is not forthcoming from the action notice.
Where is the auction notice? Where is the order directing auction to be conducted?
The direction, my lord,
Do you have a copy of that order?
pardon?
Was the reserve price fixed?
The reserve price was not fixed.
Then
The valuation, the sub-registrar valuation was submitted before the court.
by whom?
By the parties, not. Your lordship may kindly look into order 21 rule 66, which says reserve price is not mandatory to be fixed in lots.
No, but section 6 says,
Partition Act is not applicable in this case, lordship,
Why?
for one simple reason. Section 2 says those where in any suit for partition which if instituted prior to commencement of this act, a decree or partition might have been made. So, lots, one is where a suit has been instituted prior to commencement of this act, then my lords, they can take the shelter under section.
They don't be applicable to suits filed after the act.
Yes. That is what the provision reads. That is one, my lords. Second thing, my lords, they have filed an application under section 2 and 3 of the Partition Act before the court. That came to be rejected. Lord, that has arrived finality because they have not challenged that before the court. Now, third thing, lords, if there is any irregularity that they are pointing out, they had a remedy before the execution court under order 21 Rule 90 to go and file an application asking for set aside.
No, the property was sold in execution or by virtue of an order of the court in this FTP.
FTP proceedings, my lords, by virtue of the
Then
order.
where is the question of execution?
In the, before the FTP court, my lords. They had a provision under 21 Rule 97 to seeking for setting aside the sale which took place, my lords, which they did not exercise. Now they have filed before the revision petition, they have come before.
Where is the auction proceedings?
There. Page 31. The page before.
Just Mahajar Alila and Hakila. It is not there. Well, just, it is not the, it is not in the paper book. Ali. Ali. Page 87 in that. Paper.
Property is 30 feet by 17.5 feet. Next for the 25 lakhs is a.
ಅಲ್ಲ ಇವಾಗ ಇಬ್ಬರೇ ಇರೋದ್ರಿಂದ it can be divided between the brothers.
ಆಗಲ್ವಲ್ಲ, no, that is beyond that stage. 400 ಡಿಗ್ರಿ 200 ಅಡಿ ಮಾಡ್ತೇನೆ.
ಇಲ್ಲ ಇದು ಈಗ it can be divided.
30 by 17.
Sister is also there.
ಅದ್ರಲ್ಲಿ ಏನು 150 ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಮಾಡ್ತೀರಾ?
ಈಗ ಫ್ರೆಶ್ ಆಕ್ಷನ್ ಆದ್ರೆ ಏನಾದ್ರು 30 to 17.5 ಇರೋದು.
So roughly
15 into 17.5 ಡಿವೈಡ್ ಆಗುತ್ತೆ.
ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಆಗುತ್ತೆ ಅಂದಾಜು.
ಹೌದು.
500 3 ಭಾಗ ಅಂತ ಅಂದ್ರೆ.
ಅಲ್ಲ, but daughter is now is ready to give up her interest over this property. Daughter.
ನೀವ್ ಯಾರಿಗೆ?
One of the brothers.
Where is the daughter?
Daughter is respondent number. Second respondent. Sundrama. Now she gives up her right over this property in favor of the.
Who will pay him the interest then?
ಅದೇನೆ I am ready to pay.
ಕೊಡ್ತೀರಾ 25 lakhs with 15% interest ಕೊಡೋವರೆಗೆ ವಾಪಸ್ ಕೊಟ್ಬಿಟ್ಟು ನಿಮ್ಗೆ ತಗೊಳಕ್ ಹೇಳ್ತೀನಿ. Why should he suffer? He's been there for how many years now? And you've enjoyed possession.
2015 ಇಂದ ಇದ್ದೀವಿ.
15% interest ಕೊಡಿ, I'll ask him to accept that you can keep the property. ಅವ್ರಿಗೂ ಒಂದು ಅನ್ಯಾಯ ಬರ್ತಾನೆ.
ಒಂದು 5 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಡ್ಲಿಕ್ಕೆ ರೆಡಿ ಇದ್ದೀವಿ.
5 ಲಕ್ಷ ಬೇಡ, 15%
ಅಮೌಂಟ್ ಡಿಪಾಸಿಟ್ ಅಲ್ಲೇ ಇದೆ, ಡಿಪಾಸಿಟ್ ಅಲ್ಲಿ ಇದೆ.
ಅವ್ರ ಕೈಲಂತ ಇಲ್ವಲ್ಲ ಕಾಸು.
ಅದಕ್ಕೋಸ್ಕರ ಒಂದು 5 lakhs
15% interest ಕೊಡಿ, I will ask him to withdraw his claim. Or else I'll dismiss the revision. ತಗೊಳ್ಳಿ ಅವರು.
they are very poor people. 15% ತುಂಬಾ ಜಾಸ್ತಿ.
ಬಿಟ್ಬಿಡಿ ಸುಮ್ಮನೆ ಹಂಗಾರೆ, ಅವ್ರಿಗೆ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಕೊಡಕ್ ಹೇಳ್ತೀನಿ, ನೀವೇ ಕಾಸು ಇಸ್ಕೊಂಬಿಡಿ.
Next week.
That has to come to an end one way or the other, isn't it?
ಅಲ್ಲ, ಇದೊಂದೇ
ನೀವು ಆರಾಮಾಗಿ
ಪ್ರಾಪರ್ಟಿ ಇರೋದು.
ಅಲ್ಲ, ಅದಕ್ಕೆ ನೀವು ಇಟ್ಕೊಳ್ಳಿ. It's your
shelter ಇಲ್ಲ ಅವರಿಗೆ.
You keep the property, but don't prejudice him.
But 15%.
ಅವ್ರು 25 lakhs ಅವ್ರು ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ ಬರ್ತಿತ್ತಾನೆ ಕಾಸು, ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಹಾಕ್ಬೋದಿತ್ತಾನೆ.
Is one of the matters which has to be taken to consideration, but
15% ಕೊಡಿ, I'll ask him to withdraw.
ಅಷ್ಟು ಇಂಟ್ರೆಸ್ಟ್ ಸ್ವಲ್ಪ ಅಷ್ಟು ಕೊಡ್ಲಿಕ್ಕೆ ಶಕ್ತಿ ಇಲ್ಲ ಅವ್ರಿಗೆ.
ಅಂದ್ರೆ ಮನೆ ಬಿಟ್ಕೊಡ್ಬೇಕು ಅಷ್ಟೇ. ಇಲ್ಲಿ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ನಿಮ್ಗೆ ಕೊಡಕ್ ಹೇಳ್ತೀನಿ, ನೀವೇ ತಗೊಂಡ್ ಬಿಟ್ಕೊಡಿ. ನಿಮ್ ಚಾಯ್ಸ್, ಎರಡೂ ಆಗಲ್ವಲ್ಲ ನಿಮ್ಗೆ.
ಮಂಡೇ ಮೇಲೆ ಪ್ರೈಸ್ ಖರ್ಚು ಮಾತಾಡಿ.
Monday. 15% or ask him to pay. How much are you willing to pay extra? Find out what is the amount that you can pay extra.
Maybe, say 15% I can add and pay.
ತಗೊಳ್ಳಿ 15% ಸೇರಿಸ್ಕೊಡ್ತಾರಂತೆ. You can't get a better deal than this.
ಮಂಡೇ ನಾನು ಯೋಚನೆ ಮಾಡಿ.
Monday.
One CRP has not been listed, madam. CRP 306 ಬಂದಿದೆ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಆಗಿದೆ. CRP 306 of 2022. It was also connected.
Whatever numbers you've given is connected.
There is one more CRP, but that was also given. CRP 306 of 2022. 306 about 2022.
It is not connected to the lot.
But-
Individual apartments, they are able to pay the maintenance charges. There is a Krishna connectivity. All are individual apartment owners.
What is the matter about?
I'll submit. What has happened is this, before I make my submissions, my learned friend, in all these 4 cases, 4 or 5 cases, has filed lot of documents with detailed objections. In a CRP, ultimately we have to justify the judgment either in this way, right or wrong. But anyway, he has produced so many documents. So in that background, I am filing a memo with few documents so that if at all, if it becomes necessary to look into those documents.
Suit
Lordship
for
may look
recovery.
into
na?
these documents also.
Plaintiff is the owners association.
What has happened is this, Milord. The association, the plaintiff is an apartment owners association formed as per the provisions of the Karnataka Apartment Ownership Act. Admittedly, Milord, the building, this is Ahuja Palace. This is an apartment complex consisting of about 24 apartments and 4 office spaces in the basement floor. Milord, this sanction was granted as per the earlier, Milord, the first sanction plan was granted in 1991. As on date, Milord, the 1983 building bylaws were in force. As per that building bylaws, Milord, the basement floor also can be utilized for the purpose of establishing, in addition to car parking, air-conditioned office spaces for commercial purpose. That was granted. Subsequently, occupancy certificate also was issued. Milord, that has been used for quite a long time. Now, what happened is this, Milord, when the association had to be formed, Milord, if it is a case of a residential apartments, Milord, the Karnataka Apartment Ownership Act would come squarely into play. Milord, kindly, I may be permitted to pass on to your lordship the provisions of this Karnataka Apartment Ownership Act. Admittedly, here is a case where the petitioners in all these cases, they are not the members of this association. They are not the members of the association, no doubt. They are owning the apartments in the apartment.
ಒಟ್ಟು ಎಷ್ಟು ಜನ ಇದ್ದೀರಾ ನೀವು?
Yes, Milord.
ಎಷ್ಟು ಜನ ಇದ್ದೀರಾ ಒಟ್ಟು?
What to case, now there are about 5 cases, Milord. One case has not been listed before this court.
Total 18 apartments.
Totally 24 apartments.
24.
ಅದರಲ್ಲಿ ಏನಾಗಿದೆ?
5 are objecting.
Not 5 or only 17 of the people, they formed the association. Remaining people, owners of the other remaining apartments and the office spaces, they did not join in the execution of the deed of declaration under the provisions of the Karnataka Apartment Ownership. Mainly the dispute for forming the association was as to whether an association could be formed under the provisions of the Karnataka Apartment Ownership Act or under the Flats Act. There is another enactment, as your lordships are aware, of 1972. One of the objections that was raised by these people, in fact, not that they don't want to have an association at all. They said, because it also contains 4 commercial office spaces in the basement floor. Under the provisions of this Karnataka Apartment Ownership Act, Section 2, Milord, kindly, I will just draw your lordship's attention to that particular provision. Section 2 categorically says that, Milord, this is what it says. Application of Act. The act applies only to the property, the sole owner or all of the owners of which submit the same to the provisions of this act by duly executing and registering a deed declaration as hereinafter provided. So here is a case where for the application of the act, either the sole owner should give a deed of declaration or all the owners should give a deed of declaration. Here is a case, admittedly, all the owners of all the apartments have not signed the deed of declaration. So in that background, what is happening is a civil suit is also pending, filed by the persons who are not the members of this particular association, who have not joined in this, for a declaration that the very association is.
This act is only for the purpose of making it heritable and transferable.
Yes, Miller.
This act, Apartment Ownership Act,
Yes,
is
Miller.
only for the purpose of making the apartment ownership, heritable and transferable.
Transferable, and also what
Is
it
the act
also
which
says
governs
is,
the management.
Miller, what it also says is this, Miller. This apartment owners association, Miller, is to be formed as per the provisions of this act for the in a scenario where the property is exclusively used for residential purpose. Here there are admittedly commercial spaces are there. So what we suggested, we will have an association as per the Flats Act, because the definition of the word flat includes both a residential and non-residential unit. They did not agree. Even thereafter, Miller, we also agreed an association under the apartment ownership also can be formed, provided they take into account these commercial spaces also. Even though, Miller, these commercial spaces are part of the sanction plan and occupant certificate has been issued from time immemorial, Miller, they are disputing the very existence of their dispute. They don't want to give validity to that. So that is the major area of dispute between these people. Now, what has happened is in some of the, out of these 5 cases, Miller, in 3 cases, Miller, what has happened is there was no proper opportunity. Miller, in 2 of the cases, Miller, in one case, but the defendant was in USA. And by the time she came, they could appear through power of attorney holder and file the application for written statement and all that. Subsequently, opportunity to cross-examine was not given. So no sufficient opportunity was given to lead evidence. In another case, the lady is was living in Arunachal Pradesh. All these proceedings have taken place at a time when COVID was in force. This lady was in Arunachal Pradesh. By the time she came here, she could engage an advocate and file objections. No opportunity was given there also sufficiently. The matter was just hurriedly decided during that particular period.
Hurriedly decided.
Yes, Miller.
2020 suit, 23 decided.
So what has happened is this. There was no notice of summons at all and not. That's what I'm submitting. Kindly see in 390, I will just come to.
I'm having CRP 56.
Yes, Miller.
I'm having CRP 56 by 2024.
56. 56, the dispute is not relating to this one, Miller.
What is it?
Opportunity was given, but there was no proper consideration of the materials on record.
In consideration,
Your Lordship may kindly see, we have also laid evidence. Several documents have been produced before the court. And what is considered in 58 and 56 is only the evidence of the plaintiff. Defendant's evidence is just brushed aside.
The suit claim was for the payment of
Maintenance charges.
So what is your only argument is that it's not for.
Our contention is we are not the members of the association, number 1. Number 2.
So who's to pay the maintenance charges? You don't maintain the apartment.
No, we
You
have
don't
formed a
recognize
separate, that's what I'm saying. We have formed a separate association. under
Comprising
the
of how
Flats
many
Act.
members? Comprising of how many members?
The remaining people, out of 17 also, some of them have resigned. Among the 17 people who have formed the association under the Apartment Ownership Act, some of them have resigned. Now, apart from all these facts,
Just ನಿಮ್ಮ rival association flats.
I think rival association about 7 apartments and another 4 office spaces, 11 people. Apart from other people who have resigned. My other submission is this, Mr. Ultimately, here is a case where it's a small cause suit for recovery of money. In these 2 cases, 56 and 58, he has gone to the extent of giving a finding that this association is validly formed under the Apartment Ownership Act. Whereas, admittedly, there are 2 suits, rather 3 suits which are pending in the competent civil court, which are pending consideration. When I have filed this, these people who are not parties to the association, that is the plaintiff.
ತಿಂಗಳ ಎಷ್ಟು maintenance charges?
ಯಾವುದಕ್ಕೆ?
ತಿಂಗಳ ಎಷ್ಟು ಕೊಡಬೇಕು maintenance charges?
It depends upon their demand.
ಇಲ್ಲ, what is the rate fix per square feet ಅನ್ನ ಮಾಡಿರ್ತಾರೆ?
ಅವ್ರು ಹೇಗ್ ಮಾಡಿದಾರೋ ಗೊತ್ತಾಗ, they have filed a suit for recovery of the money and we have deposited the money.
That you have fixed? What is the charge that you have fixed as maintenance charges?
Per square feet. Here, the total expenses will be divided by the total number of units, proportionate to the super built-up area.
Proportionate to?
Super built-up area. See, law, section 10 of the Karnataka.
As of now, what is the due that they have to pay every month or every year?
Quarterly demand will be made.
What is the amount fixed?
In this suit, approximately it will come to 3 rupees per square feet, going with the facts on record, 3 rupees per square feet. Now, these people have not paid from 2019 January
till date, they have not paid a single rupee.
Now they have deposited the entire amount, isn't it?
Yes, they have deposited that.
So what is the future amount that they have to pay at rupees?
Separate suit has been filed. Up to date, whatever the dues are there, separate suit has been filed. It is pending for.
There's one more suit pending.
More suit. Continuation suit.
They have now filed another.
Lord, I would like to submit, my learned friend submitted, I may be permitted to.
No, what I was thinking was, whatever suit you file, let that be decided. You deposit the quarterly charges into court.
Yes, ma'am.
Subject to
Yes,
the
ma'am.
ultimate result of.
Yes, madam. That will do.
Fair enough. That would be fair.
That will do.
Instead of reviewing this order, which is for recovery, they have filed a suit for declaration. Let them proceed the suit for declaration. In fact, my lord.
We will deposit the money in the court,
Suit
madam.
number 4362 filed by this plaintiff association against the company which is interfering in the maintenance. Injunction order has been granted. Here the court has categorically stated this injunction order is subject to the outcome of the suit in OS number 203. Very fairly, the lower court has passed an order.
That is pending before the High Court, madam.
Lord, as a matter of fact, I want to submit before your lordship. Here, there are 24 apartments are in this complex. The building was sanctioned way back in 1991 for 18.
We'll go into the merits. There are five people.
Learned friend has submitted. I want to bring it to knowledge of the court.
Badabadi, 5 jana idare. You tell me the amount that they have to pay every quarterly. I will pass an order saying pending disposal of this revision. They will continue to deposit that money into
madam.
court.
That would be much fair enough.
Kodi, amount kodi.
Let them
What is
file a
the
memo,
amount?
madam.
Let the trial court pass an order and let them continue.
Mine is not like that, madam.
No, I'll pass an order here. Why do you want to go to the trial court? Give me the amount that each of them has to pay every
Let
quarter.
them also give a statement and the base of which the calculation is being made.
I can give you
Adu Maldi,
Yava
will
kodri.
deposit the money.
Tomorrow.
tomorrow morning.
Madam, it may be called next Monday. meeting.
ಏನ್ ಬರೀ ಮೆಮೊ ಕೊಡಕ್ತಾನೆ.
Tomorrow
I
morning-
memo called.
Tomorrow morning I'll submit.
Copy for the petition.
Respondent number 8 and 9.
So I appear for the respondent number 7. I undertake to file my wakalat in the registry. And for respondent number 7, I undertake to file my wakalat.
For R7.
R7.
Yes, Raghunath.
Raghunath. Yes, sir, Raghunath is the.
Yes, Raghunath undertakes to file wakalat for R7. Party has raised Raghunath, ನಿಮ್ಮ ಹೆಸರೇನು?
Chandan.
Sri Chandan undertakes to file
Chandan K.
wakalat for R7. In what is the matter about?
Sir, what has happened is, my lord, what is challenged is order of the civil court, by which, my lord, they say that there is no interest, inter se in respect of the property that is sought to be sold under this. In fact, let me clarify this.
You challenging an order passed under order 7 rule 11.
What is sought to be challenged is annexure A, page 34, where we wanted the claim to be rejected on 2 grounds. One is that suit is barred by limitation. Other one is that the power of attorney grant was coupled with interest.
Where is the plaint?
Pardon me?
Plaint.
Plaint is at annexure E, page 134 is a typed copy.
130?
134. They sought for partition. No, the suit is filed on 13/2/2008, challenging the, for a declaration.
How are they related, the plaintiffs and the first defendant?
Plaintiffs are the brothers and sisters.
How are they related to the first defendant?
First defendant is their brother. 1 to 4 plaintiffs are the sisters. And their father.
Father is B.T. Ramayana.
Yes, B.T. Ramaya.
So plaintiffs 1 to 4 and first defendant are the are siblings.
B.T. Ramaya and his son Tyagaraja, they entered into an agreement of sale, registered document on 12/2/1990 in respect of the scheduled property. Thereafter, on the same day, a registered special power of attorney also was granted in favor of the seventh
B.T. Ramaya executed agreement of sale in favor of?
In favor of Satish Pai and Satish Pai is R6.
D2.
Yeah, D2.
Sale deed is
Then
by
on the same day, a power of attorney was executed by these people in favor granting power to Raghunath, that D3,
sale deed is by D3
D3,
in favor of,
in D2.
and that is sought to be challenged.
That is sought to be challenged. Challenged, I declared that it is not binding upon me. That is, they file a suit on 13/2/2008, challenging the sale agreement, annexure B, executed by Ramaya and defendant number 1 in favor of defendant number 2. They don't challenge the DPA. Then others to
The
satisfy.
basis for the claim that the suit property is,
Juice property, joint family property, ನಮ್ಗೆಲ್ಲ share ಇದೆ. ನಮ್ಮ ತಂದೆ ಪ್ರಾಪರ್ಟಿ ಅಂತ. ತಂದೆ ಪ್ರಾಪರ್ಟಿ ನಮ್ಗೆಲ್ಲ share ಇದೆ. The suit is filed on 13/2/2008, challenging the sale agreement, registered sale agreement in 90 and sale deed 24/1/95. We say this Ramaya died on 20th March 1992. We say, but the power of attorney sustained, and we say it's coupled with interest, because the entire sale consideration had been paid along with at the time of sale agreement. No, after all these things happened, my lord, we came into the picture, my lord, Raj Trust and Raj Trust developed the property. This and all along with our 350 sites were made, layouts were made, and subsequently some sale deeds also are 800 plots have been sold. And we have also produced documents, sale deed, by which the developer sold it to individual owners. No, at this
no, but
juncture.
they don't admit the execution of the GPA. They don't admit the execution of the GPA.
Oh, GPA challenge ಮಾಡಲ್ಲ.
They don't admit the execution of the GPA.
GPA ಅಂತ challenge ಮಾಡಿಲ್ಲ, registered deed ಅದು challenge ಮಾಡಿಲ್ಲ ಅವರು.
But ನೀವು GPA ತಂದ್ರೆ whether it was agency coupled with interest.
ಹೌದು.
It's a matter for trial.
Yes.
How can I reject the plaint?
That is exact. No, what I say, just mere reading of these two documents would show that there is the.
But then I have to look at your defense. They say that this is a fraudulent GPA. They kindly
That
see
is
para
registered document.
There
And then we implemented ourselves in the plaint
If
because.
I accept your argument, that means I'm looking at your defense rather than the government's in the plaint. There are cases that the sale was executed after my father died.
Two important things for them. This 2008 suit, they challenge 1990 sale agreement. 1990 sale agreement, ಇಷ್ಟು ವರ್ಷ ಆದ ನಂತರ challenge
No, but on the death of
death of the father in 92.
the sale deeds are there 95.
90 sale agreement is 90.
Correct.
Then 95 is a sale deed.
On the
In the meantime, the property is converted to residential use.
B.T. Ramaya's death,
Yes.
they would have succeeded to his particular share.
No, 202 termination. 202.
If the GPA is admitted, straight away the plaint can be rejected. They don't admit the GPA. It is your defense that there's a GPA under which an agency coupled with interest has been created.
Please.
That is a matter for trial. As whether there was an agency created.
But on the first question, whether there is bar with limitation or moment, that is a matter on the face of it, the court has to consider it.
Other mixed question of law and fact at an limitation.
No, the fact is this, that there is a registered sale agreement on 22 to 1990.
By the registered agreement of sale, you get no right.
No. Yeah,
It's
but
only on the sale deed.
it's a public notice to say that everybody, there is a particular document and register ಆಗಿದೆ ಅಂತ. Then general power of attorney also is there.
No, but on
That is also on the same day, 12 to 1990.
On the death of the father, what is the effect on the registered agreement of sale?
202 will save it.
No, on the registered agreement of sale.
Yes.
If they admit the GPA, straight away the plaint can be rejected. They don't admit the GPA. It is your defense that there's a GPA.
No, we have not yet, we have just got ourselves implemented And immediately this application is made on two grounds. One is the coupled of interest on. Second is on the prima facie, there's a limitation.
The suit for partition can't be barred by limitation if the property continues to be joined.
No, it is not joint.
Notwithstanding-
According to his father, it is not father's property. We have a share and tantar, not joint family.
If the father executed registered agreement of sale,
Yes.
the father has not executed the sale deed.
Father,
It is your case that the father had executed a GPA
yes,
on the basis of
GPA and
which-
sale agreement.
on the basis
Then,
of which you have
then the
purchased.
son and by represented by the general power of attorney holder executed the sale deed on 24/1/95.
So you will have to establish the GPA and you will also have to establish the GPA was an agency coupled with the interest and that is irrevocable.
Just two or three, four
I have
portions.
to look at your documents then to reject the plaint.
Yes,
Can I do that? Under order 7 rule 11.
no, what I would submit is this. Brother. In the declaration, kindly see page, have a look at page 144, the prayers that are sought. At page 144. First one is directing first defendant paid.
What is their entitled to seek?
One fifth of the share so and so. By declare the sale agreement dated 13/2/90. Executed by late so and so in favor of, so not binding on the share. Agreement is admitted. Then thereafter declare sale date 24/1. In favor of, is not binding. So they don't challenge these.
They're
General power of
challenging-
attorney, registered special power of attorney. They are not challenged. Then order inquiry, main profits also. So
No, they are saying that the GPA is forged, concocted, created. If they establish that, then the entire sale goes.
prayer ilvalla adralli. Prayer illa illi.
11A node, 11A paragraph 11A, page 142. That's why I said if they have admitted the GPA, then absolutely 100% case for rejecting the plaint.
It is
They say it
submitted
is
the
further-
third respond execute a registered sale deed
On the basis of.
on the
forged,
basis, on the basis of
concocted and created
concocted
GPA.
general power of attorney.
So if they
Not-
establish this,
He said the GPA illegal. Prayer illa, how can
prayer
that be an
Bekila,
issue?
if they can establish that the GPA was forged, was concocted,
And said
the
was
sale deed is of no consequence.
created. No, then they say further.
If they.
Alleged sale deed so and so is created after the, how can I create a
No, no,
a
what
document
they're saying
after
is
his death?
The
That
sale
is
deed is
registered
executed
document.
after my father's death. On the basis of a forged GPA, a sale deed is created as their case. In para
Consent of the
11A.
by colluding second, said the.
Please read 11A once again. It is
It is
further submitted that the
the third defendant has executed registered sale deed 24/1/95 in favor of the second defendant on the basis of a forged, concocted and created general power of attorney without knowledge or consent of these plaintiffs by colluding the second and third respond each other illegal. The said alleged GPA was executed by first along with his father so and so, who is the father of plaintiff, and the BT Ramana, who is the father of these plaintiff, and the said Ramana died on 20th March 92. But the alleged sale deed was created after the death of Ramaya, and clearly show the third respondent have no right, title, interest to sole ownership over the schedule.
They are setting up the plea of fraudulent GPA.
Lord, my submission is, my Lord, that there is no prayer. Prayer will then there you can say
The
anything.
prayer is to challenge the sale deed on the ground that it is based on
No,
a fraudulent.
based on, but they should have been, there should have been a prayer for
I can't reject the plaint on a-
challenging the GPA. That is
Can't-
not
I
done. The
can't reject
registered
the-
document, it is not done.
I can't reject the plaint on an improper prayer. If the prayer is not proper, they won't get the relief. But how can they reject the plaint? You can only look at the plaint governments, nothing more than the plaint governments. I understand the blackmail litigation, no? I understand, but
So much water has flown under the water after this, 10, 15, 20 years, Adnantara, they challenge it. And then I have also put these documents to show how all these areas are affected, the 2 or 3 sale deeds have made, and it falls in the larger extent of from 800 sites are filed. Their sites
you
are
will-
divided.
you will succeed, there should be dismissed, but I can't reject the plaint on that ground. How can you reject the plaint on the basis of your defense?
Not registered document, madam, I have to only take your lordship to 2 or 3 averments made in the sale deed and then the.
No, I can't look at your document at all for me to reject the
It's a
plaintiff.
public registered document, my lord. It's a
Further, but
public document.
You give me
It's
one
a-
judgment which says I can look at the document of the defendants to reject the plaint, I'll accept it because I can
I'll-
reject a lot of plaints on that ground.
Okay, yes, I'll examine and my lord make a submission.
I don't think that is possible.
Yeah, and my lord, no, I have one or two cases are there which I will, my lord, I'll cite and then try to convince your lordships.
Realist.
Agbo.
I pay for the petition. Respondent number 8, my lord, we have not yet served the copy. Respondent number 8, my lord, we have not yet served the copy. We'll serve a copy, my lord, to respondent number 8 next week, my lord. Respondent number 8, we have not served copy to the respondent number 8, my lord. Respondent number 8, we have not served copy to the respondent number 8.
Number 8,
Respondent number 8
is he the plaintiff?
Respondent number 8 is my lord.
She's defendant number 7.
Defendant number 7.
Or in back, rejection of plaint tane.
Rejection of the
On what ground?
rejection, my lord.
Ready ilva?
Wait here. Next week.
List.
Yes. Much obliged.
Petitioner. An application under order 1206 was filed. Because the suit is filed for relief of declaration. To declare that I have to execute a reconveyance of the deed because the plaintiffs have executed a release deed in our favor. On the condition that, my lord, I have to pay 70 lakhs. 40 lakhs was already paid.
Plaint lane, what is the prayer in the plaint?
Prayer in the plaint, my lord, is to declare that that I will at where page 19, your lordship. 19 it starts.
You agree to pay this alternative prayer.
Alternative, my lord, that only to, I have to pay 30 lakhs rupees. I have also deposited. That the suit may be decreed that the application I have made. Because that they have not sought for relief of partition. I have to execute a cancellation deed of the release deed. The release deed condition is, my lord, is that I have to pay 70 lakhs. 40 lakhs is already received. 30 lakhs, my lord, which I have paid, the checks were dishonored.
Our objection ಹಾಕಿದ್ರೆ ಅದಕ್ಕೆ.
They have filed an objections.
Suit for partition ಕೇಳಿದ್ರು.
Illa, the suit for, it is suit for declaration, that there is no relief of partition at all. But the trial court has come to the conclusion that suit for partition.
ಅಲ್ಲ ಪ್ಯಾರಾ 9 ಅಲ್ಲಿ ಹಂಗೆ ಬರ್ತಿದಾರೆ. At page 15, counsel plaintiff has filed objection to the present application.
So that is the observation made by the trial court.
Issue notice. Then counsel is permitted to take out notice on the first respondent, or the respondents through their respective counsel.
They sought for a stay.
ಏನ್ ಅವಸರ ಏನ್ ಬಿಡಿ.
ಅಲ್ಲ, ಅದು ಅಲ್ಲಿ proceed ಆದ್ರೆ then it.
ಏನಾಗುತ್ತೆ ಏನೋ ಆಗಲ್ಲ.
Petitioner, my lord. See the challenging the dismissal of the application under order 7 rule 11. The first respondent filed the suit for partition and separate possession.
Where is the plaint?
Page number 22.
22.
My lord. Kindly see the relationship.
Suit for partition.
Suit for partition. The property was, scheduled property was originally purchased by the plaintiff's sister-in-law in the year 2005. And it was exchanged in 2012. Kindly see para number 5.
Sister-in-law.
Sister-in-law. She is the wife of the second defendant.
Give me the, who's the person purchased? Plaintiff.
The third defendant.
She purchased?
She purchased the property, scheduled property on, under registered sale deed dated 13/9/2005
From whom did she purchase?
from some other person. They are the not parties and it is not disputed.
Gauranga
Subs-
purchased suit property.
Subsequently, it was that property, scheduled property was exchanged with the fourth defendant
Date?
under register exchange deed 13/1/2012.
Gauranga and
In pursuance of this,
Kirana, na?
yes, man. Under the
Sale deed or exchange deed?
exchange deed.
Suit property was given to Veerappa.
Veerappa, and she got the another property, survey number 16/1.
Remember?
Survey number 16/1. That is not subject matter of this suit. And that property was also sold under the registered sale deed dated.
As a 16/1, na?
Adunu martara, marbitu again,
Yarge?
defend number 11 and 12.
Yavaga?
Under registered sale deed 15/9/2022.
This is admitted in the plaint?
Yes, my lord. Para number 5 and 6, they have admitted.
Then who is Shivraj?
Shivraj is the son of, brother of the Venkatesh and son of the first defendant.
Shivraj is the
Brother-in-law of the third defendant.
Gaurama is the wife of Venkatesh.
Yes, my lord.
Shivraj and Venkatesh are brothers.
Brothers. The first defendant, Anmaka, is the mother. And kindly see, my lord, in the
You are D4.
D8.
ನೀವು ಕೊಂಡ್ಕೊಂಡಿದ್ದೀರಾ ಇದನ್ನ?
After the D4 got the exchange, he sold the property in favor of defendant number 5, 6 and 7 by
6 and 7.
under 3 registered sale deed.
Date ಒಂದೇನಾ?
No, date, same date.
16/11/2018.
16/11/2018. And thereafter, the property original survey number 101/5.
Them you have purchased.
Under registered, my property also, I got the exchange deed in 9/4/2000, sir.
ಯಾರ ಕಡೆಯಿಂದ?
Defend number 5 and 6, 5 and 7.
5 to sub. Exchange, ಯಾವಾಗ?
In 18/10/2020.
And what property you gave them?
The property, other property is,
So you took the suit property, what property to give them?
Survey number 27/1B of Bandkodgelli, same village.
This is admitted in the plaint?
Yes.
This is our, if your lordship were to paint it, turn to ink page number 24, Miller, paint, para 4.
You are for the plaintiff.
I am for the plaintiff, para 4. That on several occasions, plaintiff has approached the defendant and demanded the defendants 1 to 3 to partition the joint family property and to allot his legitimate share in this right. But the defendants went on postponing the partition of the scheduled property at one or the other pretext. On 22/2023, defendant number 628 came near the scheduled property and tried to interfere with the possession of the scheduled property. With great difficulty, the plaintiff resisted the high-handed interference of defendant number 628. When the plaintiff questioned the illegal acts of the defendant 628, then the defendant 628 revealed that they have purchased the scheduled property. This is the date on which I specifically say that I came to know about it. And that thereafter the plaintiff made inquiry, to paraphrase, thereafter plaintiff made inquiry with regard to the documents pertaining to the scheduled property. And then he came to know that the third defendant exchanged the above suit land with the fourth defendant by taking 32 untas of land in survey number 16/1 of Gollalli village belonging to the fourth defendant through registered exchange deed dated 13/1/2012. The fourth defendant had sold the portion of scheduled property, that is 17 untas of land through registered sale deed dated 16/11/2018 in favor of defendant 5, 17 untas in favor of defendant number 6, 17
No,
untas.
he
in favor
told
of
me
defendant-
that Gaurama had exchanged this property with Veerana.
Yes.
Veerana purchased this suit property.
Please,
Veerana in turn sold it to D5, D6 and D7.
please, sir.
Then where is this question of you claiming a share here? Now Gaurama got some property in exchange. You can
Yes.
go after that property if you want.
That property was also sold.
No, whatever Gaurama,
2022.
Gaurama gave this property, suit property to Veerana.
Veeran.
In turn, she got 26 bar,
Kindly appreciate.
no, in turn, she got 16/1.
So 16/1 was.
16/1 was sold to D11 and D12.
Yes.
You can go against that, but how can you go against a property that was given to Veerana?
No, that was done without behind our back.
No,
You
but-
watch by kindly see, survey number 101/5 was measuring totally 1 acre 11 guntas. As against this property, she exchanged it for 32 guntas.
Whatever it is, she has exchanged it.
That was
No.
without our knowledge.
Yeah, which,
It's a matter of trial, madam.
ಹೆಂಗ್ ನೀವ್ ಈ ಪ್ರಾಪರ್ಟಿ Veerana got this property.
Yes.
An exchange deed.
That is what they
Now
claim.
you are giving up the property that she got in under the exchange deed. You are not making any claim over that property.
No, in fact, suit scheduled property is survey number 101/5 only.
That was what was given to Veerana.
Please, ma'am.
Yes, yes.
That was what was given to Veerana.
No, that was not,
Veerana-
it was exchange.
So Veerana gave some property to Gaurama. That you are not challenging.
That I am not challenging.
You should, isn't it? Now Gaurama has some property in lieu of the property that the family had.
Larger extent of property and
ಇವಾಗ ಏನಾಗುತ್ತೆ, now Gaurama keeps the property that she got in exchange and they're challenging the property that is given in exchange. You'll have to choose one of the two.
My,
I'll inquire my client.
ಹೆಂಗಾಗತ್ತೆ?
my lord,
ಗೌರಮ್ಮನ ಆಸ್ತಿ
I
ಉಳ್ಕೊಳ್ಳುತ್ತೆ.
understand what is running in.
My lord. My lord,
ನೀವು ಬರೀ ಇದು ಹರಾಸ್ಮೆಂಟ್ ಅಷ್ಟೇ ಅವನ ಹತ್ರ.
my lord,
Whether we are restricting it to.
No,
this
no,
land or the-
kindly see.
You can go against Gaurama's property D3 purchase 16/1 which she has sold to D11 and D12. But you can't claim this property that is 101/11.
Fine.
My
I'll
lord,
find out.
my lord, my lord, my lord, kindly see the para number 6 and also page number 135, my lord, because they have suppressed the fact. In such circumstances, court can look the documents, suppression of the facts. On that point, I would like
I'll
to
reject
rely
the
the
plaint
judgment.
Unless you withdraw this to be able to file a fresh suit.
Whether I am restricting it in respect of this.
ಅಲ್ಲ, ಆ ಪ್ರಾಪರ್ಟಿ ಇಲ್ವೇ ಇಲ್ವಲ್ಲ ಇದ್ರಲ್ಲಿ.
ಅದಕ್ಕೆ I will make my submission on that.
Alla, our release date, kindly see.
Withdraw the suit to file a fresh suit as against or give up this and include that whatever you wanted you do. But you can't have both. You can't have Gaurama's property and also the exchange property.
I understand what is running in.
Realist.
Matter is Kempegowda layout matter covered.
Covered. She stated that the matter has been interested to Shri C.V. Kiran, office to print his name and released on. The name of Lakshmi Rao and M.B. Prabhakar be deleted.
Petition.
But the last occasion directed me to produce some documents. DC proceedings ಆಗಿರೋದು, then.
Where is the meeting 10/8/2011? ಅದಾಕಿದ್ರ?
Page number 3. Of proceedings, PC and Gail, page number 40, R4, 1 lakh and is public government our
Yes, what is the matter about? Huh?
Announcement. Announcement. 1 lakh ಇದು ಮಾಡಿ ಮತ್ತೆ ಅದ್ರ 5 time ಇದು ಮಾಡಿ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿದ್ರು.
Okay, 1 lakh is to value and then page number 43, madam. Photo Siddhavana Handi. Out 1 lakh is to 43, page number is Anixra R4, 4 43 LP. Bottom in the second Lotus Siddhavana Handi. 1 lakh is out. About 20 lakh in the clean matter. To that effect, there is no document has been produced.
The judge has gone by this proceedings, 10/8/2011.
How?
After tomorrow, some senior.
Huh?
Senior day after tomorrow.
Copy ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇನ್ನೊಂದರಲ್ಲೂ file ಮಾಡಿ.
Counsel for the respondent 1 and 2 files and memo along with documents. This is same is taken on record. Relist on.
Number 41.
40?
Afternoon,
No?
serial number 12, first hour. I need time.
Who asked for a passover?
The petitioner has asked. I'm for the respond number 1 minute.
Have you informed him?
I will inform.
Realist.
I will inform.
Realist. Date code. In the name of sounds. Yes.
Serial number 44, my lordship. Kindly may be listed on 4th, 3rd or 4th kindly.
Date code. ಕೊಡ್ತಾರೆ ಇಸ್ಕೊಂಡು. ಏನಾಯ್ತು?
4th may be, ma'am.
ಅವ್ರು ನಾವು ಕೊಡೋದಕ್ಕೂ ಏನೋ ಒಪ್ಪಿಲ್ಲ ಅವ್ರು. ನಾವು ಕೊಡ್ತೀವಿ ಅಂದ್ರೂ ತಗೊಳಕ್ಕೆ.
Lordship, serial number.
Settle ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. They are not settling.
ಅವರು ಕೊಡಲ್ಲ, ನಮಗೂ ಇದು ಮಾಡಿ.
ಏನ್ ಮಾಡ್ಬೇಕಂದ್ರೆ?
I have tried my level best, my lords. If this court insists, I'll bring the parties itself and present. I'll ask the parties to come physically.
No, if I were to accept his argument and set aside the order,
I have conveyed everything, my lords.
they are ready for that.
They are ready for to be bound by the judgment. Atara, that is the position. And unfortunately.
What is the value of the property according to your client?
5 ಲಕ್ಷ ಇದೆ ಸ್ವಾಮಿ. 5 ಲಕ್ಷ.
10 ಲಕ್ಷ ಆಗುತ್ತೆ ನಿಮ್ ಪ್ರಕಾರ?
5 ಲಕ್ಷ ಇದೆ. ಅದು ಸ್ವಲ್ಪ ವೆರಿ ಅಂಡರ್ ಡೆವಲಪ್ಡ್ ಏರಿಯಾ ಅಲ್ಲಿ ಇರೋದು.
ಮತ್ತೆ ಅವ್ರು 7 ಲಕ್ಷ ಕೊಟ್ರೆ ಯಾಕೆ why can't you accept it and
knows, council also knows, even they are not willing to give that money. Even ಅವ್ರ ಹತ್ರನೂ ದುಡ್ಡಿಲ್ಲ ಅಂತಿದ್ರು.
ಇಲ್ಲ ಮಾಡ್ತಾರೆ, ನಾನು ರೆಡಿ ಇದೀನಿ ಅಂತಾನೆ ಹೇಳಿದ್ರು ಮುಂದೆ. ಅವ್ರು ಅದು
if he is prepared to pay 7.5 lakhs?
Yes, my lords, I know, I've conveyed, I've told them they'll pay you 10 lakhs only. I accept the offer, but they're unwilling to take anything because they're all physically disabled in the family. Our tande blind, there are 2 daughters who are incapable of doing anything. And then ಅವ್ರ ಹತ್ರ ಏನ್ ಅವ್ರು ಗುಡ್ಸ್ಲಾಕೊಂಡಿರೋದು. So ಹಾಗಾಗಿ they have
ಸ್ವಾಧೀನ ಅವ್ರ ಕಡೆ ಇರುತ್ತಾನೆ.
ಸ್ವಾಧೀನ ನಮ್ಮ ಹತ್ರ ಬಂದಿದೆ ಸ್ವಾಮಿ. ಈಗ ಏನಂದ್ರೆ ಡಿಫೆಂಡೆಂಟ್ 1 and 2, they had no title, they sold it to him. Based on that, the judgment was
You're not getting the present market value.
My lords,
By giving up the property, you're not getting the present market value.
yes, my lords, but they are unwilling to give up the property itself because they have children, there is burden, hage anta they are incalculating the matter. ನಮ್ಗೆ ಕೊಟ್ರೆ
ಕೊಡಲ್ಲ, ಕಾಸು ಇಸ್ಕೊಡಲ್ಲ.
ನನ್ ಗುಡ್ಸಲಲ್ಲಿ ಇದೀವಿ ನಾವು. ಈಗ 10 ಲಕ್ಷ ಇದೆ, ನೀವು 2-3 ಜನ ಹೆಣ್ಮಕ್ಳು ಮದುವೆ ಮಾಡ್ಬೇಕು, ನಾವ್ ಎಲ್ಲೋಗೋಣ ಸರ್?
By reverse the decree, then they'll get back possession.
They will get back the position. ಅವ್ರು ಈ ತರ ನಾಟ್ ವಿಲ್ಲಿಂಗ್ ಟು ಸೆಟಲ್ ಬೋತ್ ಸೈಡ್ಸ್. ಆಕ್ಚುಲಿ ಈಗ ಅವ್ರ ಪಾರ್ಟಿಯಾಗೂ ದುಡ್ಡಿಲ್ಲ ಆಕ್ಚುಲಿ ಕೊಡಕ್ಕೆ. ಇವನ್ ದೇ ಆರ್ ಆಲ್ಸೋ ವೆರಿ ಪೂರ್ ಪೀಪಲ್.
ಆ ದುಡ್ಡು ಇಲ್ಲ ಅಂತ ನೀವ್ ಇಲ್ಲ ಅಂತಿದ್ರೆ ಏನ್?
ಹಾಗೇನಿಲ್ಲ ಸ್ವಾಮಿ. I have convinced, I have put all my efforts to tell them stop the litigation, you take the money and carry on. But they are on adamant on doing their own. I can't argue, my lords.
Lordship, serial number 44 kindly may be posted on 4th.
ಡೇಟ್ ಕೊಡ್ತಾರ? ಡೇಟ್ ಕೊಡ್
4th.
ಅವ್ರು ಕೇಳಿ ಅವ್ರು ಕೊಡ್ತಾರೆ.
Entry matter may be extended more. Sir, 46. Sir, 44. Sir, serial number 44.
43, sir. 43. 14 ಆದ್ಮೇಲೆ 15. 15
Sir,
45 8.
46.
8.
46 ಇಲ್ಲಿ ನಾವು ಇಲ್ಲಿ 4th ಕೊಡಿ. 4th. ಅದು 4ನೇ ಸತಿ ಬರ್ತಾ ಇರೋದು. ಇಲ್ಲಿ ಇದು ಕೊಡಿ, 5 ಕೊಡಿ. 5ಕ್ಕೆ 5 ಕೊಡಿ. ಯಾವ ಕೊಟ್ರಿ? 8 ಕೊಟ್ರಾ?
8th ಆಗುತ್ತೆ ಸರ್
49 10th ಕೊಡಿ.
ಪೂನಂ official sir.
49 10th ಕೊಡ್ತೀರಾ?
ಯಾವ್ದು?
Sir, 50. Sir, 50. Sir,
49.
50. Sir,
ಹಾಕಿದ್ಯಾ? ನಾನು official sir ಇಲ್ಲ. ಸರ್ ಸ್ವಲ್ಪ ಸರ್ ಒಂದು 2 weeks ಕೊಡಿ ಸರ್ 49
Sir,
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕು. ನ್ಯೂ ಮ್ಯಾಟರ್ ಇದು ನಮ್ಗೇನು ಡೀಟೇಲ್ಸ್ ಬಂದಿಲ್ಲ 49 ಸರ್ ಅಲ್ಲ ಅಫಿಷಿಯಲ್ಸ್ ಇರಲ್ಲ ಸರ್ ಅವ್ರ ಅಫಿಷಿಯಲ್ಸ್ ಇರಲ್ಲ ಸರ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕು ನಾವು 24th ಇದು ಸರ್ ಅದು ಹೋಗಿದೆ ಸರ್ ಸರ್ಕಾರದ ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿದೆ
ಅದೇ ಮೇಡಮ್ ನನಗೆ ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬಿಡಿ ಸಾಕು ನನಗೆ ಹೈಕೋರ್ಟ್ ಮುಂದೆ
ಯಾಕಂದ್ರೆ ಇವಾಗ ಎಲೆಕ್ಷನ್ ಬಂತು
ಹೈಕೋರ್ಟ್ ಮುಂದೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿ ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾ ಇದೀನಿ ನಾಳೆ.
ನನಗೂ ಬಂದಿದೆ ಲೆಟರ್ ಸೇಯಿಂಗ್ ದಟ್ ವಿ ಹ್ಯಾವ್ ಫಾರ್ವರ್ಡೆಡ್ ಟು ದಿ ಗವರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಸ್ಯಾಂಕ್ಷನ್ ಆಗ್ಬಿಟ್ಟು ಬಿಕಾಸ್ ಆಫ್ ಎಲೆಕ್ಷನ್ ಏನು ಆಗ್ತಾ ಇಲ್ಲ ಏನು ಆಗೋದು ಇಲ್ಲ
ಮೇಡಮ್ 2016 ಇಂದ 16 ಇಂದ ನಾನು ಕೇಳ್ತೇನೆ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡಿ ಅಂತ ಅಷ್ಟೇ, ನನಗೆ ಏನ್ ಬೇರೆ ಏನು ಮ್ಯಾಂಡಮಸ್
ಬರ್ದಿದ್ದಾರೆ ಬಟ್ ಅದೇ ಜೂನ್ ಅಂತೂ ಆಗುತ್ತೆ ಮೇಡಮ್ ಜೂನ್ಗೆ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಕೊಡೋದೇ ಇಲ್ಲ ನನ್ಗೆ ಏನ್ ಪ್ರಾಣ. ಆಮೇಲೆ ನಂದು ಟೈಟಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದ್ದಿದ್ರೆ ನಾನೇ ಕೇಳ್ತಾ ಇರ್ಲಿಲ್ಲ.
ಅದೇ ಲೆಟರ್ ಬರ್ತಾರೆ ಕರೆಸ್ಪಾಂಡ್ ಮಾಡ್ತಾರೆ
ಕೇಳ್ಬಿಡಿ ಹೇಳೋದು ಸಬ್ಮಿಷನ್ ಮಾಡಿದೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಯಾವ ಡೇಟ್ ಆಯ್ತು? ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವ ಡೇಟ್ ಆಯ್ತು? 8th of this month. 8th of ಮಾಡ್ತೀವಿ ಸರ್. ಸರ್ ಸೀನಿಯರ್ ಇದ್ದಾರೆ, ನಾವು ಪಾಸ್ ಔಟ್ ಮಾಡ್ಸಿದ್ವಿ. ಇವ್ರು ನಮ್ದು ಯಾವ್ದು ಇಲ್ಲ ನಮ್ದು ಅಲ್ಲಿ ಇವಾಗ ನಾವು ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದು ವೇಸ್ಟ್. 2 ತಗೊಳ್ತಾರೆ, 2 ತಗೊಳ್ತಾರಲ್ಲ ಸ್ಟಾರ್ಟಿಂಗ್ ಫಸ್ಟ್ಗೆ. ಇವ್ರು ಇದ್ರೆ ಇಂಟಿಮೇಟ್ ಅಂತಾನೆ ಹೇಳಿದೆ. ಈಗ ತಡೀರಿ ಸೀನಿಯರ್ ಕೇಳ್ಕೊ ಬಂದು ಕೇಳಿ ನಾಳೆ
ಅಲ್ಲಿ ಆಫೀಸ್ ಇದೆ ಅಲ್ಲಿ ಕೇಳಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. ಕಲತ್ ಹಾಕಿದೆ ನಮ್ಮ ಶಿವಕುಮಾರ್ ಅಂತ. ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಸರ್ ಶ್ರೀನಿವಾಸ್ ಭಟ್ ಬಿಡಿ ಅಡ್ವೊಕೇಟ್ ಗೊತ್ತಾ ಸರ್? ಶ್ರೀನಿವಾಸ್ ಭಟ್ ಬಿಡಿ ಅಡ್ವೊಕೇಟ್ ಗೊತ್ತಾ ಸರ್? ಶ್ರೀನಿವಾಸ್ ಭಟ್ ಬಿಡಿ ಅಡ್ವೊಕೇಟ್ ಸರ್. ನೈನ್ ತ್ರೀ ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ನಾಳೆ ಹೇಳ್ಬಿಡಿ ಟೋಟಲ್ ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಅವ್ರಿಗೆ ಸೀನಿಯರ್ ಅಶೋಕ್ ನಾಳೆ ಅವ್ರಿಗೂ ಅಪೋಸಿಟ್ ಆಗ್ಬೇಕು 8 ಡೇಟ್ ಆಳಿಮೆ ಇದೆ ಅಲ್ಲಿ ತಾಯಿ ಅವ್ರಿಗೆ 4 to 6 ಅವ್ರ ತಾಯಿ ಇದೆಲ್ಲ ಇದೆ. ಥ್ಯಾಂಕ್ ಯು. ಊಟಕ್ಕೆ ಹೋಗುತ್ತಾ? ಬೆಳಿಗ್ಗೆ ಬಂದ್ಬಿಟ್ಟು ಸರಿಯಾಗುತ್ತೆ ಸಾಹೇಬ್ರು ಅಲ್ಲಿ ಚೀಫ್ ಹತ್ರ ಇದ್ಬಿಟ್ಟು ಸಾಹೇಬ್ರು ನಿಮ್ ಸಾಹೇಬ್ರು ಫಾಸ್ಟ್ ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡ ನಮ್ಮ ಆಪೋಸಿಟ್
230, this serial number 7, final hearing for the appeal. Kindly have it in next week, man. Serial number 7, 230 list, man. Final hearing list. Next week, man. Thank you. Please, next week, kindly have it in next week.
Petitioner, my lord.
The connected matter.
The Lordship was pleased to allow the writ petition, my lord.
Connected matter allow ಆಗಿದೆ.
Identification, 8 ಗಂಟೆ ಬಿಡ್ತೀವಿ ಅಂತ ಅದ್ರಲ್ಲಿ ಅಂಡರ್ಟೇಕಿಂಗ್ ತಗೊಂಡಿದ್ವಿ, 8 ಗಂಟೆ ಬಿಡಬೇಕು ಅಂತ. I have to check up whether the same 8.5 quintals in which we undertook are different.
Matter pertains to Mysore Road, Ring Road, my lord. Lordship.
Seven in the first list. I am representing the second and third respondent. The direction is to the government. The prayer what my lord, senior friend is sought. Well, it is against the government. Wrongly, my lord, they have sought against me. No, we are necessary party to the proceedings, my lord. The government who has to 47, madam.
I'll inquire.
For conducting a joint measurement survey, madam. That is by the Assistant Director Land Records has to.
I'll secure the instruction by next week. Next week, madam. I've written letter.
Where?
Fourth matter, fourth matter. Second list, fourth matter. For 2014, though, Friday, I had asked for Wednesday, come in on Friday, kindly have it on Friday, please. On Friday, please.
Forward bench matters, serial number 1. Ravi Agde.
Lord, I am appearing for petitioner.
Lords, I appear for the respondent for NW case at this Lords. Lords, on 26th March 2024, Lords, I have filed a memo, Lords, along with the compliance. But the cause list, Lords, is not showing my memo. On 26th March, my lords, I have filed a memo along with my lords the compliance. Lords, I'm sorry, my lord, the court is not audible.
Court of session. The direction was only to consider, Alva.
Please, my lords, we have considered, my lords. My lords, what has happened is, my lords and my lords passed an order in the writ petition. Basing upon, my lords, an earlier order passed in the writ petition, that is 79363 of 2013. To, after, my lord, this petition, my lords, was in favor of the workman. Against this petition, my lords, a writ appeal was pending. I mean, it is still pending. But the fact of pendency of the writ appeal, my lords, was not brought to the notice of this honorable court because I had no instructions from the corporation. Since, my lords, our endorsement to the representation of the petitioner is that whatever order
days you required to get the writ appeal disposed of.
No, my lords. In fact, it was moved, my lords. Probably, my lords, weeks or 10 days, another 10 days time, my lords. So
8, but I'm like 15.
Please.
For hearing on serial number 2, Sri Ram P. Gorpade.
I can't hear you. You're breaking up.
First petition not the petition number 100 704/124. The
Sir, voice break ಆಗ್ತಾ ಇದೆ.
Relist.
15. 15. This one passed over matters.
May I kindly request for just a small pass over, my lords? It's just on his legs, my lords.
You're for?
I'm for the respondent number 4. We have filed statement of objections and IA for vacating stay, my lords.
Sir.
Great.
Full petition number 10704/24 Lord. Then petition as lordship. The section number 45.
Sir, ಅದು 15 ಅಜ್ಜನ ಆಯ್ತು. Forward matter, serial number 2.
Yes, sir. Much up. Petition of lordship.
ಲಾಸ್ಟ್ ಟೈಮ್ಗೆ ರೆಕಾರ್ಡ್ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ವಿ ಸುಮ್ಮನೆ ಗೌರ್ಮೆಂಟ್ಗೆ. ಆನೇಕಲ್ಲಿಂದ ಗೌರ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಬರ್ಬೇಕಾಯ್ತು, ಫೈಲೇ ಬಂದಿಲ್ಲ ಅಂತ.
Lord, copies were served long
Copies
back,
served
even
ಮಾಡಿದ್ವಿ,
records were
copy
called for, your lordship directed and keep the record present, my lord. Everything is ಎಷ್ಟು ಸಲ ಆಯ್ತು.
Actually, my colleague's matter. Yes, he said that he has not having file. I'll secure next week.
At least
Can
the
I-
earlier they should have told me, my lord. They asked us to wait here.
Colleague has asked the petition copy to serve the petition copy to secure the records. Unexpectedly, she has to left for the day.
ಹಿಂಗೆ ಏರ್ ಮಾಡ್ಬಿಡ್ಲಾ without the records?
No, I'll secure me 1 or 2 days.
Yeah, ಬೆಳಿಗ್ಗೆನೇ ಹೇಳಿದ್ರೆ saved the.
ಹಿಂಗೆ witness.
He has asked to serve the copy on us.
Can I expect the?
ಆಗತ್ತಾ ಥರ್ಡ್ ಆಗತ್ತಾ?
ಆಯ್ತು.
4:30.
He's stuck in the arbitration, my lord. If it may be taken up for tomorrow. See,
32 ನೀವಿದ್ದೀರಾ? 22 ಕೇಳ್ತಾರೆ.
32.
22. 32. 22 ನಲ್ಲಿದ್ದೀವಿ. Read out. 32 withdraw ಮಾಡಿ.
22 I'll withdraw, my lord. That was also passed over.
22 withdrawing.
Please, my lord. We have already filed the RFA, my lord, so.
I am the person who's suffering in the interim order on 22, man. I have only one request, my lords. Let the pendency of the RFA not be a ground for KADB not to disperse the compensation.
There's already stay in the RFA.
There's a stay in.
There's a stay in the RFA.
The petition has filed a
There have been
memo
on caveat.
stating that may warrant to withdraw the writ petition in view of the filing of RFA 1882/2023. In view of the memo, writ petition is dismissed as withdrawn. 32.
If it may be taken up for tomorrow, my lord. CR. Great.
For the petitioner, my lord. My lord, it's the case where the landlord has filed a suit for claiming mean profit. And order has been impugned order, which have enclosed as Annexure A. That is the order passed by the trial court. Your lordship may kindly see, it starts at page number 11. Wherein he had asked for 25,000 per month as the damages on mean profit, where the court has awarded past award, saying that every month 10,000 has to be paid for a period of 5 years. That is from the date of the eviction notice till the date of handing over the possession. My grievance is, my lord, they have not complied with section 42 of the Court Fee Act. They have not paid the court fee at all. Your lordship may kindly see the last page at page 27. The suit is partly allowed. Respondent is directed to pay damages or mean profit at the rate of 10,000 per month to the petitioner from 1/9/2008 to 5/8/2013. The dates are not in dispute. The only thing is that now the court fee and plaint, they did not pay. That you, my lord, I have taken the objection in my written statement, in my objections. When I filed my objection, I've taken this stand that they have not paid the court fee. And even in my written arguments also, I've taken the stand that court fee is not been paid, so this they cannot pass the decree. The court below has completely ignored this argument. It passes the decree also, saying that I have to pay 10,000. That is my first count. Secondly, my lord, at the time of filing the eviction petition, his contention was only 50,000 damages has to be paid by me. That is a part of the decree earlier. He had only told 50,000 has to be paid. Now, after giving the permission to file a separate, initiate separate proceedings for mean profit, he's claiming 25,000 per month, my lord. My lord, and finally the order.
What is the premises?
Premises was a commercial premises at Yeshwantpur run by a lady who lost her husband in COVID. And now right now, though, she doesn't have any source of income at all.
It is a huge property, isn't it? 55 feet by 15.5 feet.
Yes, it is a commercial property shop. She was running a shop, doing the business of onion and potatoes.
Then 10,000 rupees is not very.
My lord, this is they are claiming from the date of 2008. Whereas my advance of rupees 50,000 is with them only. They have not paid the stamp duty at all.
Don't worry about the court fee. State will take care of it. You worry about your.
My lord, my husband was running the show. She was only a showpiece there because she was a lady. The license could easily got in her name. She was her namesake. She was running the business.
You handed over possession now.
Long back, 2013 only, 10 years over. Now they're claiming 6 lakhs from me, whereas I lost my husband in.
How much are you prepared to pay?
50,000 are already there with them. I went for compromise also, and I said I'm ready to pay another 50,000 or 1 lakh because she doesn't have any source of income, my lord. She's a lady, uneducated lady, can't even sign in English. She's taken care by her daughter. My lord, she is taken care by her daughter.
You've enjoyed their property for without paying any.
No, pay rent and all was paid up to date.
What was the rent?
4,000. 4,000 was the rent, and that is not in dispute. After me evicting the premises, they have filed this petition, my lord. And now she doesn't have husband also, no source of income. Her daughter is taking care of her, and they are not paid the court fee. The decree cannot be executed at all.
50,000 rupees, I'm not.
Further 50,000 also I'm ready to pay. I have to convince her to pay that much amount because
Convincing them. If I dismiss the petition, then you'll be.
My lord, this decree cannot be enforced at all unless and until they pay the amount.
Don't worry about all that. You worry about.
Even otherwise, it is not enforceable. The decree itself is not enforceable.
No, I don't worry. I will ensure that the court fees paid.
One more thing, my lord. Kindly see page 22. Page 22 of the petition, my lord. Point number 2, which has been decided. This does not belong to my case at all. There is no proper application of fine by the trial court. May I read, my lord? The defendant claims interest on the balance amount. This is not pertaining to me at all. Nobody claimed any difference of amount from me. The state amount said admittedly the balance advance amount. The plaintiff vacated the premises.
5 ವರ್ಷಕ್ಕೆ ಎಷ್ಟಾಗುತ್ತೆ?
5 ವರ್ಷಕ್ಕೆ 6 ಲಕ್ಷ ಆಗ್ತೈತ್ರಿ. 6 lakhs.
ಎಷ್ಟು ಕೊಡ್ತೀರಿ ಹೇಳಿ?
My lord.
Or else you will suffer the liability to pay interest on this also.
ಅಲ್ಲ, looking to the circumstances and she being a lady, doesn't have any source of income. More than 2 lakhs, she can't afford to pay at all. She's 69 years old and she doesn't have husband also. She's taken by care by her daughter. How much she can pay, my lord? And landlord is self-sufficient and with the politician also. Because of the fight with her husband, he's taking revenge on this lady now.
But don't worry, how can they recover from you? Even if you suffer a decree,
In fact, they cannot recover also.
then I'll dismiss the revision, let them suffer for some more years.
It doesn't look nice, my lord. Order from court means it's like a sword on head.
ಎಷ್ಟು ಬಿಟ್ಟು ಕೊಡ್ತೀರಾ?
ಆಫರ್ ಹೇಳಿದೆ ಸ್ವಾಮಿ ಅವರು 50,000 ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿ ಅವ್ರ ಮಗ
ಎಷ್ಟಿತ್ತು?
ಮಗ ಎಲ್ಲ ಕೆಲ್ಸಕ್ಕೆ ಹೋಗ್ತಾರೆ ಸ್ವಾಮಿ ಎಲ್ಲ.
ನಿಮ್ದು ಎಷ್ಟಿತ್ತು ಡಿಮ್ಯಾಂಡ್?
ನಮ್ದು ಸ್ವಾಮಿ ಅಗ್ರಿಮೆಂಟ್ ಕ್ಲಾರಿಫೈ ಮಾಡೋದು ಸ್ವಲ್ಪ.
The lordship can fix the amount because I have approached them so many times. In fact, before coming to this court also, I have messaged them. They don't come with some proposal. So if your lordship may kindly.
6 ಲಕ್ಷ ಆಗುತ್ತಾ?
6 lakhs ಆಗ್ತದೆ.
4 ಲಕ್ಷ ಕೊಟ್ಬಿಡಿ. ಇನ್ 3.5 ಲಕ್ಷ ಕೊಡಿ. I'll ask him to give up his claim.
Make it 50%, my lord. And she doesn't have income at all.
ಆಯ್ತು ಇರ್ಲಿ ಕೊಡಿ, ಬಿಸ್ನೆಸ್ ನಡೀತಿತ್ತಲ್ಲ.
ಎಲ್ಲಿ ಬಿಸ್ನೆಸ್ ಇಲ್ಲ, ಈಗ ಏನು ಇಲ್ಲ.
ಚೆನ್ನಾಗಿ ನಡೀತಿತ್ತಲ್ಲ.
ಅವ 10,000 ಬಾಡಿಗೆ ಕೊಡ್ತಾರೆ. They have been paying the rent.
4 ಲಕ್ಷ.
If it is fixed for 3 lakhs, my lord, I can convince. If it should be fixed for 3 lakhs, 50%.
ಆಯ್ತು 3,50,000, 50,000 ಆಗ್ಲೇ ಇದೆ. 3 ಲಕ್ಷ ಕೊಡೋಕೆ ಹೇಳ್ತೀನಿ. Ask him to agree. But one lump sum, no installment, no time. Get cash, get a decree.
ಆಯ್ತು ಸ್ವಾಮಿ. ಪಾರ್ಟಿ ಕೇಳ್ತೀನಿ.
3 lakhs, my lord. Let there be recorded.
350.
Because
I'm here till reopening of the court.
be taken up next week only.
Friday.
Yes, ma'am.
Friday ತರ್ತೀರಾ ಕಾಸು?
I'll talk to them. Yes, my lord.
Talk to them ಅಲ್ಲ, ಕಾಸು ತಂದು ಕೊಟ್ರೆ ಅವ್ರಿಗೆ ಈಸಿ ಒಪ್ಕೊಳ್ಳೋದು. ಇಲ್ಲ ಅಂದ್ರೆ ತಿರುಗ ಮುಂದಕ್ಕೆ ಹೋಗುತ್ತೆ. ನೀವು ಕಾಸು ತಗೊಂಡ್ ಬನ್ನಿ, ಒಪ್ಪಿಸ್ತೀನಿ ನಾನು.
3 lakhs. 50,000.
3,50,000.
50,000 ಬಿಟ್ಟು 3 ಲಕ್ಷ. 3.5 lakhs.
It may be taken up on Friday.
Friday.
Yes. Lord, the petitioners are the owners of site number 68 to 97 formed in survey number 122/1 of Godkere village. Now in 4 survey numbers,
ಏನ್ ಪರ್ಮಿಷನ್ ತಗೊಂಡಿದ್ರೆ ನೀವೇನಾದ್ರು ಲೇಔಟ್ ಮಾಡಕ್ಕೆ?
the permission ತಗೊಂಡಿಲ್ಲ, but 3 survey numbers have been dropped.
3 survey numbers ಅಂದ್ರೆ?
My lord, annexure O, there is notification to acquire the properties in Gotigere, Kembathalli and Vallalli. Annexure O of 2003.
Next year.
The annexure O, my lord. Page 391, running page 391. It is for extension of Anjanapura layout.
Survey number 120. ಯಾವುದು?
ಅದರಲ್ಲಿ serial number 422 ನಲ್ಲಿ 122/2.
121/2.
121/2, 221/1 and 122/2.
ಇಲ್ಲ, ನಿಮ್ದು ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಇಂಟ್ರೆಸ್ಟ್ ಅದು?
Survey number, my lord, the previous page 118/1. That is serial number 411. 1. Next page nalli 121/2, 122/1 and 122/2. These are the four several numbers belong to my vendors.
121/1 and 122/.
122/2. Next page ಇದೆ. Totally 10 ಎಕರೆ ಚಿಲ್ಲರೆ ಆಗ್ತದೆ ಅದು. ಇದರಲ್ಲಿ revenue layout was formed by take and Kotkere village panchayat approved the layout plan in the year 1993.
ಯಾರು ಪಂಚಾಯತಿ?
Panchayat ಅವ್ರು ಮಾಡಕ್ ಬರಲ್ಲ but ಮಾಡಿದ್ದಾರೆ. So what has happened, my lord? As soon as this preliminary notification was issued, including all the 4 survey numbers, then the Medical Housing Society Association has issued, given representation on 28/9/2001. That is page annexure P. That page 395. ಇದು ಆಗಿರೋ ತಪ್ಪು ಏನು ಅಂದ್ರೆ ಅಲ್ಲಿ 121/1 ಅಂತ ಹಾಕಿದ್ರೆ that is 122/1 ಆಗ್ಬೇಕು. The mistake committed by the society seeking dropping off the provision 11/8, 118/1, 121/1 ಹಾಕಿದ್ರೆ 122/1 ಆಗ್ಬೇಕದು. 121/2, 122/2. It's a mistake. Then final notification, that is Exhibit Q 396. Running page 399 ನಲ್ಲಿ ಅವೆಲ್ಲ ನಮ್ಮ 4 ಸರ್ವೆ 3 ಸರ್ವೆ ಬಿಟ್ಟಿದ್ದಾರೆ. 122/1
PNL 3 ಸರ್ವೆ ನಂಬರ್ ಹೇಳಿದೆ. 118/1, 121/2, 122/2.
Yes.
3 ಅಲ್ವಾ?
3. ಇನ್ನೊಂದು ಅದು 122/1. ಅದು 122/1 ಅಂತ ಇದೆ. ಇವು 4 ಸರ್ವೆ ನಂಬರು. ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಈ ಸರ್ವೆ 122/1 121/1 ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. 3 ಸರ್ವೆ ನಂಬರ್ ಡ್ರಾಪ್ ಆಗಿದೆ.
ಒಟ್ಟು ಎಷ್ಟಾಯ್ತು ಇದು?
ಟೋಟಲ್ 10 ಎಕರೆ 38 ಗುಂಟೆ.
10 ಎಕರೆ 38.
30 ಎಕರೆ.
ಯಾವ್ದು ಡಿಲೀಟ್ ಮಾಡಿದ್ರು?
ಡಿಲೀಟ್ ಮಾಡಿರ್ತಕ್ಕಂಥದ್ದು 118/1, 121/2, 122/2.
122/1 ಮಾಡಿಲ್ವಾ?
122/1 1 ಎಕರೆ 30 ಗುಂಟೆ ಮಾಡಿಲ್ಲ. That is the subject matter.
You delete the other 3 surrounding survey numbers?
No, not others.
121/1 drop ಆಗಿದೆ. ಎಲ್ಲ I have actually given the details of it. Almost all the surveys have been dropped.
Surrounding survey numbers ಅಲ್ಲ. On the right hand side, these 3 survey numbers come. Rest on the top and on the left and bottom, all 3 sides are acquired. I have this.
No, I have read it.
Layout plan, which I have produced along.
Is the rate 118/1?
Yes.
2 acres 30 guntas. 121/2, 2 acres 23 guntas.
Yes, sir.
Then 122/1, 1 acre 30 guntas.
Yes.
And 122/2, 3 acres 20 guntas.
Yes.
All of them belong to the same family.
ಹೌದು.
No.
Except 118/1.
Not 122/2 belongs to one Lakshman.
Our ಮೇಲ್ಗಡೆ is also a khatedaar in 121/2.
118/1.
That is different.
Belongs to Anjanappa.
That you have given up.
Yes, that is given up.
Then you also given up this property of 122/1. Sorry, 121/2. Again belonging to B.A. Ram, B.A. Lakshman.
Yes.
Yes.
Then you again given a property of B.A. Lakshman, son of P.R. Anjanappa, 122/2.
Yes.
And P.R. Anjanappa is 118/1.
But Lordship may kindly take memo which I have filed. Will be
B.A. Ram, son of 122/1. B.A. Ram.
memo dated 27/1/23, filed on 6th February 23.
Memo no objections.
There is an order
Memo.
directing the BDA to file affidavit of special land acquisition with regard to status of the lands in particular village.
Memo date filed on 6th February 22.
ಯಾವತ್ತು ಮೆಮೋ?
6th February 2023 filed. Memo dated 27/1/20. Map and yes.
Affidavit,
Affidavit along with
yes. That is ನಮಗೆ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ
I got the affidavit. This is
27/1/2023.
filed on 6/2.
yes. Yes.
That is different ಅಂತ ಕಾಣುತ್ತಲ್ಲ
Yes.
ಇದೇನಾ?
ಅದೇ.
The affidavit of C.N. Ashok, Assistant Executive Engineer. It was pursuant to the orders passed on
On the next, there, no, the sketch is there. On the right hand side, no, this is a separate Gotigere village on the right hand side. Right hand side. You can see, Lord, 120, just here, Lord, at the bottom, not exactly. The bottom. 122/1, 122/2 is on the right hand side.
The 120/2, 120/3. On the southern side alva?
South. The eastern side. 122/1 is on the here, lot, a pink colored lot. And on the right hand side is
122/1, 122/2 I got.
yes. And lot 118/2, 3 are also shown. Survey number 118 is also shown.
You've given up 122/2.
Yes.
You given up
We
121
have given up 122/2.
Where is 121/2?
ಅಲ್ಲೇ ಇದೆ ಖಾಲಿ ಜಾಗ. That is 121 bar ಪಕ್ಕದಲ್ಲಿ left side.
I can't see 121/1.
122/1.
122/1 ಇದೆ.
122/1, that is the
122/1 ಬಿಟ್ಟಿದಾರಲ್ಲ?
122/1 ಬಿಟ್ಟಿಲ್ಲ, 122/2
ಬಿಟ್ಟಿದ್ದಾರೆ.
2 ಬಿಟ್ಟಿದೆ.
ಬಿಟ್ಟಿದ್ದಾರೆ.
122/1 is the subject line.
121/2?
122/1 is the subject matter.
121/2.
ಬಿಟ್ಟಿದ್ದಾರೆ ಅದನ್ನು.
ಅದೆಲ್ಲಿ ಬರುತ್ತೆ ಅದು?
That is ಪಕ್ಕದಲ್ಲಿ 121/2. ಇದು
ಯಾವ್ದ್ರ ಪಕ್ಕ?
ವೇವ್ಸ್ ಟೈಪ್ ಹಾಕಿದ್ದಾರೆ. 122/1 ಪಕ್ಕದಲ್ಲಿ ರೈಟ್ ಸೈಡ್ ನಲ್ಲಿ.
Then 121.
122/1.
This blue portion is now 122/1, correct?
Yes. Yes.
You have given up virtually the entire other.
On the eastern side, the property is deleted. Eastern side property. Rest and all not is acquired.
And 22/2 is. Your sketch blue color shows already built up ಅಂತ.
ತಪ್ಪು. ನನ್ನ ಹತ್ರ ಇನ್ನೊಂದು 2023 ಒಂದು ಅಪ್ರೂವ್ಡ್ ಪ್ಲಾನ್ ಹತ್ರ ಇದೆ. No sites have been formed in Gotigere village.
No, not
I
here.
have also produced.
122/1 is reserved for group housing scheme, Lord. Economically weaker section here. We have reserved that. That is also
challenge here.
So that is dropped now, it is not effective, given effect to.
That was, because of the litigation, Lord, we lost the litigation, this litigation. We had lost this litigation, we went in an appeal. Appeal was allowed and matter was remanded back. This very same writ petition.
No. There were 4 7 numbers in which the society claimed.
But they say society claimed, Lord, the society is never in a picture with regard to this.
Already,
Tail deed which
members,
has-
members of the society are claiming a layout was formed.
No, Lord, they have purchased it from some individual after the acquisition proceedings.
No, no, no. I have given the list
All
of
from-
the,
They are all from the acquisition, purchased from the acquisition proceedings. Some of the writ petition out of this, there are at least 11 petitioners who have purchased the sites from after the acquisition proceedings, and that too without mentioning the survey number in the entire sale deed. Sale deed, there is no mention of the survey numbers at all. The person sells it where he has sold, in which area, whether in 122/1 or 2, 118, nowhere it is mentioned in the sale deeds. Sale deed, nowhere it is
Who
mentioned.
had sold it to them? 120.
Not one Ramu had, kindly take note,
we are Raman.
Rama had sold the property through,
In that VRM.
Yes.
through a power of attorney.
But if you have deleted 3 survey numbers abutting sold by the very same person, what is the point in hanging on to this one?
Lord, those properties were deleted, Lord,
For what reason?
not that.
Because they made a request.
They had requested, Lord, their Lord, Lord may kindly
So
see,
given them 75% relief.
Lord,
25% you are not giving them.
Lord may kindly see, Lord, they are all marked, Lord, saying that, Lord, may kindly see, Lord, they are all deleted because there were some structures, Lord. These are some structure marks are shown. Here, Lord, here is the case, it was all completely vacant, as on the date of notification, as on the date of, Lord, taking possession also, it was vacant. Lord, subsequently, Lord, during the pendency of the writ appeal,
The other 3 survey numbers, if you have deleted
Yes.
on the basis of the layout that is formed, can't you apply the same principle to this?
Lord,
If
this
it's a
was-
part of the same layout,
Lord, this is a vacant land, Lord, and Lord, this would come in the way of, Lord, other adjacent place also, adjacent survey numbers also, we have formed a layout. What you may kindly see on the left-hand side, Lord, on the western side of this 122/1.
ನಿಮ್ ಪ್ರಕಾರ ನಿಮ್ ಈ ಮ್ಯಾಪ್ ಪ್ರಕಾರ
ಹಾ.
ಬ್ಲೂ ಕಲರ್ ಆಲ್ರೆಡಿ ಬಿಲ್ಟ್ ಅಪ್ ಅಂತ ಅಂತೀರಾ ಇನ್ ದಿಸ್ ಮ್ಯಾಪ್ 122/1 ಅಲ್ಲಿ
ಹೌದು.
ಬ್ಲೂ ಕಲರ್ ಇಸ್ ಆಲ್ರೆಡಿ ಬಿಲ್ಟ್ ಅಪ್ ಅಂತ ಮಾಡಿದೆ.
Lord, Lord may kindly see this, that blue color ಅಲ್ಲಿ
ಅದ್ರಲ್ಲಿ ಬರೀ ಒಂದು ಪಿಂಕ್
pink ಇದೆ.
ಹೌದು.
That
ಅದೊಂದು
is
ಮಾತ್ರ
vacant land.
ಅಲ್ಲ ಅದೇನು ಅವಾರ್ಡ್
122/1 is a vacant land. Award passed vacant land.
ಇದು ಅವಾರ್ಡ್ ಪಾಸ್ ಏನೋ ಗೊತ್ತಾಗ್ತಿಲ್ಲ ಅದನ್ನ. Yellow is BDA formed
Lord may
area.
kindly, BDA formed area, yellow. Just below that, award vacant. Pink. No.
ಅಲ್ಲ ನೀವು ಸುತ್ತಮುತ್ತ if you are saying it's built up, you have one pocket of land.
Lord, this will be connecting to the other sides. On the other side, Lord, may
So
kindly.
there's also a road which they have formed, that also you show is built up.
No.
Then what is the other one, 122/2, either way, you have given up.
This, Lord, it was not a subject matter of a denotification by the state government. But then I'm bound to.
Where is your recommendation to the state government for withdrawal of the adjoining 3 survey numbers?
That I'll place.
They would have asked for your opinion, isn't it?
They would have asked for a status report.
Then what is the report that you were given? ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ವಸಂತ್ ಅವ್ರೆ?
ಯಾವ್ದು?
ಅವ್ರು ಸ್ಟೇಟಸ್ ರಿಪೋರ್ಟ್ ಕಳ್ಸಿರ್ತಾರಲ್ಲ ಸರ್ಕಾರ ಬಿಡ್ಬೇಕು ಬಿಡಬಾರ್ದು
ಇಲ್ಲ ಆ ತರ ಏನಿಲ್ಲ, ಸುಮಾರು ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಇಲ್ಲ ರೆಕಮೆಂಡ್ ಮಾಡಿರ್ತಾರೆ. ಇದು ಡಿಕ್ಲರೇಷನ್ ಮಾಡ್ಲಿಲ್ವಾ?
ಯಾರು?
The declaration that was not in.
No, as soon as the representation given, the survey numbers have been dropped
From the declaration.
from declaration. Final notification ಬರ್ಲಿಲ್ಲ. Final ಡ್ರಾಪ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಕೇಳಿಸಿ
What is the reason?
Not there.
ನಾನು I have made this
ಅಲ್ಲಿ
notes.
built up ಅಂತ ತೋರಿಸಿದೆ, that mark is showing as a built up mark ಇದೆ, ಅದಕ್ಕಾಗಿ ಅದನ್ನ ಡಿಲೀಟ್ ಮಾಡಿ.
ಇಲ್ಲ ಅದು 122/1 ಅಲ್ಲೂ ತೋರಿಸಿದಾರಲ್ಲ ಮಾರ್ಕ್.
ಇಲ್ಲ 122/1
ಅದ್ರಲ್ಲೂ
ಅಲ್ಲಿ
ಬ್ಲೂ ಕಲರ್ ಬಿಲ್ಟ್ ಅಪ್ ಅಂತ ಬಂದಿದೆ.
Lordship may kindly see this next for blue ತೋರಿಸಿದ್ದು award ಆದ್ಮೇಲೆ built up ಆಗಿ
My lord,
revenue ಅಂತ.
subsequently also,
Award built up revenue into bracket. Award ಆದ್ಮೇಲೆ built up. Award ಆದ್ಮೇಲೂನು some unauthorized constructions would have come. That is what is award built up.
ಇಲ್ಲಿ subsequently, several writ petitions were filed and several the survey numbers have been dropped from acquisition.
What is this, Murugesh? Why will you hold on to one?
Lord, to hold on to one is Lord on the left hand.
My lord, my lord,
what
lordship may
happens,
take statement of objection
This
of
is
filed.
related. Lordship may kindly see
On
this.
5th April 2023, I have also produced the sketch blueprint given by them in the 2023. No,
ಯಾವ್ದು?
a statement of objection ಹಾಕಿದ್ದೀನಿ ಅವರದಕ್ಕೆ. That is on 5/4/2023. ಇಲ್ಲಿ ಕೆಂಬತ್ತಳ್ಳಿ ಹೊಲದಲ್ಲಿ ಮಾತ್ರ ಲೇಔಟ್ ತೋರಿಸ್ತಾರೆ ಹೊರತು ಗೊಟ್ಟಿಗೆರೆನಲ್ಲಿ ಯಾವುದೇ ಒಂದು ಸೈಟ್ ಫಾರ್ಮ್ ತೋರಿಸಲ್ಲ. ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಇದನ್ನು. ನೋಡಿ ಪೂರ್ತಿ ಬಂದಿದೆ.
5/4.
ನೋಡಿ ಸರ್, ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
Hmm?
19 to 2020 ನಲ್ಲಿ ಕಾಪಿ ಕೊಟ್ಟಿರೋದು ನಿಮ್ಗೆ.
ಲಕ್ಷ್ಮಣ್.
ನೋಡಿ. ಇಲ್ಲ ಇಲ್ಲಿ ಕೊಟ್ಟಿರೋದು ಇಲ್ಲಿ. ಇಲ್ವಲ್ಲ, ಕೊಡ್ಬೇಕಲ್ಲ.
ಇಸ್ಕೆ ಗೊತ್ತಾಗುತ್ತೆ.
ಇದರಲ್ಲಿ ಲೇಔಟ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ತೋರಿಸೋದು ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಅಂಜನಾಪುರ ಸೈಟ್ಸ್, ಕೆಂಬತ್ತಳ್ಳಿ ವಿಲೇಜ್, ಉತ್ತರಳ್ಳಿ ಹೋಬಳಿ ಮತ್ತೆ ಗೊಲ್ದಳ್ಳಿ ಎರಡೇ ಮಾತ್ರ ಲೇಔಟ್ ಮಾಡಿರೋದು.
ಇದ್ರಲ್ಲಿ ನಿಮ್ದು ಇದಿಲ್ಲ, ಜಾಗ ಇಲ್ವಾ?
ರೈಟ್ ಸೈಡ್ ನಲ್ಲಿ. ಗೊಟ್ಟಿಗೆರೆನಲ್ಲಿ ಯಾವುದು ಕೂಡ ಇಲ್ಲ.
With respect to only that, Lord, those two villages, Lord, the block wise, the area state.
Without all the three were notified for the formation of layout. Anjanapura extension layout,
Extension of
Anjanapura layout,
in Gollaldi and Kembathaldi village.
Kembathalli, Gollalli and also Gottigere. Gottigereನಲ್ಲಿ ಒಂದು ಕೂಡ ಸೈಟೇ ಮಾಡಿಲ್ಲ ಅವರು.
ಈ ಮ್ಯಾಪ್ ಇರೋದೇ ಬರೀ ಗೊಳ್ಳಳ್ಳಿ ಕೆಂಬತ್ತಳ್ಳಿ.
ಅಷ್ಟೇ ಇರೋದು.
ಇಲ್ಲ ನಿಮ್ಗೆ ಅದ್ರದ್ದು ಗೊಟ್ಟಿಗೆರೆ ಹೆಂಗ್ ಗೊತ್ತಿರೋದು ನಿಮ್ಗೆ?
ಅದು ಕೊಟ್ಟಿಲ್ಲ ಇರು. Map, we sought for consolidated map of both all the three villages. All the three villages.
I'll get that, Lord, whatever the Gottigere is, Lord, separate this.
ಹಂಗ್ ಸಪರೇಟ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ಒಂದ್ ಲೇಔಟ್ ಅಂದ್ಮೇಲೆ.
ಇದು working plan. This is a working plan.
But if you have given up the other other three survey numbers, which are abutting and belong to the same family, in which they claim a layout has been formed. If that is the reason, I'll ask you to follow the same principle for 122/1.
Lord, I'll get that records, Lord, as to why it is, those two lands were deleted. I'll get that.
What have you said in your counter as to why they?
Lord, we have said, Lord, insofar as this is concerned, Lord, we have justified the acquisition in respect of this.
Deletion ಏನ್ ಹೇಳಿದೆ?
Deletion ಬಗ್ಗೆ ಏನು? Deletion ಬಗ್ಗೆ ಹೇಳಿ. I'll get that.
ಅದು ಸರ್ವೇನು ಮಾಡಿದ್ದಾರೆ, ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಎಷ್ಟು ಸೈಟ್ಗಳಿದ್ದಾವೆ ಅಂತ ಹೇಳಿ.
122/1 ಕೊಟ್ಟಿದಾರ.
ಇದ್ರಲ್ಲಿ ಯಾವ್ದಿದೆ ಅಂತಕ್ಕಂಥದ್ದು ಸೈಟ್ಸ್. Lot will find at page 27
of
writ petition ನಲ್ಲಿ 426 is the endorsement, volume 2.
Page 27.
426. Annexure W. ಮೇಲ್ಕಂಡ ವಿಷಯ ಸಂಬಂಧ ತಮ್ಮ ಕೋರಿಕೆ ವಿಚಾರವಾಗಿ ಅರ್ಜಿಯ ಜೊತೆ ಲಗತ್ತಿಸಿರುವ ಕ್ರಯಪತ್ರಗಳು ಪರಿಶೀಲನೆಯಾಗಿ ಸದರಿ ಕ್ರಯಪತ್ರಗಳಲ್ಲಿ ಸದರಿ ವಿಷಯಗಳು ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಸಂಖ್ಯೆಯಲ್ಲಿ ಬರುತ್ತದೆ ಆದ್ದರಿಂದ ಸರ್ವೆ ನಂಬರ್ 122/1ರಲ್ಲಿ ಜಮೀನಲ್ಲಿ ಎಷ್ಟು ಕಂದಾಯ ನಿವೇಶನ ಪ್ರಾಧಿಕಾರದ ಭೂ ಸ್ವಾಧೀನದ ಪ್ರಾರಂಭಿಕ ಅಧಿಸೂಚನೆಗಿಂತ ಮೊದಲು ನೋಂದಣಿ ಆಗಿರುತ್ತದೆ ಎಂಬ ಮಾಹಿತಿ ಪೂರಕ ದಾಖಲೆಯನ್ನು ಮುಖ್ಯ ಸಲ್ಲಿಸಲಾಗಿದೆ. ನೆಕ್ಸ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ. ಸ್ಪೆಷಲ್ LAO has actually done this on 36/2008. One 122/1.
You given any reply to this annexure X? Annexure X ಏನೋ SLAO ಬರ್ಕೊಟ್ರೋ sketch?
ಇಲ್ಲ, SLAO ಬರ್ಕೊಟ್ಟಿರೋ sketch ಅಲ್ಲ. This is not
ಕಡೆ ಏನೋ sign ಇದೆ.
sign here. Not even
FDS, Office of SLAO,
Yes.
BDA.
office of SLAO ಅಂತ ಹೇಳಿ ಬರ್ದು. Well, because the original document I have day after tomorrow, and I'll get this original records as to why other lands are deleted, left out from the acquisition.
If that is the reason, I'll ask you to apply the same principle. Mr. 122/1, if there was a joint representation given, saying that we formed layout in all these four survey numbers together.
They themselves admit that they did not make a representation in respect of this very petition schedule property. This petition schedule property was never requested for deletion. That is their case first.
There's a mistake, that's what I said.
That is the mistake they say.
121/1 ಅಂತ
They did not claim on it.
If they have said we have formed a layout in four survey numbers,
No.
assuming that the survey number is mentioned wrongly, if it's a part of the same layout, then
That they did not ever approach BDA for this property at all.
they have approached the court now.
Yes. But now the possession is taken, 16(2) notification is also done. Everything has been done. Civil court deposit is there. Everything has been done.
ಅದು ಸೈಕೋ ಸ್ಟೈಲ್ ಇದಿದೆ, ಅದನ್ನು
that
ಹಾಕಿದೆ. ಸೈಕೋ ಸ್ಟೈಲ್
Lordship may kindly see this one, they have given one the synopsis. In that, Lord, they have said as to when they have purchased, some of the petitioners have purchased the sites.
ಕೊಟ್ಟಿದೆ ನೋಡಿ. ನೆಕ್ಸ್ಟ್ annexure Y.
Lordship may kindly see, Lord, the
Annexure Y. I have given almost all the 16 persons of when they have purchased the sites. Site numbers.
petitioner number 9 purchases in the year 2004.
ಅದು from previous owner, not from the main person.
10/2005.
ನೋಡಿ,
ಒಟ್ಟು ಎಷ್ಟು ಸೈಟ್ ಮಾಡಿದ್ ನೀವು?
110 sites in the entire extent of 10 acres and
103.
110. ಅದು ಬೇರೆ ಡೈಮೆನ್ಷನ್ಸ್ ಇದೆ. ಅಲ್ಲಿ ಕೆಲವು ಏನ್ ಮಾಡಿದ್ರೆ, ಕೆಲವು ಸೈಟ್ಗಳನ್ನ ಅರ್ಧ ಮಾಡಿದ್ದಾರೆ.
ಈ ಸರ್ವೆ ನಂಬರ್ ಎಷ್ಟು ಬಂದಿದೆ?
ಇದರಲ್ಲಿ 68 to 97.
2 ಎಕರೆ ಅಷ್ಟೊಂದು ಆಗುತ್ತೆ.
1 ಎಕರೆ 30 ಗುಂಟೆನಲ್ಲಿ
29 sites.
ಹಾ,
In
ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, ಕೆಲವ್ರನ್ನ ಒಂದೊಂದು ಸೈಟ್ಗಳನ್ನ ಅರ್ಧ ಮಾಡಿ ಮಾರಾಟ ಮಾಡಿದ್ದಾರೆ.
all these purchases are prior to
All this prior to 2001, 1995 sale deed, 1997
them are registered sale deeds.
these are sale deeds. ಅವರಿಂದ ಕೆಲವರು ಆಮೇಲೆ ಕೊಂಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಇವೆಲ್ಲ 70/40, 60/60.
ಅವೆಲ್ಲ ಕೂಡ I have given the details of it in my petition.
60/30.
If all of them have purchased it and registered sale deeds, first sale.
First sale.
Even according to Junjama's case, you can reconsider, isn't it, for them?
Junjama's case, Lord, so far as the layout was concerned, it was restricted to that. But here, Lord, this is a different scenario.
More survey number, you accept their layout.
These people don't even challenge the acquisition proceedings for almost 20 years, 15 years. They keep quiet. There, Lord, immediately as soon as the notification was issued, they all came before the court and said, we all purchased the revenue sites. If the acquisition is done, Lord, we will be rendering ourselves houseless. That is when, Lord, Junjama's case, those directions were issued. Here also, Lord, here kindly see, Lord, 80/30, 80/80, these kind of sites are purchased by them. Lordship may kindly take the amended writ petition which they have filed. The page 5 of the amended writ.
Lord India.
First one is 73 by
2001 ನಲ್ಲಿ annexure P ನಲ್ಲಿ we said it in clear terms that layout have been formed in Gotkere village, Gram Panchayat lands, so and so. We have said so in the year 2001 itself after.
Most of them are in the region of 2,400 square feet, probably except one or two.
ಹೌದು ಮಧ್ಯ ಕೆಲವು
Some are odd dimensions, except the first three, which is 60 by 60. Everything else is 60 by 40 or 60 by 30.
90 by 45.
ಎರಡೆರಡು ಸೈಟ್ಗಳಾಗಿದ್ದಾವಲ್ಲ.
The vacant site, ನಿಮ್ಮ ಕಾರ್ನರ್ ಸೈಟ್ ಮಾಡಿ ನಿಮ್ದು ಹಂಗೆ ಆಗುತ್ತಲ್ಲ. ನಿಮ್ ಲೇಔಟ್ ಲಾಸ್ಟ್ ಸೈಟ್ ಇಸ್ ಆಲ್ವೇಸ್ ಗೋಯಿಂಗ್ ಟು ಬಿ
ನಾವು ಅದನ್ನ
odd sites.
ನಾವು ಅದನ್ನ ಇದಕ್ಕೆ ಮಾಡಿ ವೀಕರ್ ಸೆಕ್ಷನ್ಗೆ ಇದನ್ನ ಮಾಡಿ.
That is also not implemented, it dropped also.
That is because of the litigation it is dropped.
Dropped. Now it is a clear property, except the final notification.
Award is passed. Possession is we issue a 12-2 notice to the society. Society doesn't come and object to it. If they say not that medical association society, but we have served a notice from them. They did not come forward. We, as soon as the award is passed, it was served on them.
If you can give me the reasoning for
Deletion of.
those three.
Yes.
If the same are applicable, I'll pass the same one.
Such. Yes, such may have 3-4 days.
We have made some points where subsequent to the final notification, how many acres of land has been dropped by the BDA at the instance of the owners, and also some of the owners filed a petition. There also the almost 42 acres of land has been dropped.
ಬೇರೆದಕ್ಕೆ ಹೋಗೋದ್ ಬೇಡ, ನಿಮ್ದೇನೋ ಅಕ್ಕಪಕ್ಕದ ನೋಡೋಣ ಇರ್ರಿ.
ಅಲ್ಲ ಇದು ಹಾಕಿದ್ದೀನಿ, ಯಾಕೆ ಏನು ಉಳ್ಕೊಂಡಿಲ್ಲ
ಇದರಲ್ಲಿ
ಅದರಲ್ಲಿ.
ಇದೇ ಕೇಸಲ್ಲಿ
ಅಲ್ಲ,
they applied
190
this analogy before Lordship Justice Inchkiri had applied this analogy. What has been
allowed,
said is,
the
insofar
petition was
as
allowed.
Gotigere village, you have not been able to implement the project substantially. So I'll quash this entire notification, say
No,
that
no.
you have
So far
abandoned.
as-
Because you had not taken, they had only taken Gotigere village. Not an appeal was filed. In the very same appeal, this on division bench said, no, nothing doing. You cannot apply only one village or one particular survey number to see section 27. You will have to go back to the entire area which was notified for final notification, then analyze, then give a declaration. That is how.
Speaking, if you cannibalize a scheme.
Yes.
If there are 4 villages, in one villages, if you can't even acquire the land there, what kind of a scheme would you have? Not the scheme sanctioned by the state government. There is no scheme at all. That's a virtually a new scheme.
Not what.
That ratio will go. That percentage of open space will be defeated. How will you manage the proportion, the other survey numbers?
What happens is, by the time we initiate preliminary notification and the final notification is issued, several unauthorized constructions come up.
You allow it to,
That becomes,
you allow it to happen, or else it won't happen.
BDA will not have any right there unless it's only the state which will have a right to protect that area. By then, Lord, it would all have come up.
My experience is different. Your experience may be different, but
2007 itself.
day after tomorrow.
Thursday, please.
ಪಾಯಿಂಟ್ ಮಾಡಿದ್ದೀನಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಬೇರೆದ್ ಬೇಡ ಇರ್ರಿ, ನಿಮ್ಮ ಅಕ್ಕಪಕ್ಕದ 3 ಸರ್ವೆ ನಂಬರ್
ಇದೆ
ಇದೇ ಕಾರಣ ಕೊಟ್ಟಿದ್ರೆ you have a case.
ಕೊಟ್ಟಿದ್ದಾರೆ.
Pass on, my lordship. Senior has been held up in the quarter number 1. You kindly have to speak, my
2015.
petition,
Whom do you appear for?
and for the petition.
What is your accusation for? Fourth respondent society.
Next year, Kena. Please.
My lords,
Fourth respondent.
my lords, I appear for respondent number 4 society. My lords, T.S. Amar Kumar's name is shown. He is no more. Instead, B.N. Prakash's name may be shown, my lords. May be taken up in the next week. May I request for,
Prakash takes notice.
please,
Initially,
B.N. Prakash.
Ian Prakash accepts notice on behalf of R4 in place of Shri T.S. Amar Kumar, who is no more. Office to print his name and relist on.
Last date of hearing and submitted the productions of the documents, my lord. I served the copy. I could not file it in the office, my lord, additional documents. And I file it here. RTC, up to date RTC and taxpayer receipts. Up to date RTC and taxpayer receipt. I could not file it in the counter, my lord. Served the copy on the other side. Yes, file it now.
You are challenging the 28-4 notification.
Let me continue.
2010 notification, my lord, they have filed writ petition in the year 2015. And
I'm still in person, I'm making.
taken position past the general award also, my lord. And there is no ground urged in the annexure C.
No, they mandatory provision, they are not followed it, my lord.
You know,
I'll file. May I submit this documents, my lord?
you have survey number
Settlement 99 now, 2 acres,
99,
99,
Rangadamaya.
Rangdam. Section 28(3), my lord.
Notice bandita.
Notice ಬಂದಿತ್ತು personal hearing ಅಂತ ಇದೆ 28(3) ನಲ್ಲಿ.
Here ಮಾಡಿರ್ಲಿಲ್ವಾ?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
ಮಾಡಿದೆ. Annexure C may be kindly see, my lord. That is their objection. Even otherwise.
Objections we have filed it 28(2).
What is the order under 28-3?
28(3) mandatory.
What is the order under 28-3?
28 order ಮಾಡಿದ್ದಾರೆ ಅವರು.
ಎಲ್ಲಿದೆ?
ಅಲ್ಲ, I have not produced that
Personal
order.
hearing ಗೆ ಒಂದು ನೋಟಿಸ್ ಏನಿಲ್ಲ, personal hearing ಆಗಿಲ್ಲ ಸರ್.
ಎಲ್ಲರೂ ಮಾಡಿದ್ದಾರೆ. Total ಇದಕ್ಕೆ.
ಎಲ್ಲಿದೆ? Where is the order?
Objections ಇಲ್ಲಿ ಹೇಳಿಲ್ಲ ಸರ್. Their objection they are not mentioned.
ಹೇಳಿದೀವಲ್ಲ.
The mandate ಮೇಲೆ this personal hearing should be.
Para 5 ನಲ್ಲಿ ಹೇಳಿದೀನಿ ನಾನು. Pay to public purpose. Special Execution Officer passed order on under section 28(3) on 2024-2010 and consequently state government issued final notification under section on 6/7/2010 and gazetted on 7/7/2010. After issuance of the final notification 28(4) land west to the
ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ?
and
They were heard ಅಂತ.
pardon madam.
Where have you said they were heard?
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ನನ್ನ objection ಒಳಗೆ ಹೇಳಿಲ್ಲ, but lordship may kindly see in this case, the 28(7) was issued in the year 2013 only, taking position.
No, but if you not heard.
Well, that ground has not, specific ground has not been urged, I think, in this grounds in this.
It's a mandate, 28(3) mandates that.
The grounds ಅಲ್ಲಿ ತಾವು ನೋಡಿ. There are trees ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅಷ್ಟೇ, there is no such.
ನೀವರು ಹೇಳ್ಬೇಕು ತಾನೆ, ಕನ್ಸಿಡರ್ ಮಾಡಿದಿರಾ? ಅಬ್ಜೆಕ್ಷನ್ ಎಲ್ಲರೂ ಒಂದು ಮಾಡಿದೀನಿ.
ಅಲ್ಲಿ ಎಲ್ಲಾನು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಆ ತರ ಜನರಲ್ ಆಗಿ ಕ್ಯಾನ್ ಐ ಅಕ್ಸೆಪ್ಟ್?
ಇಲ್ಲ, ಜನರಲ್ ಆಗಿ ಮಾಡಲ್ಲ. ನಾರ್ಮಲಿ ಇಫ್ ಇಟ್ ರಿಕ್ವೈರ್ಡ್ ಫಾರ್ ಎಂಟೈರ್ ಇಸ್ ವಸಂತ ನರಸಾಪುರ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಲೇಔಟ್ ಮೇಲೆ the vast extent of land. Wherever individual objections are given, my lord, wherever it is required, we will pass an order under section 28. It is required for compactness of the industrial blocks. Have they sought for compensation anywhere?
No, man. ಅಲ್ಲ ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಜನರಲ್ ಅವಾರ್ಡ್ ಪಾಸ್ ಮಾಡಿದೀವಿ ವೆರಿ ಮಿಯಗರ್ ಅಮೌಂಟ್ ಬಟ್ ಹಿಯರ್ ವಿ ಹ್ಯಾವ್ ಪಾಸ್ಡ್ ಕನ್ಸೆಂಟ್ ಅಂಡರ್ 16 lakhs per acres ಮೇಲೆ ಬಟ್ ಸಿನ್ಸ್ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಕಮ್ ಫಾರ್ವರ್ಡ್ ಮೇಲೆ ವಿ ಪಾಸ್ ದಿ ಜನರಲ್ ಅವಾರ್ಡ್ ನಿಯರ್ಲಿ
KDB ಬ್ಲಾಕ್ ಮೇಲ್
ಅಲ್ಲ ಬ್ಲಾಕ್ ಮೇಲ್
ಇದು ತಗೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಇಷ್ಟೇ ಕೊಡ್ತೀವಿ ಅಂತ.
ಇಲ್ಲ ಹಾಗೇನಿಲ್ಲ
Make an offer, how can the general award be lesser than
ಅಲ್ಲ
the
ಅದು ಲಾರ್ಡ್ಶಿಪ್ has given a judgment that regarding that deputy commissioner committee is concerned. But even otherwise, my lord, even SLO offered this compensation at 16 lakhs, my lord, then they.
If he has not been heard in the matter, statutory
ಅಲ್ಲ ಅದನ್ನ ನಾನು ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡ್ತೀನಿ. I think.
There are hundreds of trees in that mill. How can they cut the trees mill for the industrial purpose? 60 mango trees and other trees are there as per their own assessment. Page number 35 mill. They themselves assess so many trees are there. And no industry has come out, the board has not allotted to anybody. And 35 mill.
What is the ground on delay?
Item number 12 mill.
15 years, my lord. In Banda Development Authority case, this court has, Supreme Court has specifically.
ಹಾವು 60, ಹೊಂಗೆ 6, ಸಿಲ್ವರ್
sir.
10, ತೇಗು 15.
And there is no explanation also.
And 28(6) may not within 30 days they have to take possession. No, 28 notice ಆದ್ಮೇಲೆ. 28(6) ಅಲ್ಲಿ ಮೇಲೆ.
Year ಮಾಡಿ ಅಷ್ಟೇ ಹೊಸದಾಗಿ ಅದೇ ಆರ್ಡರ್ ಮಾಡತ್ತಾನೆ ನೀವು.
ಹಾ?
To year they haven't passed the same
ಅಲ್ಲ
order.
ಮಾಡಿದ್ದಾರೆ ಅದರೊಳಗೆ ಮಾಡಿದ್ದಾರೆ ಒಂದು ನಿಮಿಷ.
ಇಲ್ಲ hearing notice ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ಹೆಂಗೆ ಹೇಳ್ತಾರೆ?
Like ಹಾಕೊಳ್ತೀನಿ, if you show me that he has been heard.
That I will show, my lord. Proceedings will be there, but ಇದರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ 99 acre ಪ್ರಸ್ತಾಪಿತ ಜಮೀನು ವಸಂತ ನರಸಾಪುರ 2ನೇ ಹಂತದ ಕೈಗಾರಿಕಾ ಅಭಿವೃದ್ಧಿಯಾಗಿ ಅತ್ಯವಶ್ಯಕವಾಗಿ ಭೂಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಮುಂದುವರಿಸಲು ಆದೇಶಿಸಿದೆ. ಆಫ್ಟರ್ ಹಿಯರ್
ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ವಿ.
ಅದನ್ನ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ, ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೆ. ಐ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್.
ಹಾಕೊಳ್ಳ
ಹಾ?
ನಾಳೆ
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
Thursday.
ಹಾ, Thursday.
ನಾಳೆ ಹಾಕೊಳ್ತೀನಿ, ಬುಧವಾರ ಹಾಫ್ ಡೇ ಇರುತ್ತೆ.
Thursday.
Thursday.
What is the matter about?
This is pertain to quashing of writ of mandamus, writ of circular, annexure W and X. Lordships may kindly see the prayer. This pertains to Saint Anthony Friary Church, my lord. Buildings have been erected. And the colleges, medical colleges.
You are challenging the 77, 78 notification.
Please, my lord, because sections 27 of the BDA Act, they have not formulated the execute the scheme within 5 years from the date of 76, my lord, notification.
Which is the layout?
That is the layout have not been formed, my lord, by them. They have not taken the possession of that.
ಯಾವ layout ಮುಳುಗೇಶ್?
Yes, sir. HSR.
HSR ಆಗಿದೆಯಲ್ಲ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಆಗಿಲ್ಲ. ಅದು
Substantial execution ಆಗಿರುತ್ತೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಆಗಿಲ್ಲ. Because they have recommended that buildings have been erected. So it is ತಾವರೆಕೆರೆ.
BTM.
BTM ಅಂತ ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ. ಇದು ತಾವರೆಕೆರೆ. ತಾವರೆಕೆರೆ, ಸುದ್ಗುಂಟೆಪಾಳ್ಯ ಮತ್ತು ಬೇಗೂರು. St. John's Medical College ಪಕ್ಕದಲ್ಲಿ ಬರ್ತದೆ. I have produced the layout plan also.
What is your objections?
That they have now sought for change of land use 1, and they challenge the preliminary and final notification. We have said it is notified and the word is passed. It cannot be deleted. Possession ತಗೊಂಡಿದೆ.
ಏನ್ ಮಾಡಿದಿರ ಅಲ್ಲಿ?
ಇದು that the put up compound ಅಂತ ಹೇಳಿ that time it was when possession was taken 94 ಅಲ್ಲಿ 15/12/1994 and 1995 16/2 notification is also.
Kindly see the photographs.
They want not now.
In
They'll have
page,
to go for.
in page 82, kindly see the photographs. The buildings have been erected in the way back in 1950. Even before acquisition, even after acquisition, the plans have been sanctioned by not only by the CITB, but also by BDA, and also BBMP have been plan have been sanctioned, and the layout has been approved. by the BDA. I have produced the annexures. And the special land acquisition officer have been recommended in his proceedings that these lands are already buildings have been erected, recommended for denotifications.
38D.
I have produced the extract of the proceedings.
You have not taken and formed any layout in this particular.
In
And-
this particular land, but they may come under 38D, Lord, if it is. They may have to come under 38D for regularization of the building as well as, Lord. Because the.
With that, as
the
per the
scheme-
measure drawn on 19/6/79, several structures were present on survey number 81/2.
Yes.
They submit the petitioner who is claiming to be owner of the property, section of 5 acres 37 montage in survey number 81 has produced documents. So you admit the structures there.
There were structures, we also had.
Then what have you done?
But it is still not demolished because there were some structures of education we had not demolished. But this is all, not if they can come under 3080, get it regularized. That's all they can. But otherwise, if the scheme is not substantially implemented, but this is very old. So far as this, some Krishna missionaries,
What is existing there?
not some missionary schools, touch me kindly, prayer hall,
Church, hospitals.
82. Page 82.
Education colleges have been there.
ರೋಡ್ ಎಲ್ಲ ಮಾಡಿದೀವಿ ಅವರೇ ಫೋಟೋಸ್ ಹಾಕಿದ್ದಾರೆ.
ಎಲ್ಲಿ ಮಾಡಿದಾರೆ road?
ಲಕ್ಷ್ಮಿ kindly see page 83. ಅದೆಲ್ಲ
Road is formed by you in their land.
Yes, not in their land. It's a main road land which is not only in their land, including all survey numbers, not
No, there is such a huge structure here,
prayer hall.
then you demolish it.
No, we'll not be demolishing it. 38D they'll come. We'll regularize it and we'll.
Statement
collecting.
ಹಾಕ್ತೀರಾ ಆ ಥರ?
Not-
Statement ಹಾಕ್ತೀರಾ ಆ
No,
ಥರ?
that's 38D is for that only.
Okay,
Lakshmi
38D.
kindly see 38D. Section 38D.
Have you taken any approvals to build this? Approval ತೊಗೊಂಡೆ
Yes, my lord. Plan has been sanctioned.
ಯಾರು?
The BBMP has been sanctioned and the CITB, then CITB has approved the layout plan. BDA has sanctioned the plan thereafter. The lordship may kindly see, I have produced the documents also. The BDA issued Kata on 4/3/1997 and the BBMP has issued Kata on 22/8/2018. Plans, the necessary plans have been sanctioned in 97/98 under the BDA LP number 11/5/1999. Annexure K and K1 minor. All the necessary plans have been
D
approved.
na?
K and
38D.
K and K1.
38?
D. Allotment of Bangalore Development Authority, land in favor of the original owner or a purchaser of or unauthorized document.
ಯಾವಾಗ ಇನ್ಸರ್ಟ್ ಆಗಿದೆ ಅದು?
2020. Sir. ಕೊಡಕ್ಕೆ.
It is 2017. Some publication paper.
Edition.
There's an cap of 4,000 square feet.
Yes.
How will you get over that?
Not,
How will you get over that?
not this 4,000, not if more than 4,000 it happens, then it will have to go to the state government, not for under a resolution. That it becomes more than 4,000, then not the regularization of constructions. Including the land, the building gets regularized. And that they'll get this regularization certificate or the consent sale deed from the BDA itself, as good as the BDA allotting it to them.
Where is it set for, it'll go to the government?
There's no provision for going into the government beyond the 4,000 square feet. Generally, if it has to be deleted, then we recommend it to the state.
But if they have to pay, what is the guidance value that they have to, 50%?
50%.
What is the 50%?
Just I will examine it tomorrow, kindly after tomorrow day after.
Examine. What is the total extent here? 1 acre, 30 guntals.
Yes. Now, what would be regularized is only the built-up area.
If you see the photographs, can you take the gardens that are running between them? Then
They'll be earmarked as a roads or whatever, the public utility places.
photo nodi, how can you?
Church idre, they will not do it.
Then?
All prayer halls will not die. That way. St. John's Hospital next to St. John, that's Kormangala to Adagodi main road. That is the place.
50% of the guidance value. ಅವ್ರಿಗೇನು ಇದೆ ಕಾಸಿದಲ್ಲ ಕೊಡೋಕೆ ಅವ್ರಿಗೆ.
Bioman service we are.
But you have lost title now.
Bioman service we are doing.
Your devotees will pay. They will take care of God. 50% ಮಾಡ್ತೀನಿ ಕೊಡೋಕೆ ಹೇಳಿ.
Kindly, I will ask one.
I'm not asking for their permission. I'm passing an order.
2 days my time. I will just confirm on this.
ಬೇರೆ ಯಾರಿಗಾರ ಮಾಡಿದಾರೆ ಈ ತರ?
ಇಲ್ಲ 38D ಬೇರೆಯವರಿಗೆಲ್ಲ ನಾವು so far as this 30, 40, 40, 60, 50, 80 ಅವರಿಗೆಲ್ಲ ನಾವು we are now asking them to come and make the payment for regularization.
ಒಂದು ಕೇಸಲ್ಲಿ ನಾನು 90% ಮಾಡ್ಬಿಟ್ಟೆ ನಾನು ಗೈಡೆನ್ಸ್ ವ್ಯಾಲ್ಯೂ.
ಏನು?
The other case, tombs.
Yes.
I asked him to pay 90% guidance
ಅಲ್ಲ
value.
ಅದರಲ್ಲಿ ತಾವು ಇದನ್ನ ಫಾಲೋ ಯಾಕಂದ್ರೆ ಆಗ್ಲೇ ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡಾಗಿತ್ತು ಅವ್ರಿಗೆ
50% ಇದೆ, ಅವ್ರು 90% ಹೇಳಿದೆ.
ಅಲ್ಲಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಬರೀ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಇದ್ದಿದ್ದು ಒಂದು ಸ್ಮಾಲ್ ಪೋರ್ಷನ್. ಲಾಟ್ ಮೇ ರಿವ್ಯೂ ದಾಟ್ ಆಲ್ಸೋ ನೋಡಿ ಇನ್ಸ್ಟೆಡ್ ಆಫ್ 90%. But what happens under 38D, Lord, what happens is only the constructed area goes to them.
No, that is not practical.
There are 2 portions of the property, one on the right hand side of the road, another one on the left hand side.
Buying their property back.
They, there, 90% is not there. That is what I had said, Lord, that is not applicable to them. But since they themselves agreed, Lord, for 90%, I had said.
Your 50% ಮಾಡೋಣ. Day after tomorrow. Wednesday. Thursday.
Please. My name is not yet Kovaku, print out. But I'm happy for the respondent, but I've been asked to file, I have filed wakalat, my name is not shown, not that. This,
Please to show the name of Shri Murugesh Shetty is appearing for R2 and R3.
please.
Name of K. Krishna be deleted.
Please.
Happy for the petition in the matter, my lord. The matter pertains to compensation, my lord.
Matter?
Pertains to compensation. The petitioner is the owner of 1 acre of land in survey number 46/7 of Bominali village, my lord. This land was notified for acquisition of HSR layout on the 15th of December 1984.
You're challenging annexure S.
It's an endorsement, my lord. I'm challenging annexure S.
Page number?
So annexure S is page number 101, my lord. In terms of annexure S, what the respondent is saying is that I'm entitled to a site measuring only 30 feet by 40 feet, as against my claim for 40 feet by 60 feet, my lord.
You already got a 30 by 46.
Yes, my lord. May I just proceed, my lords, in this manner, my lord? My land was acquired for HSR layout, my lord. For everybody who lost 1 acre of land, my lord, they all have been given site measuring 40 feet by 60 feet. Kindly may I proceed, my lord, to take it page 107, my lord. Page 107. I have annexed a table. As a sample size, I have put in 10 people, all of whose lands have been acquired for the formation of HSR layout. At column 8 is HSR layout, my lord. And all of them's lands are measuring exactly 1 acre, my lord. Now, all of them have been, all of them have been allotted a site measuring 40 feet by 60 feet, my lord. I have been discriminated and given half the dimension, my lord. The reasoning given by BD is this, that the award has been passed after 1st of April 1990. And these people awards were passed before that. That is the reasoning given, my lord. My lord, my submission is this, that as per
In respect of the people at annexure W, the award was passed prior to 1990.
is what prior to 1st of April 1990, hence they get a site measuring 40 feet by 60 feet. Mine was passed after the award, my lord, is what the stand taken by the BDS, my lord. My submission is this, my lord. May I persuade this? 1984 preliminary notification is passed. I do not object to notification. Everybody is getting one site measuring 2,400 square feet. It's a promise topple. I go ahead with that. 1986 final notification is passed. I do not object. I do not challenge the acquisition, my lord. For everybody who lost out land measuring similar dimension to mine, they have been given 2,400 square feet land, my lord. I have been given only 30/40 on the premise that my award has been passed on 7th of September 1990. My lord, my submission is threefold. I have no role to play in the award to be passed. After having notified in 1984, they have taken 6 years to pass an award, and they deny me my compensation on the ground that the delay of passing the award is because the voluminous lands. And because of a margin of few months, 5-6 months, I have lost out a site measuring 30/40, my lord. Subsequently,
The award were passed after 1/4.
prior to 1/4, my lord. The basis of classification that the BDA seeks to make is that there is a
What is it said in the counter?
my lord, Counter is where I heavily rely upon, my lord. Kindly take the statement of objections for a moment, my lord. They do not deny my claim, my lord. May I request, my lord, to take para 4, my lord? Para 4 of the objection. May I read, my lord? The relevant question is at para 4, my lord, and the objections. The condition of the petition,
What say was the date of the preliminary notification?
15th of December 1984.
15th of
December 1984 is the preliminary notification.
final notification,
28th of November 1986.
28th of November
1986.
86.
Yes, my lord.
Award.
7th of September 1990. Possession
They're saying
taken.
the scheme was operational only from 14/12/87 to 31/3/1989.
That is why I
When did they take possession according to them?
29th of October 1990, my lord.
29th of
October 1990.
October
Yes, my lord.
90.
90. 29/10/1990.
Get him, madam.
May I just,
Taking time.
may I just persuade my lord to take,
I allow the writ petition.
my lord, may kindly see para.
One batch of people, same notification. They're giving him 40/60. The only ground that you have taken is, had you taken possession between 14/12/87 to 31/3/89, you would have got one side of 40/60. But because you passed the award subsequently, you are going to give him only 30/40. Pass over ಮಾಡ್ತೀನಿ ಬರಕ್ಕೆ ಹೇಳಿ. Wait, let him.
Very well, my lord. I have produced a judgment also, my lord, for the applicability of this.
Petitioner in this case. Kindly have it on tomorrow. Senior is inconvenient.
ಮ್ಯಾಟ್ರ್ ಏನ್ ಹೇಳಿ ನೀವೇ ಶುರು ಮಾಡಿ.
My lord, I don't have file. File illa.
ಬರ್ಲೇ ಬರ್ದಾಗ ಕೋರ್ಟ್ಗೆ ಫೈಲ್ ಇಲ್ಲ ಅಂದ್ರೆ.
My lord, notification as issued by the land acquisition in the year 2009. There is no compensation given to the petitioner. Till today, we are in possession.
ಇನ್ನ ಕೌಂಟರ್ ಹಾಕಿದಾರಾ? In Chandrasekhar, you have taken a decision to give up the acquisition.
No, that's made, but the government has rejected and sent it back to acquire again.
ನೀವೇ ಬೇಡ ಅಂದ್ಮೇಲೆ ಅವ್ರಿನ್ನೇನು?
That's what, again, my lord, that's what I produce.
Where is your request asking the government to give up acquisition?
That's what they say, that they have produced annexure. I think J, my lord. Counter law ಒಪ್ಕೊಳ್ತಿರಲ್ಲ, you also agree?
Page 57 ಅಲ್ಲಿ ಡ್ರಾಫ್ಟ್ ಹಾಕಿದ್ದಾರೆ. But again, it is reconsidered and recommended for again continuation.
Award pass ಮಾಡಿದ್ದೀರಾ?
Award ಮಾಡೋದಿಲ್ಲ. 29 proceedings ಎಲ್ಲ ಆಗಿರ್ತದೆ. By that time, the approach.
Nothing said in this about the award being passed. 29 to 22 lakhs ಅಂತ ಹೇಳಿದ್ದೀರಾ?
ಹೌದು.
ಆಮೇಲೆ ಏನಾಯ್ತು ಅಂತ ಬರ್ದಿಲ್ಲ.
ಆಮೇಲೆ ಅದೇನಾಯ್ತು ಫರ್ದರ್ ಗವರ್ಮೆಂಟ್ ಓದು ಬರೋದ್ರಲ್ಲಿ then they filed a writ petition, it is stopped.
ಏನ್ ಹಂಗಾರೆ ಬೇಡ, ನಿಮ್ ಜಮೀನ್ ಬೇಡ ನಿಮ್ಗೆ?
ಈಗ ಬೇಕು ಅಂತ ಮಾಡಿದ್ದಾರೆ, ರೆಸಲ್ಯೂಷನ್ ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ, ಅವಾರ್ಡ್ ಪಾಸ್ ಮಾಡಿಲ್ವಲ್ಲ ಇನ್ನು?
ಅವಾರ್ಡ್ ಮಾಡೋದಕ್ಕೆ ಇವ್ರು ಬಂದು ಅಪ್ಲಿಕೇಶನ್ ರಿಟ್ ಹಾಕೊಂಡು ಬಂದ್ರು.
ಇಲ್ಲ, ಅವ್ರು ರಿಟ್ ಹಾಕಿದ್ದು 6 ವರ್ಷ ಆದ್ಮೇಲೆ.
ದೇರ್ ಆಫ್ಟರ್ it was taken.
8 ವರ್ಷ ಆಯ್ತು. ಸುತ್ತಮುತ್ತ ಏನಾಗಿದೆ?
I think it's old area, madam. Keಳಕೋಟೆ industrial area, it's old industrial area. ಚಿತ್ರದುರ್ಗ, ವಿಕರಿಪುರ.
ವಾಶ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಬಿಡಿ, ನೀವು ಅವಾರ್ಡ್ ಡಿಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ, ಏನು ಮಾಡಿಲ್ಲ ನೀವು.
within 5 years ಅಲ್ಲೇ ಅವಾರ್ಡ್ ಮಾಡ್ಬೇಕಿತ್ತು, ಮಾಡಿಲ್ಲ ಅವ್ರು.
This is under the cadre act. Their contention is, my lord, first they say that it was not required and sent to the, not therefore that's all. My submission, my lord, of course, there is a delay on the part of the petitioner, the delay on part also, there is no dispute about that. Lord, when it is required for industrial area, we'll pass awards and pay the compensation.
ಇಲ್ಲ, but not whenever you want.
Not because there is no, and of course, my lord, there is no time limit, that's what Hisar court has held, but we pass awards. Because of this ambiguity, my lord, some delay has taken place, that's the reason.
14 ವರ್ಷ ಆಯ್ತಲ್ಲ, ಇನ್ನೇನ್ ಮಾಡ್ತೀರಾ?
Then to leave it to my lords or because I have to take instruction whether it's required or not.
Page 56 here, these are the lands you wanted to give up, alva?
Because they're not seeking a declaration also, they're not seeking.
No, this is your resolution. AD back ಕೊಡಿ. AD back. It is the case of the petitioner that we
Lordship at disposal.
ಇಲ್ಲ ಒಂದು ಅಫಿಡವಿಟ್ ಹಾಕಕ್ಕೆ ಹೇಳ್ತೀನಿ ನಿಮ್ಗೆ ಇದು 72 ಎಕರೆ ಏನ್ ಮಾಡಿದ್ರು. The petitioner that the KDB had passed a resolution requesting the state government to issue a notification under section 4 of the KD Act and thereby alter the industrial area declared earlier by deleting an extent of 72 acres, 31 guntas. So it is the case of the petitioner that his land is also a part of the 72 acres, 31 guntas suggested by the board to be given up from the purview of acquisition in the light of strong opposition from the farmers. In the light of the above, Yaraka the affidavit.
As the second respondent. Second respondent.
The second respondent shall sign an affidavit. As to
Board
whether-
party ಮಾಡಿದ್ರು. Board party ಮಾಡಿದ್ರು.
whether awards have been passed in respect of the 27 items of land indicated in Annex Church, whether the award amounts have been deposited, whether possession of any of those lands are taken. Released on Thursday. ಚಿತ್ರದುರ್ಗ ತಾನೆ
ಎಲೆಕ್ಷನ್ ಡ್ಯೂಟಿಗೆ ಹಾಕ್ಬಿಟ್ಟಾರೆ.
ಇಲ್ಲ ಅಫಿಡವಿಟ್ ಹಾಕಕ್ ಲೇಟ್ ಆಗುತ್ತಾ?
ಆಯ್ತು
ಯಾವತ್ತು ಹಾಕೊಳ್ಳಿ?
16, 18, 18.
15.
For the petitioner, this is a matter regarding payment of compensation, Lord. The amount of compensation that has been arrived at has been challenged. Lord, the petitioner's land, my Lord, has been acquired for the Nelmangla Hassan widening, my Lord.
What is Annexure C?
Lord, Annexure C, Lord, this is the award.
And Annexure E?
Lord, Annexure E is the arbitrator's award.
ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಹೋಗೋದಿಲ್ವಾ ಇದ್ರ ಮೇಲೆ?
ಅಲ್ಲ, ಇದು ಏನಾಗಿತ್ತು ಅಂತ ಹೇಳಿದ್ರೆ, ವಿ ಹ್ಯಾಡ್ ಫೈಲ್ಡ್ ಎ ಆರ್ಬಿಟ್ರೇಟರ್ ಇದ್ರ ಮೇಲೆ ವಿ ಫೈಲ್ಡ್ ಎ ದಿಸ್ ಥಿಂಗ್ ಅಪೀಲ್ ಬಿಫೋರ್ ದಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಅಂಡರ್ 34(2). ಅಲ್ಲಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಸೆಡ್ ದಿಸ್ ಥಿಂಗ್ ಇಸ್ ನಾಟ್ ಮೇಂಟೈನಬಲ್, ಯು ವಿಲ್ ಹ್ಯಾವ್ ಟು ಗೋ ಅರ್ಜಿ ಯುವರ್ ರೆಮಿಡಿ ಎಲ್ಸ್ವೇರ್ ಅಂತ ಆರ್ಡರ್ ವಾಸ್ ಪಾಸ್ಡ್. ಆರ್ಡರ್ ಇದೆ, ಅದಕ್ಕೆ ನಾವು ಮತ್ತೆ ಇಲ್ಲಿ ಬಂದಿದ್ದು. Not maintainable and.
Your Lordship, I appear for R1 in this present matter. Your Lordship, by virtue of the application of Arbitration and Conciliation Act to NHR, they had preferred a arbitration petition before the district judge under 34(2). If so agreed by any of the order passed by the district judge, the appeal lies before 37(2), Your Lordship. The primary remedy is under 37(2). So they should have challenged the present, the order passed by the learned district judge there under before through a miscellaneous first appeal, Your Lordship. That is our main and primary objection here. And there is no dispute by the petitioner either following the due procedure in respect of the.
Where will the appeal come to this court?
Your Lordship.
The appeal will be to this court?
Your Lordship. Lordship, they had preferred arbitration application before 34, under 34(2) before the district judge, Your Lordship.
So appeal will be here only?
Under 37(2), Your Lordship. Your Lordship.
So we only want the nomenclature to be changed.
Please, Your Lordship. But
And you
Your
will be
Lordship,
satisfied?
and Your Lordship, under the primary remedy through the provision, Your Lordship. That is the primary objection, Your Lordship.
ಇಲ್ಲಿ ಕೊಡಿ ಅದು. ಬೇರೆ ಅಕ್ಕಪಕ್ಕ ಜಮೀನಿಗೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
In fact, Lord, the Hassan idರಲ್ಲಿ they have determined it 4 times. In fact, KDB ಇದು acquisition idರಲ್ಲಿ 8.5 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ. That has been observed. But the arbitrator, the SLAO says that 8.5 ಲಕ್ಷ ತುಂಬಾ ಜಾಸ್ತಿ ಆಯ್ತು, 1,90,000 ಫಿಕ್ಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ.
What is the division bench ruling that is relied upon?
Lord, the division bench ruling is that your case nalli Shankar Murthy's case, it is not maintainable ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. I have got a copy of that judgment.
So on a completely different footing. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದು ನಿಮ್ಗೆ ಅವಾರ್ಡ್?
Lord, award,
Your Lordship. We had determined the
Lord, in
The
so
three-
far as the
Total
years.
extent ಎಷ್ಟು ನಿಮ್ಗೆ ಅಕ್ವೈರ್ ಆಗಿದ್ದು?
Lord, a extent that was acquired was around 4,000 square meters. ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ square meters ಅಲ್ಲಿ
there are-
ತೋರಿಸಿದ್ದಾರೆ.
There are two notifications, Your Lordship. One was a preliminary 3A notification and 3E notification, and subsequently a fresh.
Give me the
3A
dates. What's the first 3A notification?
Please, Your Lordship, once.
Lord, ಅವರು ರೆಫರ್ ಮಾಡ್ತಾ ಇರೋದು ಸೆಕೆಂಡ್ ರಿಟ್ ಪಿಟಿಷನ್ ರೆಫರ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಆ ಫಸ್ಟ್ ರಿಟ್
This is
ಪಿಟಿಷನ್
5/6/2008 passed.
23611 by 2016.
23611 ಅಲ್ಲಿ
Yes,
ಒಂದೇ ಇದಾಗಿದ್ದು.
The first order was passed by first respondent.
What is the 3A notification date?
17/11/2006.
Then 3D?
Final notification 29/2007.
2007.
In the award?
Award
5/6/2008.
5/6/2008.
What was the award?
10,36,652.
Again per square feet and
ಅಲ್ಲ ಪರ್ ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಅವರು ಸ್ಕ್ವೇರ್ ಮೀಟರ್ಸ್ ಅಲ್ಲಿ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡ್ಬಿಟ್ಟು ಹಾಕೊಂಡಿದ್ದಾರೆ.
per square meter per square feet in ಕೊಟ್ರು ಅವ್ರು. What is the award?
Lord, kindly turn to page 27, Lord. ಅದರಲ್ಲಿ ಭೂ ಪರಿಹಾರ ಬೆಲೆ ನಿರ್ಣಯ ಪ್ಯಾರನಲ್ಲಿ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ so and so. Your Lordships may leave that and come to the next page, Lord, 28. 3 ವರ್ಷದ ಸರಾಸರಿ ಬೆಲೆ ಕಂಡು ಹಿಡಿಯುವ ಬಗ್ಗೆ ಭೂ ಸ್ವಾಧೀನಪಡಿಸಿರುವ ಜಮೀನಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಕಲಂ 3(1) ಅಡಿಯಲ್ಲಿ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿದ ದಿನಾಂಕದಿಂದ 3 ವರ್ಷ ಹಿಂದಿನ ಮಾರಾಟದ ಅಂಕಿಅಂಶಗಳನ್ನು ಸಲ್ಲಿಸಲು ಉಪನೋಂದಣಾಧಿಕಾರಿ ಕುಣಿಗಲ್ ತಾಲೂಕು ಅವರನ್ನು ಕೋರಿದರ ಮೇಲೆ ದಿನಾಂಕ 18/11/2003 ರಿಂದ 17/11/2000 ನಡೆದ ಕ್ರಯ ವಹಿವಾಟಿನ ವಿವರಗಳನ್ನು ಸಲ್ಲಿಸಿದ್ದು, ಕ್ರಯದ ಒಟ್ಟು ಅಂಕಿಅಂಶಗಳು ಈ ಕೆಳಗಂಡಂತೆ ಇರುತ್ತದೆ. ಒಟ್ಟು ಸಂಖ್ಯೆಗಳ 25 ಖುಷ್ಕಿ ಜಮೀನು 6 ಎಕರೆ 34 ಗುಂಟೆ 5,59,000 is between 2003 to 2006 ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ ಏನ್ ಯಾವ ಆಧಾರದ ಮೇಲೆ ಕೊಟ್ಟಿಲ್ಲ ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಏನೋ ಬರ್ದಿಲ್ವಾ?
ಏನು ಬರ್ದಿಲ್ಲ. And in fact, my lord, as regards my lord, the trees that are standing, my lord, in the petitioner's land, ಅದ್ರ ಬಗ್ಗೆ ಕರೆಕ್ಟ್ ಆಗಿ ಅವರು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡ್ಲೇ ಇಲ್ಲ. Kindly come to annexure D,
This
my
is in
lord.
respect of the entire notification. What exactly is this?
ಅಲ್ಲ ಇದು
Doing it for 4,000 square meters or for 37,000
ಅಲ್ಲ
square
ಇದು
meters?
ಒಟ್ಟು 38,127 ಚದರ ಮೀಟರ್ಗಳಿಗೆ 74 ಲಕ್ಷ ರೂಪಾಯಿ. ಅಂದ್ರೆ ಎಲ್ರದ್ದು
Separate ಆಗಿ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಸಪರೇಟ್ ಆಗಿ ಮಾಡಿಲ್ಲ.
Separate ಆಗಿ ಮಾಡಿದೆ your lordship. I'll
Okay,
just peruse and I'll.
I will say.
In fact, as regards petitioner's lands, my lord, kindly come to serial number 8, 24, page 24. Sannaya.
Highways. Highway. Sub-register guidelines.
Page 24,
Sub-register
Guidelines.
serial number 8, 21/3C2, then 23/1, 28/3, 29/9, 28/8 and 28/1. 1 ಗುಂಟೆ ನಾವು ಕೇಳಿರೋದು 1 ಗುಂಟೆಗೆ 1.5 ಲಕ್ಷ ಬೆಲೆ ಬಾಳುವುದಾಗಿ ನಮ್ಮ ಇದನ್ನ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ.
How can you pass a general award for the entire extent of the land?
Your lordship, the SLO has determined the award as per the guidance value provided by
No.
the government. Your lordship.
Each land may have a different peculiar factor to it. How can you pass an award for the entire 37,000 square meters as if it is one piece of land?
Your lordship, in that regard, I'll have to.
Then what is the point in issuing notice to each person to come and give his claim?
Your lordship, we may be provided a short accommodation. I'll answer to the queries your lordship has asked. Senior will appear and was short accommodation may be provided. Our primary objection was that, your lordship, if an accommodation may be provided, all the queries your lordship has raised, I shall answer and satisfy to try and satisfy them. Honorable Court.
You have to pass an award individually. I don't think it's permissible for you to pass a general award for.
Your lordship, one thing which I understood, they have taken the guidance value provided by the government in terms because.
In respect of each land that is notified.
Please, your lordship.
Come to section 3D7.
Your lord. Yes, yes,
3G7.
yes.
Come to 3G7.
I have 3G7.
How can you come to the court without in the book? I will quash the award only insofar as this land is concerned. Ask them to follow 3G7.
Your lordship, the SLO has duly followed the procedure, your lordship.
How you tell me how from 3G7 that you can pass an award for the entire 38,000 square meters of land that is notified under the notification?
Your lordship, for the same reason, your lordship, one small accommodation may be provided. I shall answer to the queries raised by your lordship. I shall try to satisfy this honorable court, your lordship. One short accommodation.
Thursday.
Please, your lordship.
Oblige.
Grateful.
Preparing for a petitioner, RSA day, not well, 1 week time.
In matter, no?
ಐ ಆಮ್ ನಾಟ್ ಬ್ರಿಂಗ್ ದಿ ಫೈಲ್, ಫೈಲ್ ತಗೊಂಡು ಹೋಗಿದ್ರು ಸರ್. ಅವ ಬೆಳಗ್ಗೆ ಹುಷಾರಿಲ್ಲ ಬರೋಕ್ಕಾಗಿಲ್ಲ.
'98 notification changing in 2016 after 18 years. In what is your ground? Award pass ಮಾಡಿದ್ದೀರಾ?
Kindly take it tomorrow, my lord. 1 week time, 1 week time.
Thirty-10, 2002, my lord. Award passed, my lord. 6,94,532, my lord. Also received the landowner, my lord.
Award pass ಮಾಡಿದ್ರಲ್ರಿ?
1 week time ಆಗಿದೆ.
ಅವ್ರೇನು ಕಾಂಪೋಸಿಷನ್ ಕೇಳಿದ್ರಾ?
Check was also no.
One week time. Not well.
Thursday.
Much obliged.
Thursday.
Much obliged. No.
pertaining to outer ring road, my lord. Pertaining to our outer ring road, my lord.
Pertaining
Gautam
to-
Mullah has taken last time, my lord, for submission, regarding BDA, Gautam Mullah.
Interim order
Sir, unmute ಮಾಡ್ಕೊಳ್ಳಿ.
Yes.
Sir, ಕೇಳಿಸ್ತಾ ಇಲ್ಲ, unmute ಮಾಡ್ಕೊಳ್ಳಿ. ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಸರ್.
English ಬರ್ತಾ ಇದ್ದಾರೆ. English.
Is in VC, my lord.
Yes.
BDA codes.
This is the last chance, the realist on. ಯಾರೋ ಬೇರೆಯವ್ರು ಬಂದ್ರು ಸುಂದರೇಶ್ ಪರ. ಈಗ ನಮಗೆ ಹುಷಾರಿಲ್ಲ. ಪರ ಬೇರೆ ಯಾರೋ ಬಂದ್ರು. ಒಂದು next time.
Bill number 14, Shri V.B. Sidramaya.
The petitioner was owner of the site, my lord. He has purchased the same from his previous owner. As per annexure A at page number 11. Where site number 104 at page number 14, my lord. That this site was acquired by the KADB for formation of industrial layout. As per annexure B at page number 16. An alternative site in a layout formed by the KADB has been.
What is
that-
annexure O?
Please, my lord.
Annexure O ಏನು?
Annexure O is the endorsement, my lord. My lord, just I brief it, my lord, 2 points. My lord, as per annexure B, alternative site was allotted. My lord, date is very important. B, my lord, page number 16.
Yes.
On 17/11/2006, an alternative site has been allotted in site number 2 in a layout formed by the KADB. In lieu of the property acquired from the petitioner. Possession certificate was also issued on 17/11/2006 as per annexure C.
Yes.
Well, this site is in a well-developed layout at annexure D, page number 18. This is site number 2 in left corner bottom. my lord.
Site number 2.
2. ಕೆಳಗಡೆಯಿಂದ ಎರಡನೇದು ಎಡಗಡೆ.
40/50.
ಅದು. That has been allotted, possession has been issued. The date is very much important. On 17/11/2006, possession certificate was issued. We have constructed the house as per annexure E. We have celebrated the housewarming ceremony as per annexure F at page number 20. And even KADB has issued an NOC to the BESCOM at page number G, page number 21, madam.
ಆಮೇಲೆ ಏನಾಯ್ತು?
Thereafter, we have approached the KADB for execution of the sale deed. My lord, earlier at page number J, this honorable court has page number 25 has directed us to give a detailed representation. Subsequently, we have given a representation as per the order of this honorable court. My lord, thereafter, they have not considered, we have filed one more writ petition as per annexure page number 30. A writ of mandamus was issued to consider my representation. So since no endorsement order was issued, we have filed a contempt petition before this honorable court. Thereafter, in pendency of the contempt petition, annexure N is issued at page number 36.
ಏನಾಯ್ತು ಹೇಳ್ತಾರೆ?
Stating that this land was denotified. A denotification notification is produced at annexure O. That we have challenged, my lord. This denotification is subsequent to allotment of sites to the petitioner, subsequent to issue of possession certificate, after layout was formed by the KADB. And we have constructed the house and we are residing in the land. Our site comes within the survey number 50/2.
Who appears for KADB?
B.B. Patil appears, my lord, on last earlier occasions, this honorable court has directed to do something. And he has taken a time.
ಇನ್ನು objections ಏನ್ ಹಾಕಿದ್ದಾರೆ?
ಇಲ್ಲ, ಏನು ಹಾಕಿಲ್ಲ. ಡಿನೋಟಿಫೈ ಆಗಿದೆ ಅಂತ ಅಷ್ಟೇ ಹೇಳ್ತಾರೆ, ಬೇರೆ ಇನ್ನೇನೋ ಕಂಟೆನ್ಷನ್ ಇಲ್ಲ.
ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿದಾರೆ ನೀವು ಓನರ್ನ? ಒಂದು ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಲ್ವಾ?
ಹೌದು, ಮಾಡ್ತೀವಿ.
ಮಾಡಿದಿರಾ?
ಇಲ್ಲ ಇಲ್ಲ, ಅವ್ರದ್ದು ಅಡ್ರೆಸ್.
Then if I quash this,
ಹೌದು,
they'll be affected, isn't it?
ಎಲ್ಲ it will affect. I will implement madam. I may permitted to implement. ಅವ್ರದ್ದು ಅಡ್ರೆಸ್ ಬೇಕು ನಮ್ಗೆ. I will collect it.
ಎಷ್ಟು ಖರ್ಚು ಮಾಡಿದಿರ ಅಲ್ಲಿ?
We have constructed a house. Photograph is at page number 19. ಅದಕ್ಕೆ NOC ಕೊಟ್ಟಿದ್ದಾರೆ, ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಸಪ್ಲೈ.
ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಬರುತ್ತೆ?
ಸರ್ವೆ ನಂಬರ್ 50/2 ಮಾತ್ರ.
ನೋಟಿಫಿಕೇಶನ್
Annexure O ನಲ್ಲಿ 50/2 ನಲ್ಲಿ ನಮ್ಮ ಸೈಟ್ ಬರುತ್ತೆ. And it is well developed layout. Money has been invested by the KDB for development of layout. ಎಲ್ಲ ಮಾಡಿದ್ಮೇಲೆ ಡಿನೋಟಿಫೈ ಮಾಡ್ತಾರೆ.
ಎಷ್ಟು ಮನೆ ಕಟ್ಟಿದಾರೆ ಅಲ್ಲಿ?
ಬೇರೆಯವ್ರ ಬಗ್ಗೆ ಐಡಿಯಾ ಇಲ್ಲ. ಇದು ಲಾಂಗ್ ಬ್ಯಾಕ್ 2009 ಇಂದ ನಾವು ಲಿಟಿಗೇಷನ್ ಫೈಟ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. 2006 ಇಂದಲೂ ಫೈಟ್ ಮಾಡ್ತಾ ಇದೀವಿ.
Because if you want me to quash annexure O,
Yes.
then the person who's going to be affected by this.
Yes, I have to implement it. I will implement it. I may permitted to implement method. I will make necessary correction.
List. And give a valuation report as to how much you have spent there.
Yes, sir.
In case we can't quash it, it is the amount that you have spent.
Not only amount, my that site, my site has been already acquired.
ಎಲ್ಲಾದ್ರೂ ಒಂದು ವ್ಯಾಲ್ಯೂ ಕಟ್ ಒಂದು ವ್ಯಾಲ್ಯೂಷನ್ ಸ್ಟೇಪ್ ಹಾಕಿ ನೋಡೋಣ.
Yes, yes.
ಹಂಗಾರೆ ಏನಾರು ಮಾಡ್ತಾರ ನೋಡೋಣ.
I will get it. Let there be an order, my lord, to implement the, I will implement myself.
It is noticed that the petitioner is challenging a notification issued under section 4 of the KD Act. Stop. The beneficiaries under section 4 of the KD of the notification, namely the landowners, section number 50/2, would be affected by the said prayer. Hence, petitioner is directed to complete the owners of land bearing section number 50/2 as additional respondent.
And notice may be ordered, my lord, I will implement it.
ಯಾರಿಗೆ ಅಂತ ಮಾಡ್ಲಿ?
ಅದು ಅವ್ರಿಗೇನೆ
ಹೆಸರು ಅಡ್ರೆಸ್ ಕೊಟ್ರೆ
ಒಂದೆರಡು ದಿನದಲ್ಲಿ ಇವತ್ತೇ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ಮಾಡ್ತೀನಿ.
ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅಲೋ ಮಾಡ್ತೀನಿ. How can I make an?
ಆಯ್ತು. ನಿಮ್ಗೂ ಡೀಟೇಲ್ಸ್ ಇಲ್ಲ. Date my lord, date my kindly please.
Respondent counsel was right there, my lord. May I call him?
Where?
He was right outside. May I call him, my lord?
Tell him. Yes, Lakshmesh.
Lord, as far as the petitions are concerned, the possession was taken in the year 1990. At that point of time, the rules which is in force.
No, did he impede the BDA to take possession? Did he challenge the acquisition?
No, he has not challenged the acquisition.
So if
There
you
is no,
take
there is
your-
no difficulty because you already allotted 30-40 site. The only question here is whether he is entitled for 30-40 or 40-60. We are
Because-
saying that we have 30-40 we already allotted.
You allot one more 30/40, that's all.
ಅದು ಬರಲ್ಲ ಅಂತ ನಾವು contention. Because the scheme in respect of NGEF layout and the scheme in respect of HSR layout started from 14/12/1987. It
Lands-
stops at 1/4/1989.
Lands acquired under the very same notification for the
Correct.
very same purpose. 40/60 is given. Only because the portion was taken after,
Yeah, the
before,
yes, my lords. The possession was taken in respect of others much earlier.
who was responsible for that?
ಅದ್ ನಾವು
For the delay.
ಈಗ ಒಂದು ಲೇಔಟ್ ಮಾಡುವಾಗ 3,000-4,000 acres ಇರುವಾಗ
Correct.
We can't take it.
ಅವ್ರದ್ದೇನ್ ತಪ್ಪಿದೆ? ಅವ್ರೇನ್ ಅಡ್ಡ ಬಂದಿದ್ರೆ, ಅವ್ರ ಸ್ಟೇ ತಗೊಂಡು ಸ್ವಾಧೀನ ತಗೊಳಕ್ಕೆ ಅಡ್ಡ ಬಂದಿದ್ರೆ ನೀವ್ ಹೇಳದ್ ಕರೆಕ್ಟ್. If you are lethargic in
ಲೆಥಾರ್ಜಿಕಲ್ ಈಗ ಹ್ಯೂಜ್ ಪ್ರಪೋರ್ಷನ್ಸ್ ಅಲ್ಲಿ ಲ್ಯಾಂಡ್ ಅಕ್ವೈರ್ ಮಾಡುವಾಗ ಒಬ್ಬರದ್ದು ಎಲ್ಲದನ್ನು ಒಂದೇ ಸಲ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅದಕ್ಕೆ ಇವ್ರದ್ದು 1990 ಬಂದಿದೆ.
2080 principles apply here also.
Lords,
28 capital A principles will apply here also.
I think ಇದು Lordship, kindly see for a moment. I am bound by a government circular. Government circular ಓದ್ತೀನಿ.
ಎಲ್ಲಿದೆ?
Annexure E, my lords.
Page.
Page, ink page 40.
E.
E.
Yes.
Lord, this is a undersecretary to the government addressed to come, because prior to the commencement of the rules, only in respect of particular schemes, my lords, that incentives were announced. This is a circular which says,
This is, there's no time fixed here. It simply says, with reference to
No.
the above subject, I am directed to convey the approval of government to the incentive schemes for voluntary acquisition of lands in the case of acquisition of the land for HSR layout and east of NGF layout.
Till-
Only as a special case.
till
So,
14/12/1987. This has to be read with
Either-
another
ಎಲ್ಲಿದೆ ಆ
election.
ತರ? This is in respect of the entire acquisition for Osur Sarjapur layout. Or you saying that it is only to.
Pending the framing of the rule as mentioned above.
ಎಲ್ಲಿ?
The last paragraph ಓದ್ತಾ ಇದೀನಿ. Pending.
Hmm.
Pending the framing of the rule as mentioned above, Bangalore Development Authority should desist from implementing this incentive scheme
Hmm.
for future acquisition.
Huh.
Except for the acquisition of lands already made in the HSR layout
For every acquisition made under HSR.
and east of it till 14/12/97. If till 14/12/97 ಇದಕ್ಕೆ because of, my lord, kindly see annexure.
ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಯಾವಾಗ ಕೊಟ್ರಿ?
Annexure F, my lord, for a moment, I'll answer.
ಯಾವಾಗ ಕೊಟ್ರಿ ಹೇಳಿ?
ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಪೊಸಿಷನ್ ಮೊದಲು ತಗೊಂಡಾಗಿತ್ತು ಎಕ್ಸೆಪ್ಟ್ ಒಬ್ಬರದು. ನಾ ಇಲ್ಲಿ ಕಮ್ ಟು ಇಟ್, my lord.
Possession ಗೋಸ್ಕರ ಏನ್ ಸಂಬಂಧ? Because
That is acquisition will complete only when I take possession, my lord.
no, here, what is this 14/12/1987?
Already made in the HSR layout and east of NGO till 12/1987.
When was the ru-
Acquisition of lands already made till 14/12/1987.
when was the rule made?
For 1/4/1989.
1/4?
1989. ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ annexure ಒಂದ್ಸಲ ಓದ್ಬಿಡ್ತೀನಿ. Annexure F. ಇದು again under secretary. I am directed to convey the approval of the government for extending the benefit of incentive scheme for which approval of government has been communicated to Bangalore Development Authority, why geo dated so and so, to the HSR and east of NGF layout for the period from 14/12/1987 to 31/3/1989. The above approval is subject to the condition that this shall not become a precedent for other land acquisition cases either in the same layout or elsewhere. So 14/12/1987 ಇಂದ 31/3/1987 ಇವ್ರದ್ದು 1990 acquisition ಆಗಿರೋದ್ರಿಂದ ರೂಲ್ಸ್ 1/4/1989 ಬಂದಿರೋದು.
86 ಅಲ್ಲಿ acquisition ಆಗಿರೋದು. ನೀವು ಅವಾರ್ಡ್ ಪಾಸ್ ಮಾಡ್ರ ನಿಧಾನ.
ಇಲ್ಲ, ಅದು ಹೇಳಿದ್ದೀನಿ ನಾನು.
ಅವಾರ್ಡ್ ಪಾಸ್ ಮಾಡಿದ್ದು 7/4/1990.
ಹೌದು.
He was not responsible for
ಇಲ್ಲ,
that.
we have under a master we have taken possession on 29/10/1980.
But award is passed on 7/4/1990, despite the fact that the notification was issued under section 19 in the year 86.
ಹೌದು. ಅಂದ್ರೆ my point is acquisition was not completed. Acquisition will complete only when I take possession. By reading of annexure E and F cumulatively, my lord, it goes to show that this applicable only till annexure E and F, my lord. Till 31/3/1989, 14/12/1987 ಇಂದ 31/3/1989. So ಇವರಿಗೆ they are entitled for 40/60 site. Once rules came into force in 1/4/1989, possession has been taken in the year 1/4/1989. So he's entitled for only 30/40 site. Therefore, we allotted 30/40 site. After 2002, my lord, again there is an amendment. There they are entitled for 40/60. In the interregnum period,
They will become victims.
entitlement is only for 30/40.
They'll become victims because they fall in this bracket. Neither here nor there.
Absolutely.
Like they become victims because of the prompt act of the BDA.
No, not My lord, it is not applicable for this BDA only, my lord. Suppose whenever the rules are being framed, if there is a vacuum at a particular point of time, what has to be made applicable is once what rules came into force. So when acquisition takes place in this case, the rules came into force in 1/4/1989. There accordingly we passed an order saying that it is entitled for 30/40.
These facts are not in dispute. A notification of section 17 of the BD Act was issued on 15/12/84. And this was followed by a declaration dated 25 or 28.
28, my lord.
28/11/1986. In these notifications, the land of the petitioner bearing survey number
46/7,
measuring
1 acre,
1 acre
Omanali village.
was included. An award was also passed in respect of these lands on 7/4/1990.
7/9, my lord.
And possession of the land was taken on 29/10/1990. It is not in dispute that the petitioner did not oppose the acquisition by filing a writ petition. And he accepted the acquisition made by the BDA. The petitioner sought for allotment of a site under the incentive scheme that was prevailing in respect of the lands acquired for HSR layout. The BDA, by the impugned order
Annexure S, my lord.
dated 33/2015, has stated that the lands of that the possession of the awards in respect of the petitioner's land was taken on 7/4/1990, that is before 31/3/1990. And hence, you would be entitled to only a site measuring 30/40. It is stated that in respect of similarly situated landowners, since possession was taken prior to 31/4/1990,
31/3, my lord.
31/3/1989,
31/3.
89, my lord.
they were entitled to a site measuring 40/60. Since there was no statutory rule enacted by that time, the petitioner is therefore before this court challenging the endorsement and contending that since lands which are notified for the formation of HSR layout, the BDA has given a site measuring 40/60 as an incentive site, it would be discriminatory for the BDA to contend that he would be entitled to only a 30/40 sites. Next, Learned Counsel for the BDA place strong reliance on the government order. What is the date of this annexure E?
Annexure E.
Date idea. Annexure E and
Annexure F.
annexure F.
E and F.
692 annexure F.
In annexure E, it is stated that the government was conveying its approval to the incentive schemes for voluntary acquisition of land in the case of acquisition of the land for HSR and part and east of NGF layouts only as a special case. It is also stated therein that a separate rule will have to be framed under the provisions of the BDA Act, provided for acquisition of lands through incentive method. And it is ultimately stated that pending the framing of the rule, the BDA should desist from implementing the incentive scheme for future acquisition, except for acquisition of lands already made in the HSR and east of NGF till 14/12/87. And also, it is thus clear that as on the date of issuance of annexure E, it was the intent of the state to provide incentive sites for lands acquired under the HSR and east of NGF layouts as a special case. By annexure F, the government has stated that it was conveying the approval for extending the benefit of the incentive scheme for the HSR and the east of NGF layout for the period 14/12/87 to 31,389. And it is also stated that the approval was being subject to the condition that this would not be a precedent for other land acquisition cases, either in the same layout or elsewhere. Next, having regard to the fact that the lands were declared to be needed to the BDA on 28/11/86 itself, it is obvious that the special scheme that had been framed for HSR would have to be applied for all the lands acquired for HSR layout. The stand of the BDA that the award was passed after 31/3/89 and possession was taken
29/10/1990.
on 29/10/1990, by which time a rule had been framed which permitted the grant of a site measuring 30/40 only cannot be accepted. As noticed above, the government had made it clear that as a special case in respect of lands acquired for HSR layout, incentive schemes and incentive sites were permitted to be granted. This would therefore indicate that for every land that is acquired for HSR layout, the BDA will be bound to apply the incentive scheme. The fact that the declaration in this case was issued prior to the last date fixed for implementation of the scheme dated 31/3/89 would also emphasize the fact that the incentive scheme would be applicable to all the lands under the notified for the HSR layout. The date of passing of the award or the date of taking of possession are two events which are not in the control of the landowner and is left entirely to the discretion of the BDA, merely because the BDA takes its own time to pass an award and take possession. The benefit available to the landowner who had not opposed the acquisition cannot be defeated. I mean, therefore, of the view that the impugned notification refusing the claim of the petitioner for allotment of another 30/40 site cannot be sustained and the same is quashed. Next, it may also be pertinent to state here that the rule that was framed, Yavad Madi first,
1/4/1988 has come into
1/4/89, which provided for a site measuring 30/40 for every acre of land acquired, was actually amended in the year 2005. 2002. And in respect of lands measuring more than 1 acre, a site measuring 40/60 was granted as an incentive. This also indicates that persons who had lost land after the year 2002 would be entitled for 40/60 sites, whereas the petitioner who did not challenge the acquisition was given a site measuring 30/40. If it is to be noticed that persons covered under the same notification were granted a site measuring 40/60, becomes obvious that the act of the BDA in refusing to allot another site bearing 30/40 would be arbitrary and highly discriminatory. Consequentially, a direction is issued to the BDA to allot a site, another site measuring 30/40 to the petitioner within a period of 3 months from the date of receipt of a copy of this order.
Grateful.
Yes.
Lord, Lordship may take up 42215, my lord. I was taking a lordship through the synopsis of that judgment.
4 ತಿಂಗಳು ಮಾಡಿ ಕಂಟೆಂಪ್ಟ್ ಆಗ್ತದೆ 3 months 4 months.
ಆಯ್ತಲ್ಲ, ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು?
ಇಲ್ಲ ಅದು
24 ವರ್ಷ ಆಯ್ತು, ಇನ್ನೂ 5 ತಿಂಗಳು 6 ತಿಂಗಳು ಕೊಡ್ಲು.
2016 ಒಂದೇ ತಿಂಗಳಿಗೆ
4 months ಮಾಡಿ. ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ ಅವ್ರಿಗೆ.
Lord, I had taken your lordships through the settlement dated the term settlement dated 10/10/2008, which is annexure C 58. Then, my lord,
Next year?
10 C annexure C page 58.
ನಿಮ್ ಕೌಂಟರ್ ಅಲ್ಲ? ನಿಮ್ ಕೌಂಟರ್ ಅಲ್ಲ?
ಅಲ್ಲ, writ petition annexure C.
Yes.
Where, my lord, I took your lordships through the provisions relating to creation of
Special pay.
yes, 2.2.1. Which is, my lord, which was equivalent to officers in grade 1, which are those pay scales also I pointed out to your lordships. Then, my lord, annexure D, page 72.
Yes.
My lord, the pay of officers were revised. If your lordship sees page 72.
Yes.
28 May 2009. Now, my lord, grade 1, if your lordship seeks 6,550 to 11,350, was revised to 12,600, 32,500. Lordship got it, my lord? Page 72 of the writ petition, my lord. 42215.
28 May 2009.
Yes, my lord. This was for officers. As I pointed out, my lord, for officers, my lord, the revision is based on Government of India directions, guidelines issued by Government of India, my lord, which is common to all the central public sector undertakings, my lord. In fact, by then, my lord, all the writ petitioners were working as officers, and therefore the revised pay scale was applicable to them. Then what happened, my lord, was.
When were they given this promotion?
Yes, my lord, they were promoted.
2007, 2008 and 2009.
2009,
Yes.
7, 8 and 9, July.
So all three of them got this revision
Yes.
in 2009.
Yeah, in two petitions, my lord, they were in scale 10. In one of them, they were in special scale. In one
The
petition,
last
but the issue involved in all the three is the same. Now, my lord,
Without trouble, 5.5 may be looked into, minutes. This was applicable to the pay of the officers who were on the rolls of the company as on 31st December 2006.
yes,
As on?
31st December 2006, and continue to be in service of the company as on the date of issuance of the circular. So
Did you get the benefit or not?
Yes, they have got the benefit.
We don't get.
Yes.
We were not officers we were not officers as on 31st December 2006. 5.1, if your lordships would see, page 2. 5.1, your lordships got. We were not on the rolls of the company as on 31st December.
They did not get the benefit of this revision also.
We didn't. That's one more of our.
Lord, they have got the benefit. This is.
Get a confirmation because it has a difference. If you're saying this, they got the benefit of the revision under the officers cadre.
Yes, yes.
And if this is made applicable only to those officers who were.
No, it is not. I'll just point that out. I'll point it out. Now, my lord, kindly have a look at annexure R5, my lord. Of my statement of objections.
Next year.
This is first one. So the first one that we take.
Yes. Going to this one. We have used.
Oh. I'm sorry, my lord, your lordship may kindly take the 42210. I was arguing that. This I will come later, my lord. 42210. I'm sorry, my lord. Four double two one zero. I was arguing that, my lord. I'm sorry.
What do you want me to read?
Yes, my lord. 42210. In that, my lord, it's the same thing, my lord, 382000. Yes. I had taken your lordship through page 50.
50 of?
Annexure C, page 50. It's the same thing, my lord. 11/10/2008. Introduction of special scale. My lordship would get it at 2.2.1, my lord.
Yes.
At page 51. Then, my lord, your lordship may come to annexure D refers to, my lord, page 64, the revision, 28/5/2009.
Annexure D.
Annexure D. Now, before that, my lord, annexure D, in this, my lord, the revision happens to all officers. Same thing, 6550, 11,350, it becomes 12,600, 32,500. Now, my lord, kindly come to page 67. Officers appointed on or after 1/1/2007. Lordship got it, my lord? 5.10. 5.10.1. All officers who joined the company on or after 1/1/2007 would be deemed to have been appointed, recruited directly in the revised scales of pay, and no further fitment benefit will be admissible to them.
This is for new recruits.
This is
People
for,
were appointed for the first time after 1/1/2007.
yeah, no,
This is not a case of a promotee.
all officers who joined the company
For the first time.
on or after, it is, in fact, those who were promoted also, it is included in this.
Can that-
Yes, Milord.
They don't join the company after 1 month.
No, they officers
They were always in
appointed
the company.
one.
I don't think 5.10.1
One.
would be applicable.
I'll just point out.
.5.3 is applicable for us. 5.3 is applicable to the persons who are already there. In page 3, page 66.
Yes.
5.3 is,
As per, so if any extraordinary increment increase in pay of officers have been granted with retrospective effect, which affects the revision of pay, such increment or pay will be ignored for the purpose of fitment. Accordingly, additional increments granted to officers with effect from 1/12/2000 in terms of PC, either as basic within pay scales or are ignored for the purpose of. Then 5.6.
I don't think there's any clause specific for the promotees.
My lord, 5, if your lordship sees, 5, page 65. Pay of officers who are on the rolls of the company on 31/12/2006 and continue to be in service. This will apply to those who are there as officers on that roll. Then, my lord, those who have subsequently promoted, they would, for them, my lord, 5.1.0.1 only will be applied, because, my lord, the benefit of revision was granted to them with retrospective effect from 2007 until they became officers under the wage revision for workmen. That, my lord, may I refer to that, my lord, at page 82 of my statement of objections, my lord. Your lordship kindly have a look at that. Page 82 of the statement of objections, which is a settlement dated 3/8/2010. Page 82, my lord.
I'm sorry, my lords, 5.11, page 669. Pay fixation on promotions effected on or after 1st January 2007. We come directly there. In page 6, page 69, 5.11.
In fact, this is clarified, my lord, at 5.10.4, page 69. Annexure D, ತಾವು ನೋಡಿದ್ರೆ, page 69, 5.10.4, my lord. Kindly have a look at that, my lord. 10.4,
Just the one before.
page 69. This would apply to them. As the wage revision in respect of workmen due from 1/1/2007 is not finalized, pay of workmen promoted or appointed to post in grade 1 on or after 1/1/2007 would provisionally be fixed at the minimum pay in the revised grade 1 scale 2007. They will draw their salary, basic and DA in the revised scale of 2007 or continue to draw the salary in the pre-revised scale, whichever is higher. Their final pay fixation in the revised scale will be done upon finalization of wage revision of workmen. That happened, my lord, in 2000.
The intent there was clear.
Yes.
That they should not be prejudiced.
Correct.
And it was also made clear that their final pay fixation in the revised scale 2007 will be done upon finalization of wage revision of workmen.
Yes, my lord.
So in case there was a revision in the workman's wage,
yes,
there must be a proportionate revision insofar as
it has happened.
These are done with effect from 1/1/2007.
Yes, it has happened, my lord. Kindly have a look at annexure R5, page 82.
Annexure
R5, my lord, page 82.
Yes.
This is a settlement, my lord,
between the workmen and the company.
Union. Between the union, trade union and the company under section 12(3) read with section 18(3) of the Industrial Disputes Act. Therefore, it binds all employees, whether they are members or not, whether they are employees now, even if they come in future also, for them, this would bind them. Now, my lord, in this para 7.1, scales of pay.
Yes.
The existing scales of pay in respect of workmen in scales 1 to 10 and special scale will be revised with effect from 1/1/2007. Now, my lord, kindly see, in this case, we are concerned with those who are in grade 10 because they were promoted in 2007. I think it was in July 2007. Their scale 6,100 to 10,535 became 12,000 to 32,120.
But those in the special scale
Yes,
were granted special scale.
yes.
They were getting the same as officers grade 1,
No, their scales, my lord, also were increased.
same as that of the grade 1.
Correct. Yes, my lord.
So what was the promotion if they were in the same pay grade?
No, I'm sorry.
Going to then officer's grade. There
No, my
must be a
lord,
step
this
up.
one, in this writ petition, the first one,
They might have as well stayed in the workman
no,
cadre
I'm
only.
sorry, they were in scale 10.
They were in scale 10.
Scale 10 was not grade 1. Scale 10 was lower to grade 1.
They were in grade 10. They did not know you would create a special scale of pay.
No, my lord,
They had this
special
opportunity to
scale.
go to the higher pay
No, my
scale,
lord.
they went.
No, my lord, special scale was created subsequently after their promotion. Now, my lord, how are they affected by it? What is their right to say, don't create a special scale?
I'm
Special
nobody saying
scale.
don't create.
Yes, my lord.
By promoting them and keeping them lower. in
No,
the-
my lord, their basic and DA has always been higher than the workmen. It is because of the basket of allowances that the workmen sometimes get because of various reasons like, my lord, overtime work, which officers don't get. Sometimes they may earn a little more than the lowest rung officer in grade 1. Therefore, that cannot be put against the workman to say that merely because a workman who has put in more number of years of service and who has reached the maximum in the scale and who gets additional allowances, gets something more than an officer who may not have put in the same number of years of service, that cannot be held against the management to say that, my lord, it shall always be. On the other hand, my lord, the principle is basic and DA should be more than that of the workman. And it is nobody's case that it is lower, my lord. Therefore, kindly see, my lord, the settlement, the terms of the settlement, my lord. The scale is increased 7.1. Then, my lord, it is with effect from 1/1/2007. Then kindly see page para for clause 14. Pay fixation on promotions effected on or after 1/1/2007.
That is within the workman cadre. This won't
Yes.
apply. This won't apply.
This will apply. Please see next 15. Fixation of pay of workmen promoted to grade 1 on or after 1/1/2007. 15.1. Pay of workmen in scale 10 and below promoted or appointed to post in grade 1 after 1/1 will be fixed from the concerned revised scale to the revised scale grade 1, as in the case of promotion from any other scale grade to the next grade by applying the normal rules of pay fixation on promotion, that is granting one increment and fixing them into the scale. Then, my lord, 15.2 is important.
Your understanding of this is they remain in the same pay scale as the special scale of pay?
No, they have been fixed.
No.
Not special scale of pay. The officer's grade which is revised, maybe that is corresponding to the special scale which was created earlier.
Virtually they're in the same scale.
But then, my lord, basic and DA is higher.
No, it is the same, 12,600. For the special scale and for this, they are the same. There is no benefit.
Yes. No, my lord, they cannot compare themselves to special scale. That's the problem, my lord. They were in grade 10.
So
Now, my lord,
it is like
special
this.
scale.
It is like this, I'm in the officer's grade, but I'm still getting the
No,
same
my lord,
scale of pay of a
officers in grade 1. Now, my lord, why special scale was created? I took your lordship through the settlement. Special scale was created because, my lord, they did not have the eligibility to move on to grade 1 officers.
So those who had eligibility suffer the consequence.
No, my lord, no. They did not, there were no promotional opportunities for them.
Because they can't come to the officer's grade, you gave them an equivalent grade.
Something
And those who are
equivalent to,
eligible.
no, something equivalent to that we created, my lord. That is a part of the settlement.
You're
Now, my lord,
saying-
no, my lord, that's a part of the settlement. Now, my lord, with the trade union. Now, my lord, in fact, at that time, my lord, petitioners were not even in grade 1, they were in grade 2. How can they question the settlement creation of special scale 1 or the subsequent settlement which granted them these benefits? They have taken these benefits. Kindly see, my lord, para 15.2 there, page 92, my lord. There will not be any change in the pay of workmen, if any, who move from the special scale to grade 1 parallelly, because, my lord, it is the same scale. Who move parallelly. In fact,
moving to an officer's cadre is useless.
no, it is not. So. No, my lord, it is,
special scale.
no, my lord, nobody, with great respect, my lord, I did not force them to take this. I did not force them to take.
Encourage them. You said workmen need to become officers. You provided their qualifications. You should have said, no, once you're a workman, be a workman for your entire life.
No, my lord, for various industrial relations problems, my lord, settlements do take place. And my lord,
There's some financial.
no, my lord,
consequences. You can't
on
penalize
one,
them.
that is why, my lord, I will take your lordship to some judgments. Now, my lord, Supreme Court says a settlement has to be viewed, cannot be viewed in such narrow manner. It has to be viewed in a manner to see whether
They have no
largely it gets benefits.
Can have no objection for any settlement that you arrive at with the workmen.
Yes.
But by virtue of them being workmen earlier, and by virtue of your encouraging them to become officers.
Yes.
If you deprive them of certain benefits.
No,
that
my
they
lord,
would
I am not
otherwise got.
depriving them. No, my lord, the problem is I can understand that at the earlier point of time when posts were offered, they need not have applied.
If you had
What
told
happens?
them-
No, my lord, how do I know?
If you had told them.
Yes.
That I'm not going to create a special scale of pay.
No, my lord, that is an issue.
To be a great.
No, my lord, that is an issue. Now, how do we know? In future, we may do this, we may not do
There
this.
must be some consequence
No,
for that.
no, my
You
lord,
can't
that is why these consequences are provided, my lord. Therefore, kindly see, my lord, after 15.1, then, my lord, kindly see. Yeah. 10.3, ಅದೆಲ್ಲಿದೆ ನೋಡಿ ಅದು 10.3. 10.3. ಕೇಳಿದಾರ 10.3 ಎಲ್ಲಿದೆ amendment. This is
15.15.
amendment.
4221.
What this settlement ಅಲ್ಲಿ
Yes.
ಯಾವ ಇದರಲ್ಲಿ ಬರುತ್ತೆ ನೋಡಿ
10.3, page 92.
ಎಲ್ಲಿದೆ? My lord, by amendment, my lord, 10.3 at page 83. Ten 2010 annexure F, my lord, the additional prayer is the amended prayer, which is the reason why, my lord, this issue has occurred. That is.
Page 83 of the writ petition.
In the writ petition, my lord, amended writ petition, additional prayer that the petitioner now sought to declare that, my lordship, 1A issue a writ of certiorari or similar so and so quashing portion of paragraph 10.3 in personal circular annexure E, that is no consequential like DA, HRA, contribution to PF, leave encashment, gratuity, etc. would be payable on the special pay and service weightage pay on promotion to grade 1. Now, my lord, this is 10.3. It is because of this there has been a difference. Because while the workmen who continued in the workman cadre continued to draw these consequentials, whereas those who were promoted were not permitted to take this along with them because they were promoted as officers, and they would have got the other benefits in view of the revision of pay scales for the officers. It is because of that, my lord, this 10.3 and this provision is made. Now, my lord, the petitioners have sought for quashing of this portion, which denies them this benefit of carrying no consequentials would be payable on special pay and service weightage, which has actually made the difference according to them, who was promoted to grade 1. Now, my lord, this 10.3, if your lordship now sees page 93 of a statement of objections, page 92, is a part of the settlement, my lord. 15.3. 15.3 ಅಲ್ಲಿ, the quantum of special pay arrived at para 9.1 will continue to be paid on promotion to grade 1. Similarly, the quantum of service weightage pay arrived at 12.1 will also continue to be paid on promotion to grade 1. All this has been granted to them.
Yes, yes.
No consequentials like DA, HRA, contribution to PF, leave encashment, gratuity, etc. would be payable on these amounts to promotion to grade 1. Therefore, this, my lord, has been questioned. This, they say, this consequentials, they have sought for quashing of this. Now, my lord, this is a part of the settlement, which is binding on all
The officers.
No, all the workmen. Now, this is for workmen. This is with retrospective effect. They cannot say that one portion which grants benefit is applicable to me. The other portion which says these things are not applicable to those who are promoted is not applicable to me. They can either say this will apply to me or not apply to me. They cannot take it in part to say part will apply, part will not apply. Now, my lord, then kindly have a look at, my lord, the order passed by the competent authority, my lord, page 148, my lord, of the writ petition, my lord.
Yes.
My lord, in the earlier round, my lord, there was a direction as per page 149, my lord.
Yes.
The Honorable High Court of Karnataka in its order dated 6/3/2015 in WP number so and so had directed the authorized representatives of the petitioners in each of these batches of the writ petitions to appear before the general manager on 6/4/15 without insisting on any notice from that authority and put forth their contentions regarding refixation of their salary on that day or on any other date to be given by the said authority. The Honorable High Court had further directed that on hearing the petitioners' authorized representatives or the representations made by the petitioners, the General Manager HR shall pass a speaking order on the said representations in an expeditious manner and within a period of 3 months from the date of submissions. In the line of the directions of the Honorable High Court of Karnataka, your representatives had met me at HAL Corporate Office on 6/4/15. During the meeting, it was inquired from you whether you would like to submit any points in addition to those contained in the writ petitions. Your representatives had stated that there were no additional points to be submitted than what is already stated in the writ petition. In this backdrop, we would like to inform you the following vis-a-vis the reliefs indicated. 1. Now, my lord, to refix the same relief that they are asked for. Please see, my lord, the first one. To refix the salary of the petitioners in accordance with the rules relating to recruitment and promotion, and also payment of corresponding arrears from the date of their promotion to grade 1 and to consider the case of petitioners and grant them at least one promotional increment more than the corresponding cadre special scale of workmen with effect from 1/3/2008. There are prescribed company rules for fixation of basic pay on promotion, granting at least one increment more than wages of special scale workmen as required by you is not in conformity with the
The
rules.
company rules for fixation of basic pay on promotion.
Yes, basic.
Yeah, you have the copy of the rules?
We have annexed it at annexure M and N. The relevant portions, annexure M, page 129 and 130. M and N.
Yeah, amended.
This is
Yes.
recruitment and promotion of personal rules. The fixation of pay on promotion and what happens in disparities. These two rules we have annexed. Sixty-three, subclause 2, it will be.
The last paragraph.
Yes, ma'am.
To the existing basic pay in the scale of pay of group E or F.
As the case may be.
That is E or F ಅಂದ್ರೆ ಇದು 10 ಅದ್ರಲ್ಲಿ ಬರುತ್ತಾ?
10 ಅಂತ ಬರುತ್ತೆ.
As the case may be, as on the rate of promotion, FDA.
And notional.
What is FDA? VOA and notional increment.
Fixed DA, variable DA.
Variable DA.
And
FDA
notional
is fixed
increment in the
DA.
group will be
That
added.
group will be added.
Yes.
The amounts so arrived at DA admissible to the officers as on the date of promotion will be deducted. The amount so arrived at will be fixed at the next incremental
Increment.
stage
Yes.
or at the minimum of grade 1 scale of pay,
Whichever is
whichever is
higher.
higher.
Whichever is higher.
And the next one,
This
if
has
there
been
is a
impl-
discrepancy,
This has been implemented.
65, where a senior employee in group B to F and grade 1 promoted from lower group receives less pay than an employee belonging to the same trade who was junior to him in the lower group and was promoted subsequently, the pay of the senior employee may be stepped up equal to that of the junior employee.
So even if
With
they are
the-
in the special scale of pay, there'll be a step up of pay by one increment.
We have to be,
Normal rule.
yeah, that is a norm. We have to be granted.
Yes. My lord, this will not apply. That's the reason why, my lord, may I just take a
Your
lordship?
company rules, isn't it?
Yes. No, my lord, that
Apply.
situation has not arisen. That situation has not arisen. May I just point out, my lord, kindly see, my lord. Page 149, I was just taking your lordship through the order passed by the competent authority on the reliefs claimed by the petitioners, my lord, in the writ petitions. On promotion from scale, the third line, my lord, on promotion from one scale of pay to the next scale of pay, examples, promotion from scale 9 to 10, scale 10 to special scale, scale 10 to grade 1, grade 1 to 2, etc. One increment is added to fix the basic pay in the promoted scale. However, the pay scale of the special scale and grade 1 is the same. As the pay scales are the same, movement from special scale to grade 1 is parallel. Hence, the basic pay on movement from special scale to grade 1 will remain the same, and one increment is not added to fix the basic pay in grade 1. This methodology of fixation of basic pay on movement from the special scale to grade 1 is a part of the settlements entered into with the recognized unions in 2008 on review of the time scale promotion and career plan scheme in respect of workmen. The rules in this regard were notified as per circular number 1010/2008, para 2.2.13 of annexure 1 to the circular dated 10/10/2008 specifically refers in this regard. In respect of promotion, or elevation to grade 1 from scale 10 or the lower scales, one notional increment is added to fix the basic pay in grade 1. Accordingly, the basic pay in grade 1 on parallel movement from special scale or on promotion from scale 10 or the lower scales is fixed as per the laid down rules in the company. As such, your request to fix the basic pay on movement from special scale to grade 1 by grant of at least one promotional increment cannot be agreed to. Because they are on the same scale. Then, and that is a part of the settlement. Then the second one, consider the representation of petitioners to the writ petitions by giving them all benefits that special scale workmen are eligible as per PC dated 1/3/2008. Special scale is in the workman cadre and grade 1 is in the officers cadre. Benefits applicable to workmen do not apply to officers and vice versa. The basic aspect to be noted here is that workmen and officers belong to two separate and distinct cadres. Both the categories are governed by separate sets of rules and terms and conditions of service. One category cannot compare with the other for the purpose of benefits. Officers in general in the company are not paid special pay and service weightage pay. However, employees like petitioners who moved from grade 1 after 1/1/2007 have been extended additional benefits of special pay and service weightage pay without consequential benefits. That, my lord, it is 10.3, which I just now read to your lordships. In this connection, it is to be noted that those promoted to grade 1 before 1/1/2007 were extended the benefit of service weightage pay, though they were drawing the same in the workman cadre. As SWP was not granted and special pay was not extended to those promoted to grade 1 before 1/1/2007, there was reduction in their emoluments also. You need to compare your case with such officers rather than with workmen in the special scale. When such a comparison is made, it will be clear that those promoted or parallelly moved from grade 1 after 1/1/2007 are better placed than seniors promoted to grade 1 before 1/1/2007. Agreeing to a request would also result in anomalies in respect of officers promoted to grade 1 earlier and who are senior to you. The management cannot consider a dispensation which would result in anomalies. Considering the above aspects, your request cannot be agreed to. Then the next one, my lord. Consider the representations of the petitioners to the writ petition by reverting them to the post of special scale workmen, along with all benefits that special scale workmen are eligible to. Option of reverting to the special scale from grade 1 is not a feasible or appropriate proposition. The petitioners had applied against the notifications for promotion from workman cadre to grade 1 on own volition. On movement to grade 1, petitioners are governed by rules applicable to officers. In fact, grade 1, there is no anomaly in your case compared to other officers. In grade 1, realistic comparisons need to be made with other officers and not workmen. Considering your request for reversion to the workman cadre could also lead to similar requests from earlier promotees to grade F and give rise to chain reactions. Considering these factors, the request cannot be agreed to. Then, my lord, fitment benefit, they ask for the final one, fitment benefit. Pay revision with effect from 1/1/2007 in respect of officers of the company was implemented in line with the guidelines notified by the Department of Public Enterprises, Government of India, and presidential directives. As per DPOM dated 26/11/2008, 30% fitment benefit was applicable to officers who were on the rolls of the company as on 31/12/2006 and continued to be on the rolls on 1/1/2007. Since you were promoted to grade 1, that is officers cadre, on after 1/1/2007, you were not eligible for fitment benefit of 30%. You had got fitment benefit of 22% applicable to workmen as on 1/1/2007 in accordance with the wage settlements entered into with the recognized trade unions on wage revision with effect from 1/1/2007. On movement or promotion to grade 1 in officers cadre with effect from 1/7/2007 or later, they became eligible for scales of pay, perks, allowances, benefits as applicable to officers in grade 1. Fitment benefit is given on salary wage revision from the date of revision. Since salary revision of officers was effective from 1/1/2007, 30% fitment benefit were not officers Since salary revision of officers was effective from 1/1/2007 and the petitioners were not officers as on 1/1/2007, the question of giving them 30% fitment benefit will not arise. Fitment benefit as applicable to officers will be applicable to you only at the time of future revisions. Accordingly, the request. Therefore, my lord, the claim of the petitioner, and that too, my lord, kindly see when this is, they were all in grade 2, and after 6 years, the benefit is sought now. To say that you remove that, give us 30% additional benefit, which is contrary to the rules. And my lord, reversion, which is, my lord, cannot be permitted. Now, my lord, some judgments which, my lord, I have cited. Kindly have a look at these judgments, my lord. I have a common list of authorities I have filed, my lord.
Bunch of 11 judgments.
I'm sorry, my lord.
11 judgments.
Yes, my lord. Yes, my lord. 11 judgments are cited.
Tamil Nadu Education Department.
Yes, my lord. Tamil Nadu, para.
What points?
My lord, yeah. My lord, Tamil Nadu, para 6, your lordship kindly take, my lord. Para 6, 7, 8 and 16 are the relevant paras. Para 6. The next development in the fortunes of the former district board schools employees came in GO number so and so. Here, government recapitulated the position after 1/7/1470 and considered afresh the question of integration of two services. The government schools servants being called A wing and the staff of the former district schools being called B wing. In the considered view of the government, complete integration of A and B wings was administratively difficult, and so they were kept separate as two wings of Tamil Nadu Education Subordinate Service and Tamil Nadu Education Service. Certain amelioratory measures were taken in opening up better prospects and avenues of promotion for the new arrivals from the district board schools. Presumably, this halfway house arrangement was hardly a sufficient appeasement, and government was again agitated over the question. The pressure of social justice brought to bear on government through many channels, including the House of Legislature, persuaded the state to overhaul the entire pattern of integration and fitment of the two wings in a common seniority list. Then, my lord, para 7. In service jurisprudence, integration is a complicated administrative problem where in doing broad justice to many, some bruise to a few cannot be ruled out. Kindly see, my lord, how the Supreme Court has viewed. By and large, majority have got benefit, my lord, merely because a minority of them get bruised because of this. That cannot be altered.
The people were appointed as officers here, promoted as
Uh,
officers.
In fact, my lord, the total number of workmen is around 10,000 in Bangalore itself. And officers.
Who went to the cadre of officers grade.
Yes,
1.
officer.
How many are before the court?
My lord, here, 1 minute, my lord.
351 in Bangalore.
No, 1 minute.
Officers grade 1.
Officers who are promoted from the.
No, 1 minute. In the writ petitioners are, my lord, I'll just point out. In 42210, there are 5 petitioners. And in the other cases, 42215, my lord, there are 12 petitioners.
And in the last case.
And in the last case,
13.
there are 13 petitioners. Only they are in before this honorable. None of the, in fact, the total number of officers as of now is around 20,000.
No. Those who were promoted.
All right. Those who I can get those details as to how many were promoted.
351. We know about it.
Yes.
350.
In fact, that would also affect the others who are already promoted. Because the wage revision is applicable to all. Then para 8, my lord. The feeble criticism that promotional proportion between the two wings in the process of interlacing and integration is unsupported by any rational guideline is pointless. This states case is that when two sources merge, it is not uncommon to resort to quota rule for promotion. Although after getting into common pool further, apartheid shall be interdicted save in a limited class with which we are not concerned here. Of course, even if the quota rule is an administrative device to inject justice into the integrating process, the ratio cannot be arbitrary nor based on extraneous factors. None such is ever nor established. The onus is on the challenger, and here the ratio is moderately related to the number on both sides. And we see nothing going berserk, nothing bizarre, nothing which makes you rub your eyes to query what strange thing is this garment doing. Counsel for the respondents explain that when equated groups from different sources are brought together, quota rota expedients are practical devices familiar in the field. Bearing in mind the strength of the district board, staff to be inducted, the ratio is rational. Maybe a better formula could be evolved, but the court cannot substitute its wisdom for garments, save to see that unreasonable perversity, malafide manipulation, indefensible arbitrariness, and like infirmities do not defile the equation for integration. None of these factors are also there in my writ petition.
But that was a case of integration of two services.
Yes, my lord.
That can't be the.
No, Lord, that my lord, yes.
The case related to integration of services, what they say is correct.
Yes. Now, my lord.
This is not a question of integrating two services.
No, my lord, what happens is when you revise the scales of workmen, and then in fact, my lord, here special scale was created. Now, why special scale was created, I just pointed out, my lord, because there was a demand from the union, and my lord, they were stagnating, and some incentive for them was given to create special scale, which was almost kind of equivalent to officers in grade 1. And my lord, it is not as though, my lord, officers were left in the lurch.
This is one of those rare cases where they want to go down. And you're not allowing them to go down.
No, my
Everybody
lord.
wants to move up in life, but here they're ready to move down.
Yes.
To their
Will-
original cadre.
After two.
And you're not agreeing for that also.
No, my lord, no, my lord, except for 10 or 15 who are before this on the court, nobody else has a grievance about this. No, my lord, as I pointed out, there are 10,000 workmen and 20,000 officers.
No, but I just said right
Yes.
away, everybody wants to go up. Here they're prepared to go down. And you're not allowing them to go down.
My lord, next judgment, my lord, kindly see. Para 8, page 8, my lord. Division bench judgment of Madras High Court. Para 14, my lord. We are of considered view that the impugned clause 6.64 of the board's proceedings dated so and so is not illegal or unconstitutional. It may be mentioned, there is always a presumption in favor of the constitutional validity of a statute or rule, and an attempt should be made to uphold the same instead of striking it down. Then, my lord, 16, it may be mentioned that fixing of pay scales and salaries is a complicated matter, and it is for the executive authority to decide, as they only have the expertise in this matter. Ordinarily, it is not proper for the courts to interfere in these types of matters, as courts do not have such expertise. Then, my lord, come to para 18, my lord.
This is also important.
Para 18, my lord.
Yes.
In our opinion, fixation of pay scales, salaries, etc. are purely executive functions, and it is not proper for this court to interfere in this executive domain. In Rama Mutramalingam versus Deputy Director so and so, a division bench of this court discussed the philosophy of judicial restraint in great detail, and we reiterate the views expressed therein. There are several considerations which have to be taken into account by the executive while fixing the pay scales, salaries, etc. And the court should realize that only the executive authorities have the requisite expertise in such matters and not courts. Interference by courts in the fixation of pay scales and salaries can only result in chaos and confusion and can have adverse and undesirable repercussions. Then para 19 and 20.
Yes.
There is, there is nothing in the constitution or in any statutory rule that a junior cannot get a higher salary than a senior, particularly when junior has put in large number of years of service as compared to the senior, who may be a new recruit. In any event, these are matters to be decided by the executive. And it is not proper for this court to encroach upon this field as has been done by the learned single judge. The courts must exercise judicial restraint and not interfere in such matters. Then para 20, my lord, they refer to the judgments of the Supreme Court on this aspect. It is well settled in the policy matters. This court has a very limited scope of interference.
Yes.
Then, my lord, the next judgment, may I just refer to, my lord? Page 20, my lord. 2002, 3 SEC, page 411.
Yes.
Para 18, my lord. My lord, this is how a settlement has to be looked into, my lord, this is the Supreme Court. Settlement, especially when it is a 12-3 settlement entered into with the trade union.
No, they are not agreed with the settlement. They are
No, my
not
lord,
saying.
what they are now asking for is to quash a part of the settlement.
All right.
That 10.3 is a settlement which I took your lordship through. They are asking this on the court to quash that settlement. 10.3 is a part of settlement, R5. The next principle to be borne in mind is that in a case where validity of settlement is assailed, now, my lord, here validity of a part of settlement is assailed, my lord. The limited scope of inquiry would be whether the settlement arrived at in the course in accordance with subsection 1 or 3 of section 12 is on the whole just and fair and reached bona fide. An unjust, unfair or malafide settlement militates against the spirit and basic postulate of agreement reached as a result of conciliation, and therefore such settlement will not be given effect to. In fact, para 19, kindly see, my lord. In Herbertson's versus Workman, this court called for a finding on the point whether settlement was fair and just, and it is in the light of the findings of the tribunal that the appeal was disposed of. Goswami J, speaking for the 3-judge bench, made it clear that settlement cannot be judged on the touchstone of principles which are relevant for adjudication of an industrial dispute. It was observed that tribunal fell into error in invoking the principles that should govern the adjudication of a dispute regarding dearness allowance in judging whether the settlement was just and fair. The rationale of this principle was explained thus. There may be several factors that may influence parties to come to a settlement as a phased endeavor in the course of collective bargaining. Once cordiality is established between the employer and labor in arriving at a settlement which operates well for the period that is in force, there is always a likelihood of further advances in the shape of improved emoluments by voluntary settlement, avoiding friction and unhealthy litigation. This is the quintessence of settlement which courts and tribunals should endeavor to encourage. It is in that spirit the settlement has to be judged and not by yardstick adopted in scrutinizing an award in adjudication. The line of inquiry whether settlement was unfair or unjust in KCP. Then, my lord, para 21 in Herbert, another principle which deserves notice is the one firmly laid down in Herbertson's case. It was emphasized that settlement has to be taken as a package deal. Kindly see this, my lord. And it should not be scanned in bits and pieces to hold some parts good and acceptable and others bad. No, my lord, that too, if your lordship sees, kindly see, my lord, this was questioned by the association, not an individual. Even when an association questions this settlement, saying that it is unjust and fair, this is the law laid down by the Supreme Court. Now, my lord, here, union is not before this honorable court, saying that we have entered into an unfair settlement, which is not working to the benefit of the employees in general. It is not their case. It is only, as I pointed out of 20,000 workmen, about 15 or 20 of them who are before this honorable court saying that interpreting a particular provision, they are not saying the whole settlement is bad. In fact, my lord, they are taking benefit of a part of the settlement. But then the other part which says you will get only this benefit, but you will not carry the other benefit like HRA, DA for getting your allowances, which was made applicable to workmen who continue to be workmen, but barred for those who are promoted, already promoted as officers. Now, my lord, that has to be my responsible submission to lordship is it cannot be looked into and then quashed into bits and pieces. It has to be looked into as a whole. Now, my lord, whether a individual has a right to question this settlement, my lord, kindly have a look at this judgment of the Honorable Supreme Court. They have no right at all. It is only in case of a termination, my lord, which becomes an industrial dispute under section 2 capital A, that they have a right. Otherwise, they don't have a right. In fact, my lord, industrial machinery evolved through the Industrial Disputes Act, my lords are aware. It creates a special forum for adjudicating industrial disputes. Now, my lord, this settlement, interpretation of this settlement, justification of this settlement also is an industrial dispute, because any dispute between employer and employee, between workmen and workmen, between workmen and employer would be an industrial dispute. Therefore, my lord, when the specific machinery is provided there, my lord, it has to be done strictly in accordance with the provisions of the Act. If the Act itself does not give them the benefit of coming directly and questioning a settlement, now, my lord, that should not be entertained under 226 is my responsible submission. Kindly see page para 20, my lord. Para 20. The expression industrial dispute is defined in section 2K to mean any dispute or difference between employers and employers, between employers and workmen, and between workmen and workmen, provided such dispute is connected with the employment, non-employment, terms of employment, or conditions of labor of any person. It is well settled by several decisions of this court that a dispute between employer and an individual workman does not constitute an industrial dispute unless the cause of workmen is exposed by a body of workmen. Of course, where the dispute concerns the body of workers as a whole or to a section thereof, it is an industrial dispute. It is precisely for this reason that section 2A was inserted by amendment in 1965. It says where any employer discharges, dismisses, retrenches, or otherwise terminates the services of an individual workman, any dispute or difference between that workman and his employer connected with or arising out of such discharge, dismissal, retrenchment, or termination shall be deemed to be an industrial dispute, notwithstanding that no other workman or union of workmen is a party. By virtue of this provision, the scope of concept of industrial disputes has been widened, which now embraces not only 2K but also 2A. However, it covers only cases of discharge, dismissal, retrenchment. Therefore, my lord, this is not a case of discharge, dismissal. This is a case of finding out whether a particular provision in the settlement is fair or unfair, it acts prejudicially, and whether that should be struck down, which is what, my lord, the prayer in this writ petition. Therefore, my lord, when they have no right at all to raise a dispute, and even under section 10 before the labor court, my lord, they should not be permitted to raise this and then seek relief of quashing a part of the settlement under 226. Therefore, my lord, this petition has no merit.
Produce certain citations. My lords, in so far as the relief that my learned senior friend is saying, my lords, we are aggrieved not by the settlement as such, but we are aggrieved by the settlement which is made applicable not to the workmen, to the officers. After we go as officers, that settlement gets binding on us, my lords. That is only that portion we have sought as not applicable to the petition. Lords, along with the memo, I have produced a few citations, my lords. 1/2/2021, 1/6/2022, and 29/9/2023. if I request your lots to go to the memo dated 1/2/2021. It was stated, my lots, that
Yes.
my lots, I have produced pay slip at page 3, my lots, of petitioner number 5, who was promoted, my lots, as grade 1 on July 1st, 2007. If your lordships could see the basic 87,250. The next page, my lots, is his junior and also who did not, who continued, my lots, in special scale. It is 1,02,580. And here, my lots, page 3, your lordships may note that he's not in grade 1, he's promoted to grade 3. After 2 promotions also, he gets so much lesser than his junior. My lots, page 5, my lots, in Karnataka KB case, a similar, my lots, discrepancy had arisen. I would not trouble your lordships. I'd request your lordships directly to page 19, my lots, para 24. Para 22 is the question which the Honorable High Court decided. Para 22, my lots.
Yes.
The question herein, whether this kind of benefits conferred on the juniors without extending corresponding benefits on their seniors is arbitrary and violative of protection guaranteed in Article 14. Para 24 it is answered, my lords. It is necessary to remember that departmental examinations under the KLE rules have been prescribed to promote efficiency among the officials. It is therefore expected that all those who have passed such examinations must be treated equally. At any rate, no premium could be paid to a junior who has not been able to pass the examination, either by his lethargic attitude or inefficiency. But the actions of the government and the KB seem to be the other way about. It will be interesting to note from the aforesaid illustration that the junior who could not pass the prescribed examinations in time and who has taken his own time to pass, perhaps after 1 or 2 unsuccessful attempts, has been rewarded with more pay than his immediate senior who had passed such examinations long earlier to his junior. It looks as though the senior, this is all spoken about, my lords.
Yes.
Page 23, there is a judgment of the Guwahati High Court, my lords, which is very similar to the case on hand, where, my lords, workmen in W9 were promoted, my lords. Here also, my lords, page 24, learned counsel for the appellant submit that even though principle of equal, your lordships got para 19, my lords, page 24, down, my lords, last paragraph. Learned counsel for the appellants submits that even though principle of equal pay for equal work may not be applicable, seniors could not be paid less than juniors. And principle of relativity was also a part of right to equality. Employees in W9 cadre working as workmen constituted feeder cadre for supervisors. And in this view of the matter, principle of relativity had to be applied and appellants had to be paid at least 1 rupee higher than the pay of the employees in the lower cadre. They could not be paid lesser than the employees in the feeder cadre. Reliance has been paid so and so, so and so. Last part of page 25, my lords. On due consideration, we find that employees in higher cadre cannot get lesser pay than the employees in the feeder cadre. There is merit in the contention raised that the appellants have to be paid at least 1 rupee higher. This, my lords, was challenged in the Honorable Apex Court, page 28, my lords, is the order.
Yes.
It's dismissed. A review petition is also dismissed, my lords.
Just one thing, my lord. This, what my learned friend brought to your lordship's notice, there, my lord, what was being considered was both categories in the workman category. They were not comparing workmen with the officers category.
My lords, on 1/6/2022, I have produced one more memo, my lords, with page 2, division bench of this honorable court, my lords.
The writ appeal number?
Writ petition number, my lords, 33038 of 2016,
ಯಾವಾಗ ಹಾಕಿದ್ರೆ?
1/6/2022.
2020.
2022. 1st July 2022. Same petition, 4221. There is a seal also, my lords. I'll produce it again. First June 2020.
Yes.
Page 4, my lords, in page 3. Page 3, my lords, this here also the discrepancy, my lords, the aroused because of assured career progression scheme, which was introduced. My lords, para 4, my lords, the solitary question before this court is whether the petitioners who are admittedly senior in the cadre of superintendent of excise are entitled for stepping up of pay or not. This was answered by referring to a number of decisions, my lords. Para 8 is what this honorable court says, the division bench, my lords. Para 8, page 11, in page 11. In light of the aforesaid judgments, the seniors who are admittedly placed above in the accreditation list than their juniors are entitled for stepping up of pay. A person who, by virtue of his excellent service record, is promoted to the next higher post is certainly superior, so far as his service record is concerned, than a person who does not get promotion under the normal course and is granted upgradation under the ACP scheme or under any other schemes of upgradation. This, my lords, was also challenged before the Honorable Apex Court. Page 14, I have the relevant portion, my lords, of the Apex Court is at page 19, para 6. Therefore, it was a case where a junior was drawing more pay on account of upgradation under ACP scheme, and there was an anomaly, and therefore the pay of the senior was required to be stepped up. Hence, in the facts and circumstances of the case, the High Court has rightly directed the appellants herein to step up the pay of the original writ petitioners, keeping in view the pay scale which has been granted to the juniors from the date they have started drawing lesser pay than their juniors. This has become final. I have also produced, my lords, one more memo on 29/9/2023 to show the differences in the pay scales, my lords. Admittedly, even in the basic, there is a difference, my lords. 29/9/2023.
Which case, in which writ?
Same. 42227 we have produced, I'm sorry. 42227. In the beginning, the difference was very less, my lords, but on each revision, the difference exaggerates, my lords. 5th October 2023 is the seal of the Honorable Court. Page 3, my lords, the basic pay. It is a SS employee.
But he does have a point when he says that if your pay is now revised,
Yes, my lord.
you will be getting higher pay than those in officers grade 1, 2 or 3.
They have to revise it. Logically, an employer, my lords, he has to
The
be a
other
model
officers-
employer.
Then the other officers who are directly recruited, they will start saying that people,
My lords, direct recruitment, they cannot have a grievance, my lords. They will be bound by the recruitment notification.
with equal pay for equal work.
Recruitment
us are the same.
notification, my lords. But here, this is a direct consequence of promotion, my lords.
But there's also that disparity that officers who are directly recruited would start getting a lesser pay scale than people who were promoted from the cadre of workmen.
Yes, yes, my lords. They will,
Discrepancy, how would you
yes.
reconcile?
My lords, after 2007, 8 and 9, only these 3 years, people started, asked for promotions, my lords. After that, nobody is asked for promotion because even officers in grade 5, 6 are getting lesser than the special scale of pay. My lords, as a model employer, my lords, they are,
No, but
they
you also
have
have to think about the consequences for the other people. What if they come to the court and say,
they are bound with the notification, my lords, the recruitment notification. They cannot ask for the, here we are a different class in itself. We are promotees.
but
Many of the courts, my lords, they have held,
no, but the bottom line is,
bottom line is yes, my lords. As an employer, my lords, I would always suggest that's why, my lords, this honorable court on the last occasion sent it for reconciliation, saying that this is the bottom line. That's exactly why this honorable court said, you come up with a workable solution. They outright refused, my lords.
reverting you to special scale of pay would be much better.
Much happier. We are very happy, my lords.
That
Actually,
way,
nobody
they don't have
will,
to pay for the other officers.
nobody will be, that's exactly why we made this prayer. So nobody can be.
Solving that subsequent problem.
My lord, that will open up Pandora's box, my lord.
No, it
They,
is-
all those who were promoted 5 years back, 6 years back, if they say, now that the pay scales of workmen in scale, SS scale is higher,
Only
now
those
grant
people,
that, Andre, it will open up Pandora's.
no, only those
It will
people
create
want,
chaos in the industry.
only those people who want a demotion in their life. Why do you want to oppose that
My lord,
demotion?
the petitioner can compare themselves only in the officer's cadre, my lord.
But
They
want-
cannot compare themselves to the workman cadre.
They
That's
want
the
to be in
whole-
the last bench. They're happy in the last bench. They don't want to come in the first bench.
In fact, my lord.
What is your grievance?
Just one more judgment, my lord, in the list that I have given already. On constitution bench judgment, my lord, the status of officers, my lord, whether they have a right.
But they don't want to be officers.
What? No, my lord, they cannot say whenever we want, I can understand if we force them.
Not that whenever, because they are now feeling.
No, my lord, in
they-
future, now, my lord, at the time when they took promotion, we also did not know that we will create a special scale.
Maybe they'll give an undertaking.
No, my lord, therefore, my lord, you can't unsettle
This is the
what
final
has
cho-
been settled and in place for 10 years.
This is their final choice. They'll stay in
Lord,
the urban
Lord,
cadre no
that,
matter what.
my lord,
They
that-
cannot
We have a
that,
union.
that right cannot be given to them, my lord, is my respect.
At least we have a
That
union,
right
my
is to be
lords.
given to them in order to save you
That,
from further
no, my
financial
lord,
problems.
that I can understand, my lord, if all those officers who are promoted and who are getting less, if they were before this court as a class,
Those-
saying that, my lord, it has done injustice, then that's a different aspect.
Those who want to be officers continue to be officers. Those who don't want to be officers, in order to save you from further financial consequences.
No, my lord, it is their volition. They have applied and they have come. Once they come and become officers, they cannot control the pay scale of workmen. How can they control?
They're not, they want the scale.
No, my lord, they cannot then say
They're
that
happy.
what you do to workmen, give it to us also.
No, they,
That, my lord,
they're giving up whatever promotion that they had.
my lord, that cannot
Want to
be.
go back in
My lord,
life.
with great respect, my lord, that can't be
That
permitted.
is not an unknown thing.
My lord, after 5 years or 6 years, they cannot be
There
permitted
are
that.
thousands of examples
No,
where
my lord,
people refuse
no,
to.
after 5 or 6 years, my lord, with great respect, my lord, that should not be permitted. My lord, is my responsibility.
My only submission, my lord.
In fact, my lord,
10th August 2010, after all the 3 batches were promoted,
it
my
from
lords,
you
they
that-
made a
I
retrospective.
take it from you that you're prepared to go back to
We
that.
are, my
government
lords.
case.
I have made a prayer. We are prepared. We will get much higher benefits.
no, my lord, at their whims and fancies, they cannot be considered for promotion and they cannot be put back as saying that now we don't want promotion, therefore send it back. My lord, it's unheard of. I'm sorry. It's unheard of.
We'll have a union at
Just
least,
a-
my lords. Many of
unheard.
the officers were terminated because they came before this honorable court. That is what many officers did not
In
come
fact-
forward, my lords, because
Roshan Lal Tendon, I'm sure your lordship would have seen. Lord, judgment 11, ನನ್ನ ಇದರಲ್ಲಿ ಒಂದೇ ಒಂದು paragraph Lordship may kindly permit me to read. Status of officers and their right to claim revision in wages, reversion, all that has been considered by Supreme Court. Constitution bench.
That's why Vidyulata says
You have no right.
That's why Vidyulata is saying, I don't want all that.
I'll
No,
go
my
for
lord,
Being,
even reversion is not permissible. Even that, my lord, Supreme Court says, no, you can't be permitted to claim whenever you want
if you can.
higher benefit, whenever you want lower benefit.
No, if you can revert them by punishment, they are prepared to accept reversion by a reward by them.
My lord,
Isn't it? You can revert them as a punishment. They are taking it voluntarily.
Lord, citations that I have given, just one paragraph would like to take your lordships through, my lord. Those 11 judgments that I have given. I had referred to it earlier. My lord, the judgment starts at page 90.
Page
90, my lord. Constitution bench judgment in Rochelle Tendon.
Yes.
Lordship got, my lord. Para 6 at page 95, my lord. We pass on to consider the next contention of the petitioner, Lordship. Para 6. The next contention of the petitioner, that there was a contractual right as regards the condition of service applicable to the petitioner at the time he entered grade D, and the condition of service could not be altered to his disadvantage afterwards by notification issued by the Railway Board. It was said that the order of the Railway Board dated so and so laid down that promotion to grade C from D was to be based on seniority cum suitability, and this condition of service was contractual and could not be altered thereafter to the prejudice of the petitioner. In our opinion, there is no warrant for this argument. It is true that the original of government service is contractual. There is an offer and acceptance in every case. But once appointed to his post or office, the government servant acquires a status, and his rights and obligations are no longer determined by consent of both parties, but by statute or statutory rules which may be framed and altered unilaterally by the government. In other words, the legal position of a government servant is more one of status than contract. The hallmark of status is the attachment to a legal relationship of rights and duties imposed by the public law, and not by mere agreement of parties. The emolument of the government servant and his terms of service are governed by statute or statutory rules, which may be unilaterally altered by the government without the consent of the employee. It is true that Article 311 imposes constitutional restrictions upon the power of removal and power of removal granted to the president and the governor under Article 1310. But it is obvious that the relationship between the government and its servant is not like an ordinary contract of service between the master and servant. The legal relationship is something entirely different, something in the nature of status. It is more than such a purely contractual relationship voluntarily entered into between the parties. The duties of status are fixed by the law, and in the enforcement of these duties, society has an interest. In the language of jurisprudence, status is a condition of membership of a group, which powers and duties are exclusively determined by law and not by agreement between the parties concerned. The matter is clearly stated by Salmon and Williams on contracts. Now, my lord, para 7, therefore they reject this. Therefore, my lord, this is one of status. They are also government servants. I am a public sector. Obliged.